ಹಲೋ ಹಲೋ It is this one, Lordship's
Next week.
total number 1.
Or go before same bench antar now.
Not entertaining the content on interim orders.
Submission, my lord.
Ah.
The KAT has taken a view contrary to order of this honorable court. It was held, my lord. Once the transfer order being implemented, court cannot interfere and rejected application solely on that ground.
Sorry, next week.
My lord, in this,
Come on.
the instruction of this court, I have filed an earlier application, my lord. So it was listed in the month of Jan. So due to, I have submitted
So
memo
next week.
in the first week of
My
December.
lords, the petitioner has been prematurely
Pending.
transferred.
Premature.
KAT has yesterday dismissed the petition, my lords. I request.
Interim order itta.
Interim order was there yesterday.
Sorry, next
Tomorrow.
week. Not tomorrow. Tomorrow ಅಂದ್ರೆ ಬಹಳ ಅಪ್ಸೆಟ್ ಆಗಿ ಹೋಗ್ತದೆ, ಬೇರೆ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇರ್ತಾವೆ. Yes. ನೋಡ್ಕೊಂಡು ಹಾಕೊಳ್ರಿ, ಯಾವ ರೀತಿ ಹಾಕ್ಬೇಕು ನೋಡ್ರಿ. ಹಾ.
My lord.
ಹಾ.
ಇದು ಇಂಪ್ಯೂಟ್ ಇದನ್ನ KCT ಆರ್ಡರ್ ಆಗಿದೆ sir.
ಏನು ಆರ್ಡರ್?
ಅದು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಸರ್
ಏನನ್ನು reject ಮಾಡಿ?
ಅಪ್ಲಿಕೆಂಟ್ ಪಿಟಿಷನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
Application for grant of lottery. What was the
ರೆಸ್ಪಾಂಡ್
application?
ಕಾಂಟ್ರರಿ ಟು ದಿ ರೂಲ್ಸ್.
Week after next ಹಾಕಿ. Yes. Vijay Krishna.
Yes, sorry to make a mention, my lord.
Head.
Serial number 7 ಅಲ್ಲಿ, it is reported that fifth respondent, contesting respondent, died on 28/9/24.
9 ದಲ್ಲ?
7 ಅಲ್ಲಿ.
ಹಾ.
So I will take steps, my lord, in 2 weeks.
Yes. 2 weeks for taking steps.
Yes.
My lord,
7, R5,
Finally.
Gudos Day Kotechand.
Comma, respondent number 5 is reported to have been dead. Respondent number 5 having been reported dead. Okay.
My lords, may I make one submission?
ಅದು ಬರ್ಬೇಕು, ಅವ್ರು ಬರ್ದಂಗೆ ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದು. Okay.
My lords, serial number 23, my lords, appear on behalf of the respondents.
23.
Yes, my lords, appear on behalf of the respondents, seeks for a week accommodation, my lords.
ಏನದು 23? CAT 2018 matter.
Yes, my lord. Next week, candidate, my lords, with onchur person inconvenience.
No, week after next at the request of.
Lord, serial number 21, my lord. I am for the respondent, my lord.
ಅಲ್ಲಿ ನೋಡಿ, ಯಾರಾದ್ರೂ ಈ ಅಜರ್ಮೆಂಟ್ ಆದಾಗ ಅಪೋನೆಂಟಿಗೆ ನೀವು ತಿಳಿಸ್ತಿಲ್ಲ, ಅವ್ರು ಇಲ್ಲಿ ಬಂದು ಆರ್ಗ್ಯೂ ಮಾಡಕ್ ಬಂದ್ರು ಅಂದ್ರೆ ನಾವು ತಗೊಂಡ್ಬಿಡ್ತೇವೆ. ಗೊತ್ತಾಯ್ತಾ? ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು.
Serial number 21, my lord. I am for the respondent, my lord.
ಕೂತ್ಕೊಂಡು ಪಾಪ.
I am for the respondent, B. Vidyalata, my lord. I informed the petitioner counsel, my lord. Senior is suffering from my wife.
ಅಪಲೆಂಟ್.
I am for the respondent, my lord. I informed the appellant counsel, my lord. Senior is suffering from viral fever, my lord. Kindly, I will.
Is it?
Please, my lord.
But don't generate that ground here. We'll otherwise also will give you.
On Monday or Tuesday, my
ಬಹಳ
lord.
ಜನರನ್ನ you will drive them to illness. That need not be.
My lord,
all right.
kindly
In
request
the
for on Monday or
First week
Tuesday.
of first week of February. Yeah. Okay.
My lord, serial number
Hundred.
18, my lord. As informed by the-
1/8.
Please, my lord, I seek for a week's accommodation in this matter, my lord.
ಏನದು 1/8? 2013 matter.
Please, my lord.
Having paid cost, have you paid cost?
I have to pay cost. Today I'll pay the cost.
You have not paid cost? ಏನದು? You are for?
I'm for the respondent. ma'am.
Cost, you have to pay double cost now. The coordinate bench, wide order dated 10/3/2023 had directed. ಯಾರನ್ನ ಡೈರೆಕ್ಟ್ ಮಾಡಿತ್ತು?
The respondent.
ಯಾವ ರೆಸ್ಪಾಂಡೆಂಟ್? ವಿಚ್ ರೆಸ್ಪಾಂಡೆಂಟ್? ಅದು ನೋಡ್ಕೊಂಡು ಬರಲ್ಲ, ಅವ್ರು ಜಡ್ಜ್ ನೋಡ್ಕೊಂಡು ಮಾಡ್ಲಿ ಅಂತ ಅಲ್ಲ. ಕೊಡಿ. Had directed the respondent to pay a cost rupees 1,000 to Karnataka Advocates Clerks Benevolent Trust. First up. Nearly more than 1.5 years having lapsed, comma, the order remains uncomplied and there is no explanation as to why it is not complied with, comma, either. First, in view of the above, the respondent is directed to pay rupees 2,500 instead of rupees 1,000 as ordered in terms of the said order within 2 days, failing which heavy adverse inference would be drawn in the main matter itself. Yes,
Kind leave, my lord. Cell number 19, my lord.
19.
Please,
Ah.
respondent, my lord. For a week's accommodation in this case.
2013 matter,
Please.
ಇವಾಗೆಲ್ಲ ನಾವು ಟೈಮ್ ಕೊಟ್ಟು
Next
ಏನು
week.
ಎಲ್ಲರೂ ಹಿಂಗೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದೀರಿ.
What happens my lord, after it was
What
heard?
happens to your client?
Please,
11 years ಆಗಿದೆ.
I apologize for that. Next week, my lord, without fail. I inform the Argopals, you know.
Good. Call the week after next
Serial number 17, my lord.
at the request of learned counsel appearing for the
Respondent,
respondent.
all the rest.
ಅವ್ರಿಗೆ ತಿಳಿಸ್ಬೇಕು.
I will inform.
ಇಲ್ಲ ಅವ್ರು ಬಂದು ಇಲ್ಲಿ ಕೂತ್ಕೊಳ್ತಾರೆ ಆಮೇಲೆ.
ಇಲ್ಲ, I will inform Argopals.
Okay.
Publish.
Serial number 17, my lord. Seeking for 1 week accommodation, my lord. As senior is not available, his father-in-law has expired yesterday, my lord. So 1 week accommodation, my lord.
All right. Call
Respondent number 1 to 5, my lord.
week after next at the request of counsel appearing for the respondents 1 to 5 on the ground of bereavement in counsel's family. Okay.
Can be granted to file paper book.
Paper publication ಮಾಡ್ಕೊಂಡಾಗಿದೆಯಾ? Paper books fail ಆಗಿದಾ?
ಫೈಲ್ ಆಗಿಲ್ಲ ಸರ್, ಫೈಲ್ ಆಗಿಲ್ಲ.
2013 matter.
ಅದು the counsel shown on record is no longer on the panel. In the open court, I was directed to take notice. I've taken notice, I'm gathering the papers. I'll file it in 2 weeks' time.
Finally, peremptorily 4 weeks was granted.
The papers were not with me. I've applied for the papers and I'm
The
gathering.
coordinate bench wide order dated, a coordinate bench wide order dated 3/9/2022 had said as under. First off, learned counsel for the appellant submits that there was some difficulty in procuring the papers and therefore book could not be prepared. And therefore, some time be granted. First off. 2 weeks granted, next paragraph, in the above circumstances, 2 weeks granted, subject to appellants, ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
BDA, my lords.
BDA,
BDA.
appellant presenting, ಯಾವ book ಕೊಡ್ತೀರಿ, ಎಷ್ಟು ಕೊಡ್ತೀರಿ?
I leave it to my lords.
ಶೂನ್ಯ ಸಂಪಾದನೆ ಕೊಡಿ.
ಆಯ್ತು.
By ರಾಜಶೇಖರ ಭೂಸ್ನೂರ್ಮಠ್. Professor Rajshekar Bhusnurmad, 2 sets, a set of 2 books to Advocates Association Library within 2 weeks. Okay.
Publish, my lords.
Appears for the appellant, please, my lord. That in this case, the LR of the respondent was already served with the notice on 29/7/2024, my lord, as per the postal records. However, my lord, the acknowledgement has not been notified after having served, my lord. And thereafter, she sells this one of the suitable properties on 17/9/2024.
17/9/24.
Yes,
But you have not amended the cast title appeal memo also.
I will file right now, my lord. I will file. It's ready, my lord.
Paper books ಹಾಕಿಲ್ಲ.
Paper books, my lord, in 3 days. It is also ready, my lord. I will file it in 3 days.
ಒಂದೆರಡು ಬುಕ್ಸ್ ಕೊಡಿ ಲೈಬ್ರರಿಗೆ.
ಆಯ್ತು.
ಅದು ಏನ್ ಮಾಡ್ಬೇಕೀಗ? ಸರ್ವಿಸ್ ಅಂಡ್ ಸಫಿಷಿಯಂಟ್ ಮಾಡಕ await ಅಂತ ಇದೆ ನಮ್ಮಲ್ಲಿ.
Await ಅಂತ ಇದೆ. ಅದು we verified with the postal, my lord, records.
Track record.
Yes, but I have not produced any records. But after verification, it was found that on 29/7/2024, my lord, she was served with the notice.
Counsel for the appellant submits that his verification of postal track sheet,
Please.
shows that appellant,
A respondent, LR of the
Yeah,
respondent,
respondent.
Sujata, my lord.
respondent
Sujata.
1A,
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 wife of the deceased there.
the widow of the deceased
Yes, my lord.
respondent
Please.
has been duly served with the court notice on
29/7/2024.
29/7/2024.
And she sells, my lord.
And
one of the-
therefore, service be held sufficient.
Much
First,
And
I
may
agree with this.
make one submission, my lord.
Ah.
after the service was duly served.
ಹೇಳಿದ್ರಲ್ಲ ಇದು ಆಗಿದೆ ಏನೋ
She sells one of the.
ನೀವು ಪೇಪರ್ ಬುಕ್ ಹಾಕಿ
ಹಾಕ್ತೀನಿ sir.
ಅದೆಲ್ಲ ಹಾಕಿದ್ಮೇಲೆ
Acting, sir, because my IA is there. Second set I will file it.
ಸರ್ವಿಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರ ಸಾಕು ಒಂದೇ ಸರಿ ಸರ್ವಿಸ್ ಆದ್ರೂ ಮುಗಿದು ಅವ್ರು ಬರ್ಲಿ ಅಂತ ನಾವೇನ್ ಮಾಡೋಣ ಫಸ್ಟ್ ಅಲ್ಲೇ ನೋಡಮ್ಮ in saying this we have noted the coordinate bench order dated 25/9/2024 also full stop. Next 2 weeks time granted
3
for
days.
filing of ಅಲ್ಲಿ ಇಷ್ಟು ಹಾಕಿಲ್ಲ ಈಗ ಹೇಳೋದು
Ready.
1 week time granted for filing of paper books subject to the condition ಯಾವ ಪುಸ್ತಕ ಕೊಡ್ತೀರಿ that the appellant shall present
Whatever the books ಮೇಲೆ
ಯಾವುದು?
ತಾವ್ ಯಾವ್ದು ಹೇಳ್ತೀರ ಅದ್ ನಾನು
ಭೈರಪ್ಪನವರ ಸತ್ಯ ಮತ್ತು
ಭೈರಪ್ಪ.
ಸೌಂದರ್ಯ ಕೊಡಿ
ಭೈರಪ್ಪ.
2 books, a set of 2 books. ಸತ್ಯ ಮತ್ತು ಸೌಂದರ್ಯ ಟ್ರುತ್ ಅಂಡ್ ಬ್ಯೂಟಿ ಇದೆ ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಇದೆ ಅದು.
Yes, I will give it. Satya and so on.
ಸತ್ಯ ಮತ್ತು ಸೌಂದರ್ಯ ಆಫ್ ಡಾಕ್ಟರ್ S.L. ಭೈರಪ್ಪ ಟು ಅಡ್ವೊಕೇಟ್ಸ್ ಅಸೋಸಿಯೇಷನ್ ಲೈಬ್ರರಿ.
Much obliged. ಇವಾಗಲೇ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. Second set I am filing.
Compliance to be done, other compliance to be done in the meanwhile. Okay. Next. ಬಂದಿಲ್ಲ ಅದು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಅವೇಟ್ ಸರ್ವಿಸ್ ಇದೆ ಅವೇಟ್ ಸರ್ವಿಸ್ ಕಾಲ್ ಒಂದು ಯಾವ್ದಾರ ಡೇಟ್ ಕೊಡಿ ಮುಂದಿನ ಜನವರಿಯಲ್ಲಿ. January ಹಾಕಿ 13 January ಹಾಕಿ. First, absence of party in person, appellant party in person noted. Okay. Next.
Appear for the petition.
Ah.
Submission with respect to translation.
Dispensed with. ಏನಿದೆ matter?
Matter relates to selection of minutes to the post of lecturer management sub. Of the year, notification of the year, minutes 2014 wide annexure A11 and A12 minutes.
2014,
2015,
15.
2015, 22/1, 2015 and 5/3/2015, A11 and A12 minutes. Plus total five rural
Staff assistant professor in management.
subject minutes.
Ah.
Subsequent minutes notification, minutes 1 in wide annexure A14 minutes, 2 people minutes, namely Sanket Pujari and 1 Tejaswini had selected.
No additional list was prepared.
No additional list was prepared minutes. In the meanwhile minutes, there was an order of tribunal. 1 Sanket Pujari, Tejaswini TI did not report. 1 Sanket Pujari was allowed to participate in the selection due to interim order of the tribunal, which subsequent to came to be dismissed or disposed with direction to revise the list. And he was found to be not eligible. But they, instead of revising the list, they called me for document verification. And subsequently, they carry forward the list. They don't revise the additional list.
That appears to be wrong is your submission.
Indeed, minutes. Wide annexure A18 minutes. Minutes may kindly take page 183. They show my name.
DG. Service admission ಬಂದಿದೆ
Admission ಬಂದಿದೆ.
Learned DG is requested to accept notice for. There are respondent.
Minutes 1, 3 is key. 4 is private respondent.
Learned panel counsel N.K. Ramesh is requested to accept notice for respondent number 3. Emergent notice to
4
or 4.
deeply obliged.
Okay.
My lords, I appear on behalf of the petitioners. My lords, the office note is, my lords, insofar.
One more date ಅಂದ್ರೆ ಏನದು ಅದರಲ್ಲಿ?
My lords, I'll just explain, my lords. My lords, I have impugned the order dated 18/9. Please, my lord. 18/6/2024, my lords, wherein on the at the stage of complainant's arguments, the complainant had argued and I had missed the matter by about 5-10 minutes, my lords, and after which the complaint was allowed in part on the very same date. On the same day, my lords, I filed a recall application seeking to place my arguments on record, my lords. The matter was posted on the subsequent date, wherein my lords is pleased to see page 53, wherein I had filed an application for the records to be put up.
accepting a plausible explanation offered by the counsel for the petitioner of his objection is overruled.
My lords,
Ah.
there's some urgency in this matter. May I make a submission, my lords?
Yes.
My lords, this is a complaint filed by the complainant before this. My lords, this complaint came to be filed before the state.
ಬೈಕ್ ನಲ್ಲಿ ಯಾರ್ಯಾರು ಮಾತಾಡ್ತೀರಿ ಅವ್ರಿಗೆ 10 marks 10 ಗ್ರೇಸ್ ಮಾರ್ಕ್ಸ್
Please, my lords.
ಹಂಗಂದ್ರೆ ಏನು ಅಂತ ಕೇಳ್ಬೇಕು.
My lords, the complaint was filed before the State Consumer Forum and I was a respondent therein. The complaint is as against the company, and in the impugned order, my lords, there are two aspects. One is that the directors have been made jointly and severally liable. My lords, the first aspect is that I was not given an opportunity to present my case. On 18/6/2024.
All right, you deposit 50% of the amount here. You are a company.
My lords, one aspect is that the parent company is under liquidation. Therefore, under the IBC, the
ಆಯ್ತು, ನೀವು
consolidation of claims would be before the IRP. Second is, my lords,
IDB is not in liquidation.
IDEB, no, my lords.
ಬಿಡಿ madam, ನೀವು ತುಂಬಿ.
Buildcon is under,
And
and
28 lakh 25,000 plus 12% interest, 50,000 litigation expenses ಎಷ್ಟಾಗ್ತದೆ? 28,25,000 ಯಾವಾಗ್ನಿಂದ ಅದು? 2016 ನಿಂದನ?
2000. Please,
16 ಅಲ್ಲ 2016 page 23.
please, my lords.
1 to 2020 159 of 2016 ಇದೆ.
Please, my lords. The calculation,
ಈ ಎಲ್ಲ ಅಮೌಂಟ್ ಹಾಕ್ಬಿಡಿ, ಅದು ಇನ್ನೂ ಡಬಲ್ ಆಗ್ತದೆ.
my lords, may I seek for a lesser sum to be deposited, my lords.
ಅವಾಗ ನಾವು ಕೊಡ್ತೇವಲ್ಲ ವಾಪಸ್, ನಾವೇನು ಜಡ್ಜಸ್ ತಗೊಂಡು ಹೋಗಲ್ಲ, ಏನಿಲ್ಲ, ಇಲ್ಲೇ ಇರ್ತದೆ. ಇಫ್ ಯು ಸಕ್ಸೀಡ್ ಇಟ್ ವಿಲ್ ಬಿ ಗಿವನ್ ಬ್ಯಾಕ್ ಟು ಯು. ಬರ್ಕೊಳ್ಳಿ.
My lords, 25%, my lords.
Huh?
If the sum may be reduced to 25%.
ಏನು, on what ground I should reduce?
My
we
lords,
should
there are two
reduce it.
aspects, my lords.
Huh?
One is insofar as principles of natural justice, my lords. The second aspect
You are a
is,
company.
no, my lords, in the impugned order,
Huh.
what has been stated is that the directors are jointly and
No,
severally liable.
directors of the company.
Are jointly and severally liable, my lords.
ಹಂಗಾಗಿ ಅಷ್ಟು ತುಂಬಿಡಿ ನೋಡೋಣ ಅಂತ.
My lords, another aspect is that insofar as the directors are concerned, there was section 95 proceedings that are pending. And therefore, there's a moratorium against those directors, my lords, insofar.
Moratorium applies to the company but not to the directors ಅನ್ಕೊಂಡು ಧ್ಯಾನ್ argued one matter, quoting
lords,
Nariman's judgment, Justice Nariman's judgment.
My lords, this is in so,
Personal insolvency resolution is initiated, then there's a separate moratorium. But if it is only against the company, then directors don't have it. But I think 95 is a personal insolvency resolution.
Allah.
Possibly that is there.
Anyway, what is your difficulty? You deposit this money. Thank you, Dan. Thank you so much. You deposit this money. We'll give you interim order. But
my lords, the lesser sum is,
issue emergent notice.
my lords, notice has been served, my lords.
ಸರ್ವಾಗಿದೆ.
Yes.
ಆಲ್ ರೈಟ್. ಮತ್ತೊಂದ್ಸರಿ ಹೋಗ್ಲಿ, ಈಗ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಆಗಿದೆ ಅಂದಾಗನೇ ಬರ್ತಾರ ಅವ್ರು. Emergent notice again. Interim order. Staying the impugned order. Subject to petitioner depositing a sum of rupees 26 lakh in the registry of this court forthwith. The amount shall not be released to anybody without the order of court.
My lords, in a time limit of 4 weeks, my lords.
ಈ ಕಂಪನಿಗೆ 4 weeks.
Please,
ಏನೋ ಯಾರೋ ಕಲ್ಲೇಗೌಡ ಮಲ್ಲೇಗೌಡ
My lords, 4 weeks.
within 2 weeks. ಅಲ್ಲಿ ನೋಡಮ್ಮ, as under, subject to petitioner depositing 26 lakh as under in the registry as under. 13 lakh within 1 week and the remainder in the next 1 week following. Next 1 week following. Okay. Failing which interim order stands rescinded on its own. ಆಗಿದೆ. ಇನ್ನೊಂದು ಸರಿ ಹೋಗ್ಲಿ. The registry to send this order to the respondent by speed post. Okay. He will come there.
Obliged.
Okay.
My lords, contempt proceedings against the directors of the company, my lords.
Huh.
Initially, my lords, the contempt, page 28 of the order, my lords. The contempt, the NCLT, my lords, directed me to pay 75,000 for 6 months, my lords, which I have paid What has not been paid, my lords, is a valuation certificate advertisement cost, which, my lords, the resolution profession is quantifying at 7 lakhs. Out of 11 lakhs, my lords, I've paid already 5 lakhs, my lords, which the court says 75,000.
ದುಡ್ಡು ತುಂಬರಕ್ಕೆ ಅಂತ
I've,
ಹೇಳಿದ್ವಲ್ಲ,
I've carried, I've carried a DD of 2 lakhs, my lords.
3 ಅಂತ
My
ಹೇಳಿದ್ವಿ.
lords, I did, my lords, I
We
did.
told you yesterday, bring 3 lakhs
Because
ಅಂತ ನಾವು ಹೇಳ್ಬಿಟ್ಟಿದ್ವಿ.
Yes, my lords.
ತೊಗೊಂಬಂದ್ರೆ ಕೊಡ್ತೀವಿ, ಇಲ್ಲಪ್ಪ ಅಂತ
I'll
ಇದ್ರ
pay
ಮೇಲೆ
1 lakh within a span of 1 week, my lords. I've carried 2 lakhs DD right now, my lords.
ಯಾರ ಹೆಸರು ತೊಗೊಂಬಂದಿರ ಅಮೌಂಟ್?
The resolution professional, my lords, the respondent number 1.
ಅದು ನಾವು ನಮ್ಮ ಹೆಸರಿಗೆ ತೊಗೊಂಬರ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ವಿ.
No, my lords, rather paid.
Okay. Issue emergent notice, the interim order as prayed for, subject to petitioner. ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು ಅಮೌಂಟ್?
The resolution professional, our respondent number 1, my lords.
Petitioner paying a sum of rupees 3 lakh to the respondent number
1. The only respondent, my
to
lords.
the first respondent. First respondent is resolution
Professional, yes, my lords.
professional. The first respondent resolution. Obre,
Yes, my lords, only 1, my lords.
to the respondent resolution professional. Professional, as under, full stop. 2 lakh today,
2 lakh today, my lords.
2 lakh, a sum of rupees 2 lakh within 3 days,
3 days.
and another sum of rupees 1 lakh within 1 week,
1 week, my lords.
1 week.
I'm grateful. my lords.
Failing which the interim order stands rescinded and the petition runs risk of dismissal as well.
I'm grateful. my lords.
Next.
I'd filed, it's a covered by issue, my lord, regulation of sweepers.
Because immediately after regularization of the employee lordship, he died, and they are claiming pension.
That-
Because minimum of 10 years of service, they have to put in your lordship,
10 years of which service?
qualified service.
Post regularization.
Post-regularization.
But there is one judgment where Mr. V. Lakshmi Narayana argued and Justice Gopal Gowda bench said,
There are
the contrary no idea. Conflicting idea, Lakshmi Narayana. If suppose if the employee dies in one matter where you have ILR 1990, 97. 2000. 2000. Where they have awarded, they said you should count.
ಮಾಡಿದ್ದಾರೆ, ಕೆಲವೊಂದು ಮಾಡಿ.
25 years he has put in of service of 20.
He dies.
Correct. 25 ವರ್ಷ ಕಾಯ್ದಾನ ಅವನು. But death does not wait for anybody. Government should always believe that the men are mortal, women are also. But you think that they are eternal ಅಂತ ಅನ್ಕೊಳೋದಕ್ಕೆ ಎಷ್ಟು ಸಮಸ್ಯೆ ಆಗ್ತದೆ. 25 ವರ್ಷ ಆಗಿ ಡೆತ್ ಆಗಿದೆ. ಬಿಡಪ್ಪ ಏನೋ ಇಮಿಡಿಯೇಟ್ಲಿ 2 ವರ್ಷ 4 ವರ್ಷದಲ್ಲ ಅಥವಾ 10 ವರ್ಷ 6890 ಆರ್ಡರ್ ನಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ ಆರ್ಡರ್ 10 ವರ್ಷ ಆದ್ಮೇಲೆ ಆಗಿದೆ. ಹಂಗಾಗಿ ಏನು ಮಾಡಕ 25 years he has put it. There is one provision in KCSR which says Professor Nagarajan, which says the previous service should be counted. Which is that provision? 248A. 248A. All right. Call next week at the request of so and so. ಏನಿಲ್ಲ okay. Judgment on the ಕೊಡಿ that judgment please give that ತೊಂಬನ್ನಿ ಅದ್ಮೇಲೆ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟು ಇದೆ.
That matter went to the.
No, not that matter. Another matter which R.K. Garg had argued. I remember that was from Ghaziabad. Just find out and
Please.
Just find out that. ಅಂತ ಇದೆ. ಮಿನಿಮಮ್ ಸರ್ವಿಸ್ ಯಾವುದು ಅಂತ ಅದ್ ನೋಡ್ಕೊಂಬೋದು. ಎಸ್, ಅದು ಪೋಸ್ಟ್ ರೆಗ್ಯುಲರೇಷನ್ ಇದು ಕಾನ್ಫ್ಲಿಕ್ಟಿಂಗ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಇದೆ ಎಲ್ಲ ನಮ್ಗೆ.
There was a direction to promote within 10 days. Orders tomorrow.
You are issuing tomorrow.
Tomorrow.
We'll record that.
Please.
Learned AGA submits.
May call it on Monday minutes.
Learned AGA submits that. In terms of I'll ಬರಿಬೇಕು. Wide order dated 4/11/2024, we had said as under. First stop, next paragraph. The senior advocate appearing for the petitioner complains that this order has not been complied with and that there is no justification whatsoever for non-compliance. First off, learned AGA submits the order shall be complied within 2 days, within 3 days. First off, this submission he makes on the instruction of Yaravu, Under Secretary, so and so, who is personally present before the court. Non-compliance will be viewed very seriously, and any stringent order, including one for imprisonment, may be made. Arrest may be made. Okay.
May be called on Monday minutes.
I'll call this matter on Monday.
Monday. or
Compliance, but call this matter.
There was some mistake in
Ah,
the date.
Monday.
I just want.
Monday. Okay. Or suppose if it is not complied, we'll direct arrest and detention of your secretary. Yes, that's the only way, Mr. Holla. Otherwise, we will not be able to. ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ, ಅದ್ರ ಮೇಲೆ ಒಂದು ಅಪೀಲು, ಆಮೇಲೆ ಅದು ಅಪೀಲ್ ಆಗಕ್ಕೆ 5 ವರ್ಷ ಆಗ್ತದೆ, ಆಮೇಲೆ ಕಂಪ್ಲೈನ್ಸ್, ಕಂಟೆಂಪ್ಟ್ ಮೇಂಟೈನೇಬಲ್, ನಾಟ್ ಮೇಂಟೈನೇಬಲ್, ಅದ್ರ ಮೇಲೆ ಒಂದು 6 ತಿಂಗಳ ಆರ್ಗ್ಯುಮೆಂಟು, ಇದರಲ್ಲೇ ಹೋಗ್ಬಿಡ್ತಾನೆ ಸಿಟಿಸನ್. ಹಂಗಾಗಿ ಏನಿಲ್ಲ, ಗೌರ್ಮೆಂಟ್ಗೆ ನಮ್ನಿಂದ ಇದೆ ದಿಸ್ ಲ್ಯಾಂಗ್ವೇಜ್ ದೇ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್, ನೋ ಅದರ್ ಲ್ಯಾಂಗ್ವೇಜ್. ಎಸ್ ಎಸ್
ಇದರಲ್ಲಿ ಮ್ಯಾಟರ್ ಇಸ್ ಕಮಿಂಗ್ ಅಪ್ ಬಿಫೋರ್ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆನ್ ಫ್ರೈಡೆ. ಸೊ ನೀವು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವಾಗಲಾದ್ರೂ ಒಂದು
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಲ್ಲಿ ಮಂಡೇ ಹಾಕೊಂಡಂತೆ
ಎಂಟ್ರಿ ಮಾಡರ್ 30th of October.
ಎಂಟ್ರಿ ಮಾಡಿದೆ
ಅಲ್ಲ, that is questioned by
therefore
yes,
ಅದು ಸಬ್ಜೆಕ್ಟ್ ಟು
dispose ಆಗಿಲ್ಲ. I
There is a
thought it is
direction in
disposed.
one matter, my lord. In one matter, it had come up on 22nd. There's a direction for the CIRP to continue. Continue.
The other two matters, they are
That is coming up on Friday.
Friday. ನಾಳೆ ನಾಡ್ದು. We'll have this matter next week.
Yes.
ಯಾವ್ದಕ್ಕೆ ನೋಡೋಣ. ಈಗ suppose if apex court does something, then notice may not be necessary at all. All right, call this matter next week, please, at the request of learned senior advocate Mr. Holla, and then appearing for the respective respondent so and so, on the ground that the connected, the offshoot matter is being examined by the apex court, and it is slated to be posted on Friday instead. Okay. 10.1 ನಲ್ಲಿ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೇಕಾಗ್ತದೆ ಅಲ್ಲಿ ತನಕ. 10.1 ನಲ್ಲಿದೆ ಎಂಟ್ರಿ ಮಾಡರ್ ಟು ಕಂಟಿನ್ಯೂ ಟಿಲ್ ದೆನ್. ಓಕೆ. Yes.
The thing, my lord, is since there's a direction for the CIRP to continue,
ಹಂಗಾಗಿ ಎಂಟ್ರಿ
that is against the company itself. It may be
ಇದೆಯಾ ಆರ್ಡರ್ ಕಾಪಿ?
ಇಲ್ಲ, ರಿಲೀಸ್ ಆಗಿಲ್ಲ, ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ,
ಮೊನ್ನೆ ಬಂತು.
Some protection has to be made.
ಹೆಂಗೆ
ಅಲ್ಲ, ಅವ್ರಿಗೆ
ಕಂಟಿನ್ಯೂ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿದಾಗ
ಅಲ್ಲ, ಗೊತ್ತಿಲ್ಲ ಅದು ಏನ್ ಆರ್ಡರ್ ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ.
ಅವ್ರು ಕೇವಿಯಟ್ ಇದ್ರು.
ಅದೇ ಏನ್ ಆರ್ಡರ್ ಅಂತ ಗೊತ್ತಿದ್ರೆ ಅಲ್ಲ, ಆಫ್ ಕೋರ್ಸ್ ಸಬ್ಜೆಕ್ಟ್ ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಸೊ ದಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ವಿಲ್ ಬಿ
ಕಂಟಿನ್ಯೂ ಆಗಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ ಅಂತ.
what I've been told, I was not there.
We will record your submission. Please. ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರ ಮೇಲೆ ಏನು ಹೇಳೋದು ಬೇಡ, ಹಂಗೆ
ಎಸ್
ಇಷ್ಟೇ ಇಡೋಣ, ಸೊ ದಟ್ ಮತ್ತೆ ಬೇರೆ ಸಮಸ್ಯೆ ಆಗೋದು ಬೇಡ.
ಎಸ್ ಎಸ್
ಓಕೆ. ಏನ್ ಬೇಡ, ಹಂಗೆ ಇರಲಿ. ಎಸ್.
Lordship, this case of censure, your lordship.
Censure.
SI, sub-inspector.
Censure expires same day.
Same.
Huh.
That is set aside, your lordship. He has challenged it after 2 years. Without considering that aspect, the KAT has set aside that order.
ಈಗ 2 ವರ್ಷ ಆಗಿದೆ, ಅವ ಈಗ ಅದನ್ನ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡ್ಲಿದ್ರು, ಇಟ್ ಡೈಸ್, ಇಟ್ ಕಮಿಟ್ಸ್ ಲೀಗಲ್ ಸುಯಿಸೈಡ್ ಸೇಮ್ ಡೇ.
ಅಲ್ಲ, ಅದನ್ನ ಸೆನ್ಷರ್ ಆಗಿದ್ದು ಹೋಗ್ಬಿಡುತ್ತಲ್ಲ ಸುಮ್ಮನೆ, ಯಾಕಂದ್ರೆ ಈಸ್ ಎ ಪೊಲೀಸ್ ಆಫೀಸರ್. ವೈ ಲಾರ್ಡ್ಶಿಪ್ ಮೈ ಕೈಂಡ್ಲಿ ಅಪ್ರಿಶಿಯೇಟ್ ಆನ್ ದ ಗ್ರೌಂಡ್ ಆಫ್ಟರ್ 2 years he has challenged it before the disciplinary authority, appellate authority.
ಅಲ್ಲ, we'll assume
Please, Lord.
it is not set aside. What is the legal effect? Because censure order, ಯಾವುದು ನಾವು ಪ್ರೊಫೆಸರ್ ನಾಗರಾಜನ್ ಯಾವ್ದು ಇದು
Minor.
that dies on the same day ಅಂತ ಓದ್ದೆ ನಾನು, ಸೇಮ್ ಡೇ.
ಅದು admonish. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಬರೋದಿಲ್ಲ ಅಂತ.
ಅಲ್ಲ ಅದೇ ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ವೈ ಅನ್ನೆಸರಿ ದಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಸೆಟ್ ಅಸೆ. ಅಲ್ಲ ನಾವ್ ಯಾಕೆಂದ್ರೆ ಅದು ಸೆನ್ಷೂರ್ ಇರೋದನ್ನ ಅವರೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ ಆಫ್ಟರ್ 2 years. And the court has gone into the merits of the case. Your Lordship may can see the administrative tribunal has gone into the merit of the case
Correct.
and set aside that censure order.
1 second. Either a consequence, because in that famous judgment, court said, challenging to the appointment of Justice A.N. Ray as Chief Justice of India. In that Supreme Court said, futile writs shall not be issued. We'll assume that this is wrong order. Wrong is no ground for challenge unless it is coupled with consequences. What are the consequences? Tell it.
ಅಲ್ಲ ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಸೆನ್ಷೂರ್ ಆರ್ಡರ್ ಅಂತ ಇದೆ. ಅದು ಸೆಟ್ ಅಸೈಡ್ ಆಗ್ಬಿಟ್ರೆ ಅದು ಮಾಡಿಲ್ಲ ಅಂತಾನೆ ಆಗ್ಬಿಡುತ್ತೆ ಅಂತ.
ಹೌದು, ಅದಿದೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. ಅದು ಅವತ್ತೇ ಸತ್ತಿರ್ತದೆ. ಇಟ್ ಡೈಸ್ ಆನ್ ದ ಸೇಮ್ ಡೇ. ಅದು ಬೇರೆ ಒಂದು ಅಪ್ರಾಪ್ರಿಯೇಟ್ ಕೇಸ್ ನಲ್ಲಿ ನೋಡೋಣ ಅಂತ ಇದ್ರಾಗ ಏನಿಲ್ಲ.
With your Lordship kind permission, my lord, may make one statement regarding that, my lord.
ಹಾ,
My lord, what has happened is if an inquiry is pending and ultimately because of the inquiry some promotion has
ಯಾವ್ದೋ
been
ಪ್ರಮೋಷನ್ ಎಲ್ಲ ವಿಥೋಲ್ಡ್ ಆಗಿದ್ರೆ ಮಾಡಿದ್ರೆ ಸೀಲ್ಡ್ ಕವರ್.
ಅವಾಗ ಏನಾಗುತ್ತೆ, ಸೆನ್ಶ್ಯೂರ್ ಇಂಪೋಸ್ ಆದ್ರೆ ಸೀಲ್ಡ್ ಕವರ್ ವಿಲ್ ನಾಟ್ ಬಿ ಓಪನ್ಡ್. ಇಟ್ ಇಸ್ ಆಸ್ ಗುಡ್ ಆಸ್ ಎನಿ ಅದರ್ ಪನಿಷ್ಮೆಂಟ್. ದೇರ್ಫೋರ್ ಇಟ್ ರಿಕ್ವೈರ್ಸ್ ದಟ್ ಇಟ್ ಶುಡ್ ಬಿ ಕ್ವಾಶ್ಡ್. ಬಟ್ ಸೊ ನೋ ಆರ್ಡರ್ ಆಫ್ ಪನಿಷ್ಮೆಂಟ್ ಇಫ್ ಇಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬೀನ್ ಪಾಸ್ಡ್ ಆಸ್ ಆನ್ ದಿ ಡೇಟ್ ಆಫ್ censure, as your Lordship rightly said, it becomes redundant because the very day it dies. But if is something already
ರಿಡಂಡೆಂಟ್ ಅಲ್ಲ, ಇಟ್ ಡೈಸ್ ಅಂತ ಇದೆ. ರಿಡಂಡೆಂಟ್ ಅಲ್ಲ, ರಿಡಂಡೆಂಟ್ ಇಟ್ ರಿಮೇನ್ಸ್ ಬಟ್ ಇಟ್ ಇಸ್ ಇನ್ಎಫೆಕ್ಟಿವ್ ಅಂತ. ಬಟ್ ಇಟ್ ಡೈಸ್ ಅಂತ ಇದೆ. ಜಜ್ಮೆಂಟ್ ಹಂಗೆ ಹೋಲ್ಡ್ ಮಾಡೇ ನಾವು ಇನ್ ದ ಲೇಟೆಸ್ಟ್ ಜಜ್ಮೆಂಟ್.
ಗವರ್ಮೆಂಟ್ ಸರ್ಕ್ಯುಲರ್ ಇದೆ ಅದ್ರ ಬಗ್ಗೆ.
ಇದೆ, ಅದೇ ಅದು ನೋಡ್ಕೊಂಡೆ ಮಾಡಿದ್ವಿ ನಾವು. ಹಾ, ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಇದ್ರೆ ವಿ ಹ್ಯಾವ್ ಅಗ್ರೀಡ್. ಫಿಟೈಲ್ ರೇಟ್ ಮಾಡಕ್ ಬರೋದು. This is that judgment. No futile writs. The Constitution bench judgment where challenge was made to the appointment of Justice A.N. Ray as Chief Justice. And by that time, the next in order had resigned. Therefore, Supreme Court said, we will not examine the issue of futile writs. Anybody from memory pond? Versus so and so. Another judgment. This happened in the wake of the ADM Jabalpur versus Shivkant Shukla. In the light of that judgment, it happened actually. Anyway, Barkal.
My submission, your Lordship, the tribunal has gone into merits of the case.
Correct. We would have examined, provided it has legal consequences. You feel that matter requires examination?
Please, Lordship.
Issue emergent notice. ಬೇರೆ ಕೇಸ್ನಲ್ಲಿ ಹಿಂಗಾಗ್ಬಾರ್ದು ಅಂತ ಒಂದು ಎಂಗ್ಸೈಟಿ ನಿಮಗೆ. ಇದೇ ರೀತಿ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ರೆ. ಎಸ್,
petition by the Lokayukta institution against respondent number 1, my lord.
ಯಾವ್ದದು ಧಾರವಾಡ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಾ?
As regarding the approach of the honorable KSAT, my lord, which has proceeded to adjudicate the list like a criminal appeal, wherein as far as disciplinary inquiry is concerned, my lord, it has to be, the yardstick has to be preponderance of probabilities.
They applied
Please.
beyond
please.
the reasonable doubt.
Yes. If your lordship may kindly see.
Where is that?
Page number 36, my lord.
36.
Page number 36, para number 11, my lord, at the bottom. Evidence,
PW3.
yes, evidence of PW3 investigation officer might be helpful to the disciplinary authority in order to prove the factum of recovery of the tainted currency notes.
No, that is
From
in
the
criminal
possession
law,
of the
as you are rightly said. In criminal law, that would have been, but in
Yes, but as far as preponderance of probability,
will
my
not
lord,
be applicable.
there is, as far as the hand wash of the delinquent officer, my lord, that
It
has
pro-
not been discussed.
It
Shirt
the
wash.
pink test.
Yes, it has
Positive?
turned pink color. That is the finding of the disciplinary inquiry by the Lokayukta institution, my lord. His shirt also, my lord, turned pink.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ
My lord, the respondent, my lord, is,
Issue emergent notice.
my lord, as far as stay is concerned, stay, my lord.
Entry matter you have sought for.
Yes, yes, my lord. I
ಯಾವಾಗ
have-
ಇದೆ? 22. Order was made on which date?
No, I have sought for an interim order, my lord. It
Correct.
has not been.
When the order was made by the
23, my lord, 2000.
interim order as prayed for till next date of hearing.
Obliged.
Yes.
My lord, additional qualifying service for the assistant teachers, grade 6 to 8, my lord, that was challenged before KAT, my lord. KAT, my lord, has dismissed the application, my lord. This,
Dismissed the application.
additional qualifying, additional
the-
qualifications.
Allowed the application.
Yes, ma'am.
That Bedanga Talukdar's case,
Yes, my lord.
that weave is not loosened.
My lord.
Appears that
In-
weave
in-
is
In
loosened.
the present case, my lord, what has happened? There was a PIL, my lord, pending before the division bench. There, my lord, there was a direction that, my lord, the qualification has to be upgraded. State had made submission that, my lord, in view of that, my lord, that there will be an amendment to the rules. NCT is the regulatory body for
Correct.
this. Yes,
But
ma'am.
kindly come to page 44. Qualification as on the recruitment notification.
Yes, ma'am.
Please read 31/1/2015, that page 44. What qualification was prescribed in the recruitment notification? That would be the relevant date.
My lord, may I submit, my lord? The date of notification, my lord, was
31/1/2015.
15, yes, my lord. This amendment for the additional qualification was made on 26/11/2015.
26/11.
26/11/2015.
Oh.
Well, my submission is that, my lord, NCTE is the regulatory body for all, for fixing the eligibility criteria for all the teachers, my lord. My lord, in page, if my lords may kindly see, there is a notification of the NCTE also, my lord. 12/11/2014, NCTE has issued. Yes, my lord.
Before
NCTE,
this itself.
what it says, my lord, any amendment is made from time to time that will be applicable for the recruitment of the teachers.
If process is halfway through.
My humble submission is that, my lord, there was a PIL also pending before division bench. My lord, in that, my lord, there was, state had made a submission that the qualification will be upgraded, my lord.
For
As
next,
such, my lord, the rules were amended.
When they were amended, they were in November 2015, you amended.
Yes, my lord.
But that time, the notification was in operation.
It was in operation. That
Then
is,
how can that be?
Notification, did you mention that it is subject to any such amendment or litigation?
Recruitment
that,
notification.
that is not stated. 138 is the notification. There it is not there.
ಅದನ್ನೂ ಹೇಳಿಲ್ಲ ನೀವು, ಅದ್ ಹೇಳಕ್ಕೂ ಬರಲ್ಲ, is another thing. November 2015 amendment ಆಗಿದೆ.
Please, my
PIL ಯಾವತ್ತು decide ಆಗಿದೆ?
lord, that the PIL I'm not
When
having.
it was decided?
I have the number of PIL, my lord. Would it be taken on Tuesday, my lord? I'll get the PIL.
Next week. ಏನಿಲ್ಲ.
Lord, notice maybe.
ಯಾಕೆ notice? We are not convinced at all. Sorry.
But NCT, which is a regulatory body, my lord, it says, my lord, any amendment made, accordingly, rules were also amended.
You say, in fact, Apex Court in BS Minas referred to Justice Felix Frankfurter's judgment,
Please, my lord.
saying, if you tell to the public at large that you are going to do this, you are bound by that ordinarily. We have followed that in 3 judgments. That judgment, great judge, Justice Felix Frankfurter was a great judge of US Supreme Court. His
Please,
birthday was celebrated as National Day of United States of America.
Yes, my lord.
And his introduction to the letter, two books are very famous books, I tell you.
Please, my
The
lord.
letter correspondence between Harald Lusky of Manchester University and Oliver Wendell Holmes
Please, my lord.
from 2016, sorry, 1916 till 1937, till he breathed his last.
Please, my lord.
Letter correspond to volumes there. He has written an introduction to that. That introduction itself is something marvelous. His versions became Indian law because of B.S. Mina's, another is Sukadev Singh versus Bhagat Ram and R.D. Shetty versus International Airport Authority. I've said that. Maneka Gandhi also,
Please.
even in Maneka Gandhi. And how can you say?
Really, the only thing what they, sir,
Time ಕೊಟ್ಟಿದ್ದೀನಿ.
TCH.
ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ
Please.
upgrade argument ಅನ್ನು upgrade ಮಾಡ್ಕೊಂಬನ್ನಿ. Yes. Generally,
For the petitioner in this case.
what is
this
meant by Farooqi?
We are the descendants of Hazrat Umar Farooq.
Okay.
Yes. So that is how it has continued. And
Do you know one thing? Prophets' descendants,
yes,
when they were in Karbala, because they were threatened, somebody told them, go to India, you may be protected. So descendants of prophet came to India.
yes,
They did not go to any other country. They came to India.
this country of peace and love.
Which accommodates. That's the reason why your that Kashmiri Pandit who converted to Islam, that Muhammad Allama Iqbal, Sare Jahan se Acha. In one stanza he says, in one write-up, he's a great scholar, Pandit from Kashmir. He writes, the ship of Islam sailed through 7 seas, but sank into Ganges in Sindhu waters. Very historical sense, in that sense he said. Yes.
I am for the petitioner in this case. Petitioner is a 100% blind candidate. His candidature was rejected because he is 100% blind. It is a covered matter of this
What
on.
by our judgment?
Yes, 11th, 19994 of 2020.
19994.
But
I am giving a similar order was is required. Another petition was filed.
Another petition also.
It is also filed. Interim order is granted in that.
In that matter.
Yes. It may be clubbed with it, Your Lord.
Why you will dispose it off today?
Indeed, because
fee issue is there?
No, it is pro bono, Your Lord. Because their date is given as January. And because I will be answerable to the candidates, one is saying mine is taking that way. That is, or it may be clubbed and any date, short date may be.
Call this matter along with WP number.
I have
Fine. So tomorrow?
Yes, Your Lord.
One notice agide, no?
Emergent notice because all are
respondents.
Yes.
Okay. But tomorrow we'll have that.
Please.
Okay.
The
One
connected.
copy tagdittukodna. Raghu, keep that copy.
I have produced in the other case. I have
The other
produced.
case you have produced?
Yes, produced.
Very good.
It is 18603, the connect.
Write down.
In fact, I am from the same university where Allama Iqbal studied.
Oh.
I did my law.
Great thinker and a great writer. He went back to Pakistan after writing this poem and became defense minister and waged war against India. History, sometimes history plays very, very mischievously. Yes, but very great scholar.
Yes.
Is from Pandit family.
Yes.
From Waraha Mullah in Jammu Kashmir. Kumar.
APF for the appellant in this matter. Plaintiff's appeal, my lords.
Respondent number 3 may request for a passover.
Passover.
Please.
Passover.
Please.
Yes.
Your Lordship advised, my lord, the government has to give posting to both of us. my lord.
Huh?
Your Lordship, suggestion,
Mike Odi. Mike Tol.
I'm sorry. Yeah, a suggestion was made to go send both of us out of Bangalore. They.
That matter. That lady.
Yes,
one
my lord,
lady
yes,
and
yes.
one gentleman.
They.
Order madira?
Though it is for, the honorable minister has to sign it.
To sign
Yes, that is what they have requested with a letter, my lord. ಅಲ್ಲ, ಇದು ತಗೊಳ್ಳಿ, photo. ಸ್ವಲ್ಪ
ಅಲ್ಲ ಈಗ ನಾವ್ ಏನಾದ್ರು ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ ಮಿನಿಸ್ಟರ್ ಸೈನ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ
It will be signed, that is what they are.
ನೋ ಇಶ್ಯೂ.
But I have produced a prop.
I requested for that code or not that. He requested.
Let them make that request. my lord.
ನಾವೆಲ್ಲಿ ಆದೇಶ ಮಾಡೇವೆ ಆ ರೀತಿ. Only discussion took place in the.
Outside Bangalore ಅವ್ರನ್ನ post ಮಾಡಿ, that was the directions.
Orally, your lordship was pleased to make a suggestion, send both of them out of Bangalore.
ಹೌದು,
Since I was in Bangalore for more than 6.5 years, my lord, and my friend, there is a complaint against that, on observing that your lordship was pleased to make a small suggestion, that's all, there's no order as such.
Same copy, my lord. I received a better copy. I am placing it. In the memo, it is not legible, my lord.
ಆಯ್ತು, ಅವ್ರದ್ದಾಯ್ತು, ಇವ್ರದ್ದು ಏನ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ, ಇಬ್ರದ್ದು together it is pending for signature.
ಹಂಗಾರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕರಿತೇವೆ, ಅವಾಗ ತಿಳ್ಕೊಂಡು ಹೇಳಿ ಏನಾಗುತ್ತೆ.
Please.
ಹ?
Yes,
ಏನ್ ಡಿಸ್ಪೋಸಲ್ ಮಾಡ್ಬೋದು, ಈ ರೀತಿ ಮಾಡ್ತೀರಾ?
yes, my lord. It can be done.
ಬರ್ತಾರೆ. Are you agreeable with that proposal? Please.
That.
Professor, you are also
So,
agreeable.
ನನಗೆ ಕೊಡಲ್ಲ ಕೇಳ್ತಿದ್ದು that it because my only hardship not that I'm KR-ಪುರಂ ಅಲ್ಲಿಂದ ಹೋದ್ರೆ ಸ್ವಲ್ಪ my aged parents are there and
Representation ಕೊಡಿ, ಅದನ್ನ ಕನ್ಸಿಡರ್
Yes, yes. Let them.
grateful.
ಬರ್ಕೊಳ್ಳಿ. This matter laying a challenge to the state administrative tribunal's order dated in application number so and so was heard by this court for some time other day. First off, some discussion took place as to the proposal for sending the petitioner and the contesting private respondent out of the district, so that the level of heartburn would diminish. First off, for that purpose, matter was adjourned. First off, next part. Today, learned AGA has filed a memo dated 27/11/2024 along with ಇದಕ್ಕೆ ಏನಂತಾರೆ ಇದಕ್ಕೆ no term ಏನಂತಾರೆ, this is not order in
No,
it.
my lord. Letter dated, my lord.
Producing a copy of the letter dated 26/11/2024 addressed by her client,
Under secretary.
that is under secretary to the
And the
Department
revenue.
of Revenue bracket ನಲ್ಲಿ services one
Yes, my lord.
services one, which reads as under. First off, learned counsel for the petitioner is agreeable with the proposal penned in the said letter. Although learned counsel appearing for the private respondent has some reservation. First off, Professor Nagarajan appearing for the private respondent submits that his client would be satisfied if her representation in the making seeking appropriate placement is duly considered by the respondent government. First off, he also submit that such representation will be made in not very within 1 week.
Grateful.
Within 1 week from this day. First off, it hardly needs to be stated that the apex court in Varadharao state, Karnataka, they are 95 Supreme Court.
91 Supreme Court subject to correction.
May not be 91. Just note cut. In so and so has observed that the employees who feel aggrieved by transfers can make representation to the employer. And that the grievance of the employees shall be duly addressed. First, next paragraph. In the above circumstances and with the above observations, this petition is dismissed.
So far as petitioner is also concerned, he may be permitted to submit the representation, my lord. He has also opted for Gauri Bijnur cases.
Ali, Professor so and so. Next, in one sentence. Similarly, counsel for the petitioner reserves his reserves his client's right to make similar representation. Okay. This
Great.
Till such time, the present petition may be continued, my lord, please.
86 Supreme Court it is. 1986 Supreme Court. You are right. Because 85 Justice Ramajesh decided it.
Alinda gate in the sea. By then there was no high court, my lord.
Correct.
He said,
Varadhara versus.
Varadhara was from Mangalore, my lord, used to come.
Yes, he was in labor department.
Yes, labor
I read that
department.
judgment. Once I read that judgment.
He used to argue the case personally before Supreme Court also, my lord, please.
Yes. Yeah.
Appeal arising out of dismissal of the suit, my lord, which has been filed, lord, to enforce a foreign judgment.
This matter we heard sometime
Your
the other
lordship
day.
heard it.
Yourself and Katie.
Yes.
Where is Katie? Your friend is not here.
On the last occasion I appeared through VC, he was here.
Just see whether just he may be in the coffee shop or in the library. We'll pass it over. Yes.
We pass over the matter.
Huh?
Senior has held up in other.
Suhani Pula.
It's
Katie, are you ready in the matter? Come. Yes, start. Yes. You have come from Kerala?
Yes, Madurai.
Madurai, Tamil Nadu.
Yes, ma'am.
City of great temple, Meenakshi temples. Yes.
My lord, bundle it. We'll get a copy. Lord, I just prepared because I have to now substantiate whether the judgment of the foreign court
What is the
conclusive
just
or
give
not.
us the foundational facts.
Yes. Lord, the appellant before lordship, Lord, had preferred a civil suit before the district court at Illinois.
Illinois. US.
US. Lord, for recovery of money from the defendant herein. Lord, this summons was served on the defendant. He appeared before the district court therein. He filed an application to strike off my complaint. That was rejected. Subsequently, he filed his answers and a counterclaim therein. He filed it therein. And he was also directed, my lord, for discovery, for which, my lord, he took time from May 2003 to October 2003. In the meantime, his advocate, his attorney therein, my lord, withdrew from the case.
His advocate?
Attorney there. He withdrew from defending the defendant.
He retired.
There. Yes, he retired.
To use our terminology.
Yes.
Retired from.
He retired, yes. So, my lord, there was an intimation to him. He has acknowledged it. He has written directly to the district judge therein also. That so I just wanted to narrate the facts.
That's what.
Yes. And subsequently, my lord, after 1911-2003, Lord, he was aware that there is no one to defend his case at United States. And subsequently on February 20,
But in the meanwhile,
2004.
WS was filed, counterclaim also was filed.
Yes.
Almost like ours.
Yes, yes,
Okay.
yes. But I have also comparatively, I have given a chart of all those.
Indian law
provisions.
and
Yes.
Illinois law.
Civil CPC with the federal rules. Yes. I'll circulate it again if it is there. Thereafter on 20 February 2004, a judgment was passed by the.
Why federal rules?
It's not
That
federal
is
court, I'm sorry.
State
District
law,
court.
state rule.
District court,
State
I'm
rule.
sorry.
Okay.
District, I stand corrected.
Okay.
District Court passed an order on 22/2004, a judgment. Based on the judgment, I filed a civil suit before the District Court at Bangalore.
You filed suit again?
Yes, yes. I have to file a civil suit because 44A of CPC is not applicable to me because there is no reciprocal arrangement.
Between India and
Yes.
US.
If there is a reciprocal
What is
arrangement,
that 44 of CPC? I do not
44.
remember. Just let us. Where there is no reciprocal treaty, something like that.
There is nothing so to that extent, but there are some.
Let us read. CPC, so many times I have read, but again and again, we have to read. Yes.
44A.
A.
Yes.
44A. Execution
this
of
amendment
decrees
is
passed by courts in reciprocating territory.
Execution of degree passed by courts in reciprocating
Where are
territories.
you reading?
Yes.
Where are you reading?
44A, my lord.
44 capital A?
Yes. Where a certified copy of a degree of any of the superior court of any reciprocating territory has been filed in a district court, the degree may be executed in India as if it had been passed by the district court.
So foreign decree.
Yes.
With foreign judgment
Yes.
to use
Yes.
section.
Yes, you have to only file it here for execution.
That directly can be executed
Yes.
in Indian
Yes.
courts. So this is not applicable because there is no reciprocatory arrangement.
Yes.
Okay. Therefore,
2. Together with the certified copy of the degree shall be filed a certificate from the superior court so and so. If any of the degree has been satisfied all this. Now your lordship may kindly take 3, 44A subclause 3.
the provisions of section 47 shall.
3. The
As from the
provision
filing
of
of-
section 47 shall from the filing of the certified copy of the degree apply to the proceedings of a district court executing a degree under this section, and the district court shall refuse execution of any degree if it is shown to the satisfaction. My lord, I'll emphasize here. If it is shown to the satisfaction of the court that the degree falls within any of the exceptions specified in clause A to F of section 13. My lord, 13 is the rider. Section 13, my lord, prescribes regarding, my lord, conclusiveness of a foreign judgment. When
That question arises.
Yes.
That question arises.
My lord, here is
44A.
44A is applicable for degree which has been obtained from a reciprocating country.
Correct.
If I don't have a degree, or if there is no reciprocal arrangements from with India, I have to file a civil suit before the India, the district court where the defendant is living. And my lord, 13 is will have to be substantiated.
What is 13? Let us see.
Yes. When lordship's got it?
Yeah. When foreign judgment.
13
not
and 14, my
conclusive.
lord, will have to go together.
13 and 14.
14, yes.
Okay.
Because there is a presumption of the foreign judgment.
Okay.
May I read, my lord?
Okay.
A foreign judgment shall be conclusive as to the matter thereby directly adjudicated upon between the same parties or between parties under whom they are any of them litigating under the same title except A, where it has not been pronounced by a court of a competent jurisdiction. B, where it has not been given on merits of the case. C, where it appears on the face of the proceeding to be found on incorrect view of international law or refusal to recognize the law of India in case in which such law is applicable. Now D, where the proceedings in which the judgment was obtained are opposed to natural justice. E, where it has been obtained by fraud. F, where it sustains a claim founded on a breach of any law in India. Force in India, I'm sorry. Now 14.
One second. We'll examine what is meant by 13. 13 is independent of 44A.
Yes, my lord. Yes. It is an independent test.
So you need not have reciprocity arrangement
Yes.
with the country whose court has passed the foreign judgment.
Yes.
That's right. I do not know.
I beg your pardon.
We are asking.
My lord, District Court of Illinois has passed the order.
Correct.
I have.
Is it a foreign judgment?
It is
Very
a foreign judgment.
is defined.
Yes, my lord, it is defined.
Under
Lordship may kindly see 2F25 of this
the dictionary clause of
definition, CPC 2, 5 and 6. Man. A foreign court and a foreign judgment. Because even in the last occasion, your lordship posed the same question. 2-5.
5.
Yes. Lordship got it?
Yes. Foreign court means
Foreign
court
court
situated
means the
outside
court
India.
Outside India. And not established or continued by the authority of the central government. 6, my lord, speaks about foreign judgment, means the judgment of a foreign.
Perhaps foreign court means a court situated outside India and not established or continued by the authority. That means it should be like Indian court only, but operating from outside India. But may not be much relevant now. Foreign judgment means the judgment of a foreign court. Yeah. Any judgment of apex court discussing
There are
court foreign judgment. Do you have any judgment?
Yes, my lord, Alcon Electronics 2017. The last occasion I've circulated that.
You have that copy? Not rulings court of sir. Rulings is on.
Avune. Irka. Alcon Electronics.
Not established, you are right. Established, not established.
In fact, my lord, section 14 contemplates that there is a presumption. Your lordship may also take 14 also before going to
Section 13 is a substantive law.
Yes.
Section 13 is the substantive law. 14 is rule of evidence. Because presumptive
14 speaks about
presumed to be.
Yes. Cousin.
So it presumes competence of the court which rendered the judge, handed the judge.
Yes.
Only that much.
Yes.
Okay.
Now, your lordship may kindly take para 12.
12 of this judgment. That's fine.
It starts from para 13. I'll skip over that. Your lordship may kindly take para 14. At page number. Not available. Sorry. Made para 13. Para 14, man.
14.
Yes.
A plain reading.
Yes. A plain reading of section 13 CPC would show that to be conclusive, an order or degree must have been obtained after following the due judicial process by giving reasonable notice
next
and opportunity
which is that,
to all.
Yes, we have seen that. Which is the next paragraph? Which paragraph you want to bank upon? In
15, 16, 17 also.
15, 16, 17?
Yes, all the three, all the four.
Very clear that the foreign judgment is between final and between parties, not impeachable either on facts or law, except on limited ground science. Restoring section 13, we have to look at plain meaning of the word that expression. 14.6 is the presumption. That's irrebuttable. Rebuttable. 15. Appellant contends that the order of the English court is not given merit and falls on 13C. It is a result of which it is not conclusive. Therefore, such judgment can be considered judgment passed on merits when the court deciding the case gives opportunity to parties to put their version. Considering that tribal submission gives its decision in the form of an order or judgment, it is certainly an order on merits of the case in the context 13 series. Applying the same standard told that or passed by the English court as an order of marriage, meant by itself to jurisdiction. Then the order by dismissing the point by English. Had it been the case where a falsification was allowed, cost by the law, that is, refer any appeal sciences, so and so. All right.
14 to 17 would be relevant.
7. Yes, we have read all the paragraphs. Any
I'll
other
stop.
paragraph to be read in this judgment?
My lord, because the issue 1 is relating to, my lord, the merits of the case and the other things.
No,
which
but this question, 44A is not
not
considered.
applicable to me.
Not applicable.
So that is why I filed a civil suit. Otherwise, I could have filed an EP before the district court of Bangalore. If there was a reciprocal arrangement.
You would have
because
executed
in this
the
case, yes,
decree
in this
itself.
case, Alcon Electronics, there was a reciprocal arrangements between UK and India. But
So 13 also enacts rule of evidence only. Mr. Kitty? What is your take on 13 and 14? 13 also, it does not make the judgment enforceable proprio vigor in India. It makes what is decided in the judgment conclusive. That's all.
yes,
Just see the section 13. 13 enacts the rule of evidence as to the foreign judgment becoming conclusive, which is that section in the Evidence Act.
4,
One provision,
section 4 of
section
the
4
evidence.
of the Evidence Act shall be conclusive. So it's plain 12 of the Evidence Act, conclusive proof of legitimacy of the child.
My lord, we will read the last paragraph of 44A for that purpose, to
44A.
come back to 13 as
No,
to.
44A will
44
not
is-
travel
No, no.
because
Oh,
we have no reciprocity arrangement with Illinois.
no, I am not on that. I am on this part of it. Please see 44A3.
Yes.
The provision of so and so shall be the date of filing so and so. If it is shown to the satisfaction of the court,
Only
that the
enact.
decree, no,
Mr.
no,
Chetty,
we are
one
dealing with
second.
the whole
We have read
degree.
that. 1 second, we'll tell our view on that. 44A is subject to 13.
Yes.
That's all.
So what does it say? But 44A, it says, shall refuse execution of such decree if the decree is shown to the satisfaction of the court that the decree falls within any of the exceptions specified. So the entire decree as a whole is then excluded from 44.
Provided it is.
And it
put
falls
in
within
execution.
13.
No. No. 44A puts a foreign judgment on par with a judgment handed by the domestic court. Makes its execution subject to complying with 13. That's all. 44A is not applicable because
No, it's not.
he is not executing the decree at all. He
I
is
accept.
using the decree as a piece of conclusive evidence.
Yes. But now 13. It is substantive to the extent that if it does not conform to the rule of evidence stipulated there, then it goes. So the my lord,
Gopal,
it furthers the
the matter
proposition.
is urgent on request. There was some bereavement in the family of your opponent's counsel.
My lord, what has fallen from my lord is the last nail that was required. I'll put it in this fashion, merely rephrasing what my lord has said.
No, we are not on.
No.
Only-
I'm not. I'm only, with apology, my lord. I will be a little on a lighter side, my lord.
I
Forgive
know,
me
you know.
for that.
Should be.
It's my want.
It should
I
be.
always
Should
do it
be.
that way. He is neither shut out nor do I have intent to shut him out, though I shut out this case in the trial court arguing myself 10 years back, my lord. That's a different issue, my lord. The point that my lord, the finer nuance that has come from the court gives me an additional point to urge. Additional to the extent that it sustains what has already been there. It is this, my lord. When it is said that it is not that en bloc, the decree is final. No. I find that nuance most gratifying, my lord, most satisfying. It is for this reason. When we say the matter is not conclusive, and my lord, I repeat that when the matter is not conclusive, it means an
Something
aforesaid
can be-
requirement that the matter ought to have been dealt with.
Correct.
Because for anything to be conclusive, there is a requirement that the matter ought to have been dealt with.
Correct.
That prerequisite is one which I will develop upon when my turn comes further on that. But I am in complete agreement on that when my lord has pointed this out to the extent that it is conclusive as with regard to the matter. And
Correct.
on that, there is no dispute.
Correct.
We accept that.
Only evidentiary.
We
matter.
go with that proper. We
In
proceed.
other words,
Yes, indeed, my
it
lord.
is evidentiary,
Yes.
not rights are decided.
And once we, yes. And once we go evidentiary, we go to the merits of the matter, we go to the facts of the matter, we go to the substantive issues
As
in the matter.
enumerated in 13.
Then it straight away flows back to 13.
Agree. So on law, we are in agreement now,
Yes.
broadly.
Yes.
Broadly, we are in agreement.
Entirely.
Yes, ma'am.
Okay. In other words, I will now articulate in the light of your submission, in the light of the judgment of the apex court, text of 13, 14, 44A, more particularly the last provision of the 44A, because it takes you have to travel to 13 again.
Yes.
Because of that. Yes. Where perhaps these are all on the principle of comity and amity of nations, which J.G. Stark discusses in his international. Open hymn discusses in international law, that friendliness with the countries.
That
on-
was
in the
also
globe
highly-
that way. One second.
That aspect was also highlighted in Alcon Electronics also by the apex.
The first one is where we have an arrangement with a foreign jurisdiction. The decrees granted by the foreign courts become our decrees for the purpose of execution, only for the purpose of execution. If that is in the text of section 44 capital A, subject to the exceptions which have been enumerated
Yes.
in section 13. Correct? Yes. Where we do not have any arrangement with the foreign country, then 13 becomes invocable, not for deciding the rights of the parties as having been decided, but only as evidentiary of certain things stated in the decree, subject to following principles of natural justice,
Yes.
applying the law which otherwise would have been applied, Indian law, which otherwise would have been applied, and recognizing Indian law otherwise. This
Exceptions.
appears to
Yes,
be the
6 exceptions.
in substance
One
of
is
13,
jurisdiction.
14, etc.
One is jurisdiction, A. B is on merits. C is, my lord, whether it is in contravention of international law. D is with regard to, my lord, whether principles of natural justice.
International law,
Yes. Contravention. of-
private international
Yes,
law.
Yes. And 4 is whether it was, whether there was a violation of natural justice.
Justice principle.
E with regard to fraud committed to obtain the
That's
judgment.
all.
on- Yes.
That is.
And F, my lord.
Lord Coke's principle.
Yes.
Fraud vitiates everything. Edward Coke's principle.
And if the judgment is obtained on a contrary law which is enforced in India.
Yes.
Now I'll just circulate another judgment of the Gujarat High Court. Not,
To the
this is
effect-
following. I've also circulated
To the what effect?
to the extent because this is a non-reciprocating country.
Yeah, we are in agreement
Yes.
with you. When
Yes.
judges agree, unless you want to confuse
Yes.
us,
Now,
you need
my
not
lord-
take the decisions at all.
Now, your lordship, kindly take, my lord, I just prepared a short notes on 13B, my lord. I've just circulated it.
It's not now.
Your Lordship got it, my lord.
Ah,
So this, I just culled out the 6 exceptions insofar as this case is concerned.
we can skip off. We have read it. No.
I beg your pardon?
We can skip off. Go to next point.
Yes. Lord, now, my lord, with regard to A, my lord, I have taken, my lord, the defendant had admitted in his written statement and his examination.
Let us go to the facts now.
Yes.
You had filed money suit.
Yes.
OS 590 of 2005.
Yes, please.
What are the issues framed?
The issues which are framed are at page number 32, my lord. 32.
32.
32. Lordship.
Correct.
32 of the booklet.
Correct.
Whether the plaintiff,
Judgment of foreign court on which is lying is conclusive against the defendants. Number one.
whether the defendant
Defendant
proves
proves
that this
this
court
court
has
has
no
no
territorial
territorial
jurisdiction.
He was asked to,
Yes,
burden
yes.
was on him. All. One, we have understood.
To try to suit,
Two,
try the suit
whether
and thereby
is
the
it-
suit is not maintainable.
it-
Whether the plaintiff is entitled to the suit and what order or degree to be passed. Now,
One
there was an
second.
additional issue.
One second.
also.
Whether the plaintiff proves that the judgment of foreign court on which he is lying conclusive against the defendants. Why that one? First, read the first issue. It's a
First-
duplication.
Yes,
Duplication.
there is some.
Same is
Yes,
duplicate.
madam.
Okay, anyway,
One-
leave it. No issue. The next one, additional issues.
Additional issue is at the instance of the defendant. Whether a
Not-
defendant proves that the foreign judgment on which the plaintiff is relying is not conclusive as it comes in any one of A to F of section 13 as contended in their written statement.
So issue number 2 was territorial jurisdiction of the court.
Yes, that is at
Which
his,
court? This court or Madurai court that way?
yes, my lord, yes.
Not on 13 or 44A.
But if that is answered, 13A is answered herein. 13A speaks about the competency of the foreign court.
About
The Lordship may kindly see 14. 14, because 13A speaks about whether the judgment was obtained by a competent court.
Brother, 13 speaks of evidentiary value of the judgment.
Yes,
It does not speak of territorial jurisdiction of Indian court at all.
that I am only before your Lordship to say, if it is a stand that the district court, the Illinois, did not have jurisdiction to pass an order, then my lord 13A would be applicable. Your Lordship may kindly take the 14 for a moment again.
14 we read.
Yes,
The
14
presumption of
speaks.
competence.
Yes, only till the jurisdiction. If he
No,
admits the
this-
jurisdiction,
No, brother. Your issue number 2
yes,
is jurisdiction under section 16 to 21 or something like that, na? This is territorial jurisdiction of the court.
not his.
It has nothing to do with jurisdiction of that court.
No, if he admits the jurisdiction of that court, it
Still he
becomes
can raise.
conclusive.
No.
My lord, I would
No,
say,
no.
I would say to this extent, because his contention in the written statement was, I should not have filed the suit before
In
the
Bengal.
present, yes.
Yeah.
But my contention is, my lord, I am aided with a foreign judgment.
No, courts have said, I remember one judgment of Justice Rajamanna of your High Court, great judge of your High Court on this point. Jurisdiction is not spoken of in the sense you are putting forth. It is competence. Section
Yes.
14,
Yes.
competency is one thing, jurisdiction is another. That's how Halsbury treats. Halsbury's 4th edition, Halsbury's Laws of England. You,
Because-
the jurisdiction, I'll tell you, this is discussed by Supreme Court in 1954. Kiran Singh versus Chaman Paswan. 54, write down so that you can
I'll
check.
go through.
AR 1954, page 347, something like that. 3 types of jurisdictions. One is subject matter jurisdiction. Another is pecuniary jurisdiction, and yet another is the territorial jurisdiction. The issue number 2 is territorial jurisdiction
Of
the court which possibly gave the decree, dismissed your suit, na? He took up the contention, not Bengaluru court, but Madurai court or some other court that way. Bengaluru court cannot decide the matter. One second. Listen to that. Listen to us.
his contention was that the judgment which has been obtained from the foreign court cannot be enforced here.
That is issue.
That is issue number
additional
2.
Additional issue.
No, that is with regard to my lord 13. Additional issue with regard to 13.
Correct.
The second issue was with regard to
Where
the
are
jurisdiction.
your WS?
I beg your pardon.
Where is that contention raised? How that issue is framed?
But,
Where is that contention of WS?
In the WS, kindly see page 25, running page 25, last paragraph. As admitted by the plaintiff in para 2 of the plaint, the foreign court is the jurisdictional court and therefore the present suit is not maintainable. That is my averment there.
Huh?
In para 3.
Para 3.
Para 3, running page 25.
Page
25 of the booklet.
last portion.
25.
Last portion, last sentence.
Last portion and
You are
page number
right, you are
25. The question of carrying on joint venture.
As
business-
admitted by the plaintiff in para 2 of the plaint, the foreign court is
Difference
the
have not
jurisdictional
issued
court
any
and therefore the
developments
present
in
suit is
para
not
2
maintainable.
Jurisdiction.
Had filed a frivolous case. Para 25, para 3,
Page
page
25.
25, para 3.
Para 3,
ಯಾವ sentence? Which sentence?
last sentence.
As admitted plaintiff in para 2 of the plaint, the foreign court is the jurisdictional court and therefore the present suit is not, then that issue would not have framed at all. This is not your case. Let us see with the para 2 of his plaint. Where is that?
Starts at page number 1.
Next one, page 4 also.
Ah,
Page 4,
para 4.
no.
Page 26.
Not, they have themselves said in their pleading that only the foreign court has jurisdiction.
And if they may say that, but court will decide that, even if they have said that.
No, but I'm not putting too much energy
Okay,
onto-
on that at all.
to that aspect.
You are right. Yes. This was this. Whom you examined on your behalf?
I have examined myself on my behalf, on behalf of the company.
Veerasikku Bomai Swami. That is BDW1. Your plaintiff side, who was examined? Plaintiff himself was?
Yes, plaintiff and the defendant were examined.
Where is that plaintiff deposition?
She is at page number 34 it starts.
34.
Proof affidavit starts at 30 and the examinations thereafter. Actually gets at 56, further examination. The 1 to 24 exhibits which have been marked.
When
Page number
when
37.
they admit in their plaint, then neither
What?
is to this effect, page 4 of the paper book itself. The foreign court was the jurisdictional court and that it was so is also admitted by the defendants before the foreign court.
To the extent that
To the extent
judgment
when they
rendered by
admit.
it is valid ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ.
When they admit, no, when they admit jurisdiction at that point of time, it means jurisdiction for the purpose of suing in the first instance.
Admission on jurisdiction are never treated as conclusive. That's the law. Yes. Because by admission, you can't give the jurisdiction. That's on that principle. 1783 judgment of the House of Lords. All jurisdictions have followed that. Yes.
But here, the process having been completed in that court, having stated that it is having jurisdiction there, and then after concluding that, they have now come and sued on this. That would have
Not have anything.
Paras.
on the territorial issue, there is a finding that it has jurisdiction, and we have not questioned that subsequently.
what-
That need not be labored on that.
Correct, correct.
Sound. Court sound.
ಅದೇ ರೀತಿ ಮಾಡಿದ್ದಾರೆ. ಅದೇ ರೀತಿ. ಅದೇ ಸೆಂಟೆನ್ಸ್ ಹೇಳಿದೆ ಒಂದು ಐ ಡೋಂಟ್ ರಿಮೆಂಬರ್ ನೇಮ್ ಆಫ್ ದಿ ಜಡ್ಜ್. Some judge. He said the same sentence is there, correct? Limits defenses of availability. Come to 54.
Pardon?
Page 54. You are a local counsel. You should advise him. You should brief him so that whenever, because some interaction problem will be there, na? ನಾವೇನ್ ಹೇಳ್ತಾ ಇದೀವಿ ಅಂತ ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು. Come to 54.
Yes, ma'am.
Read your prayer.
Yes. Directing the defendants to pay a sum of rupees so and so, together with interest at 18% per annum for the date of the suit until its payment. Grant such other relief as this honorable court may deem fit grant.
Where is any further examination also done?
Oh, my lord.
Where is cross-examination?
It is available at page
58.
Yes, my lord.
Begins at 50,
Starts at 59.
59.
Yes, sir. That is my appellant's cross-examination.
You were importing textile material from India and China.
Yes, ma'am. From India to United States. China, sorry.
Deni
In
is
Tamil
in
Nadu.
Tamil Nadu.
Yes.
Deni is
Just near
Munnar.
Kambam. Yes, Munnar.
Munnar.
On the way to Munnar.
Deni, Bodi, Munnar. These three. Okay. All right. Perhaps others, perhaps you have to come afternoon. This will take some time. It's a little heavy matter. ಒಂದಿಬ್ರು ಯಾರಾದ್ರೂ ನೆಕ್ಸ್ಟ್ ಒಂದು ಇಬ್ರು ಮೂರು ಜನ ಇರಿ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಇರೋರು ಉಳಿದವ್ರು ಕಾಯೋದು ಬೇಡ ಯು ಆರ್ ಎಂಟೈಟಲ್ ಟು ಸಿಟ್ ಇನ್ ದಿ ಕೋರ್ಟ್ ಆಲ್ ವಿ ಫೀಲ್ ವೆರಿ ವೆರಿ happy to see you all here, but you need not sit.
If I may focus on two sentences while my lord may read the entire thing. At page 59 itself, para 2, last line.
Yes, 59, I read that actually.
It's, I have produced certified copies of all the documents which have been produced before the US court.
He says in US court we have produced.
In US court. And then he says, after that, when we say whether you have produced any document to show the defendant number 1 offered himself to associate so-and-so, those documents have been produced before the US court. And what he has produced before this court are enumerated as ABCD in the chief itself, my lord has seen. And those are all procedural documents of what transpired in the US court with regard to procedure, each one of them.
No, once there is a decree, on you lies the heavy burden and limited scope of defense. Under 13, read with 14.
No, that's all right. I'm only pointing out his evidence here in support of the prayer that was read earlier. And straight away, my lord rightly took them to the evidence. And when we went to the evidence, what was it in evidence? This was in evidence, my lord. Kindly see the.
No, Mr. Kheti, you now the foreign judgment is conclusive subject to enumerated exceptions.
Yes, yes.
Exceptions are always to be proved by those who put forth the exceptions. What are your defenses?
That I will come to.
You be seated.
I will.
It's on par with arbitration matters.
Arbitration.
34,
challenge,
34.
limited scope.
That's how court have said.
Now, the suit has to be treated as if it is an arbitration challenge under 34. The limitations which are there enumerated in 34(2).
The same limitations
Yes,
apply here.
Almost same limitation.
Yes, my lord, I agree with that.
Yeah.
I was,
the scope.
this is the second limb of the submission. I still have to overcome the first limb. And for the first limb, I will begin thus, my lord. What my learned friend is counting upon in his submission,
What court say,
13.
what court below say as to why the judgment of Illinois court cannot be treated as conclusive proof between you? Where is the reasoning? Yes.
It was only on merits.
1 second. Two questions just we are putting to ascertain the facts. You had submitted yourself to the jurisdiction of foreign court.
Yes.
You had drawn the battle lines were also drawn there. You had filed your pleadings.
Yes.
Did you depose before that court at any point of time? Up to particular level, perhaps you deposed also.
I did not depose.
You did not depose.
No, I did not. Depose.
After filing of your written statement
Yeah.
and counterclaim, you did not go before the court at all.
Not go.
What is the reason why you did not go there?
But one of the reasons was, I think there was some issue with the council with regard to the fees. So they were extremely.
That was with your
expensive. That
advocate.
was one. And secondly, I was given to understand also that there was no visa available to him. In the first instance, it was rejected. His visa was rejected. That was also one of the issues that.
When you were supposed to go before the foreign court, can you tell us the date?
Sometime that date.
Two thousand one,
Huh?
14/8/2001.
What is that?
Summons were issued to the defendant.
Summons
Served on
was
the
issued.
defendant on 29/9/2001.
1 second.
Yes.
Summons was, you instituted the suit in foreign Illinois court when?
Well, I instituted it in 14/8, madam.
Suit filed on?
14/8.
No, Barkoli. The suit in Illinois district court,
It's available on page number 118.
1 second, 1 second.
118.
1 second. Suit in Illinois court, district court was filed on,
A complaint. There they.
anyway, in our, this.
Yes.
You
It's a
can say,
complaint there, it's a common law.
Ali, suit bracketal complaint. On which date?
14/8/2001.
14/8/2001. That is available in which page?
Page number 118.
Bracket
exhibit
nalli,
3
PB 118. 118?
Of the booklet, madam.
That's what. 118, bracket complete.
And
Summons was issued on which date?
summons was served on the defendant on 29/9.
Issued on which date? There is some relevance. That's the reason. I'm not disclosing it to you now. Summons was issued on which date?
29/9/2001. Was served.
Summons was served. Served, yeah. Issue date, you don't know. Anyway, served on the defendant on
29/9/2001.
29/9/2001.
Acknowledgement-
Break 1 second.
Acknowledgements were returned on
Acknowledgement of service returned on
18/10/2001. 2001.
18/10/2001. All this is available in at which page?
All that is available in page number 118 of the booklet. Exhibit
ಇಲ್ಲಿ
P3.
ಹಾಕೊಂಡ್ಬಿಡೋದು ಲಾಸ್ಟಿಗೆ. Exhibit
P3.
P3,
And next, my lord.
PB 118. Okay.
Then 9/11/2001.
When he filed his WS and counterclaim, he filed his written statement and counterclaim in the foreign court.
Yes. Initially, he filed an application to dismiss my complaint on 11/9/2002.
ಬರ್ಕೊಳ್ಳಿ. On 11/9/2002,
Exhibit P10.
defendant filed application seeking dismissal of suit. Wide exhibit
P10. madam.
P10. Page, paper book page?
Yes, all the paper book,
How can that be one page?
197.
197, PB 197. Okay.
I'm sorry, my lordship, that is the order which is supposed to have been passed.
One,
Yeah.
1 second, 1 second. The application came to be rejected on
On 11/9/2002, but it was filed on 9/2/2002.
9/2.
Yes, 9.
Filing 9/2 madu. It was rejected on
11/9/2002.
11/9/2002. Exhibit
Exhibit P10.
P10, page
197.
PB 197. Okay.
Then 17/10/2002, my lord, he filed his answers.
1 second.
That is a written statement.
He filed his WS come counterclaim on
17/10/2002,
17/10/2002.
page number 207.
How can that? But his application was rejected in November. Before that only he filed his
In
objection.
the meantime, he filed his only this application.
Okay.
Because that was, that your lordship may visualize Order 7, Rule 11.
That's all.
There,
Some other corresponding provision will
yes,
be there.
because he had taken a stand, it was an oral agreement. Oral agreement has to be enforced within a period of 5 years.
Under that
Fraud
law.
Act at United States. That was the stand in rejecting, to strike off my complaint.
He took up contention that there was oral agreement.
Yes, he admits and
Where is
assumes.
that admission?
Yes, your lordship may kindly see the
Page.
exhibit P10.
Only that paragraph just show us. We are a bit slow because this is a first matter where at least I am considering, maybe our Joshi
First matter
brother
for you.
may have handled. For me, this is first case.
All are learning, my lord, even my.
For
the
you
first
also.
Judgment also.
Where he admitted oral agreement.
But it is available. Page number.
Anyway, afterwards you can say that.
I'll just give it.
Okay. The order rejecting his application is of November 2002. 11/9, September 2002. Correct. Okay. Thereafter, you filed your pleadings.
Yes.
Okay. All right. Then what were the issues framed there?
But I had filed this complaint for 4 grounds. But your lordship.
Are there any issues framed in
No
American?
issues were framed.
No issues are framed.
In the meantime, after his application defending or
Was
answers,
rejected.
no, answers were filed and a counterclaim. He was directed, my lord, for discovery. Both were directed for discovery.
Like our discovery
Yes.
only.
Like order 11, Rule 21. So he was directed to come for discovery. She took time, my lord, till October 2003. From March, after the dismissal of his.
Whether like our courts, there also there was an order for discovery.
Yes.
Order for
Yes, there
discovery.
was a discovery. He admits.
The foreign court, Illinois court made an order for discovery on.
Lord, 7/5/2003.
7/5/2003.
The time was given till 17th October.
Giving time till 17/10/2003.
Page
Correct?
number 217.
Huh?
Page number 217 of the booklet.
217, a PB 217. Okay. Got the point. Next. He did not avail that.
He did not avail that. He did not avail that. He wanted to prolong it. His attorney withdrew from the case, defending him, retired.
He retired on which date?
1911, that's what he admits also.
First off. Defendant's attorney retired from the case on
9/10/2003, my lord.
9/10/2003. What was the last date for effecting discovery?
But it was till 17th October 2003.
17/10/2003 being the last date for effecting discovery. Okay.
And subsequently he filed.
He informed court saying my attorney has retired. On which date he said?
He has written directly to the learned judgment.
On
That
which
is on
date?
21/11/2003.
That is after the expiry of.
Yes.
In that letter, what he has said?
Lord, he has said that his attorney has retired. That
Retired
is
on
fully
which date?
contained. It's an exhibit. Pardon me.
Full stop. Defendant addressed letter dated, date ಹೇಳಿ, tell the date. His letter
But
to
it's
judge
available at page number 245. His letter to the
dated,
district judge, exhibit P20,
letter
245.
dated.
Dated January, dated 21/11/2003.
2003, informing the judge as to the retirement of his attorney. Okay. Allen time game ಕೇಳಿದ್ರೆ, did he ask for time? My attorney has retired, therefore give time to appoint another attorney, something like that.
No time.
No time.
In fact, he has.
Why
written
his attorney retired? Just we want to know.
That he did not give the payment to the concerned attorney. So he wanted, and he was not cooperative. That is what he has filed an application before the district court at Illinois that he wanted to retire from the case.
Saying that payment was not being made.
Yes, because
That
he
was
was
the-
not cooperating with
That
him.
is also marked as exhibit.
Abhigo?
Is it marked as exhibit?
Not, it has been marked as exhibit before the trial court hearing.
Here, it was part of the record there.
Yes, yes. In fact, my lord,
Attorney, Prema, attorney had filed an application before Illinois court on
before that. Minimum 19.
7/11/23.
21/11/2003.
21/11/2003.
Yes.
On 21/11 to 7/11.
Defendant's attorney withdrew.
Wakalat,
on
that's
7/11.
right.
It's available page number 237.
Filed application on 21/11.
Abhigo?
He filed application for settlement of his claims.
Yes, he filed that application, dates, my lord, 7th November 2003. 242, page number 2. The dates are some corrections in the date, my lord.
21/11, all these are available here.
Right. I thought the dates are not correct.
Not correct.
240, your lordship, 242, page number 242, the booklet it has
The
been.
dates
correct.
which you have given are not correct.
Some, to some extent, it not corrected. 242, your lordship may kindly see,
No, no.
November 7,
PB.
2003.
You tell the correct date now.
Yes, my lord, I'm looking at the papers.
Which is
and
that?
7th November 2003.
7/11/2003. PB. PB means paper book
Paper book 242.
242. In which he mentions about non-payment of fees by the defendant. Okay. So he was permitted to retire.
Yes, that is at exhibit P19 at page number 244.
He was permitted to retire. Wide order dated
19/11/2003.
19/11/2003.
Hearing held on motion to withdraw as defendant counsel.
Okay.
Motion of so and so, so and so. And the notice was ordered onto him.
First off, notice was issued by Illinois court to the defendant on
19/11/2003.
19/11/2003. Paper book,
Paper
that is
book-
wide exhibit.
Yes, my lord, exhibit 240, page number 244, exhibit P19.
P19, PB 244. Okay. Then what he did, defendant did.
Lord, in fact, my lord, he wrote a letter to his attorney, that is exhibit P20. I'm sorry with the date. That is 21/11/2003. After receiving the
Defendant
summons.
letter to the attorney,
Yes, he wrote it, and a copy marked to the district judge.
judge.
That is exhibit P20 at page number 240.
So he did not address the judge directly. He marked a copy of his letter to the judge. ಅಲ್ಲಿ ನೋಡಮ್ಮ, ಆ ರೀತಿ change ಮಾಡ್ತಾರೆ.
I'm sorry with
ಅಲ್ಲ.
exhibit P20 dated 21/11/2003.
Mr. Joyce, which case you are waiting for? Rangnath Joyce.
Serial number 22.
22, may not, afternoon we'll take that, if at all it is possible. ಅವ್ರಿಗೂ ಹೇಳ್ಬಿಡಿ, ಫೋನ್ ಮಾಡಿ, ಅವರೆಲ್ಲ ಆಫ್ ಮಾಡ್ಕೊಂಡು ಕುತ್ಕೊಂಡ್ಬಿಟ್ಟಾರೆ.
My lord, 22, my lord, learned friend telephoned to me and said he wanted time, Friday or something, my lord. I was, that's why I could not go through the papers, my lord. Otherwise I would.
ಅವ್ರಿಗೇನೋ ಓದ್ಲಿಕ್ಕೆ ಟೈಮ್.
ನಂಗೆ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು ಇವತ್ತು ನಾಳೆ ಮಾಡಲ್ಲ ಅಂತ ಅದು.
ಅಲ್ಲ, ನಾನೇನ್ ಮಾಡಿಲ್ಲ ಅವ್ರಿಗೆ.
Okay.
If he wants time, I have no
No objection. And the other one date ಕೊಡಿ. take with third week of December. Third week ಅಷ್ಟು ಬರೀ ಸಾಕು. We don't know. Third week, okay.
Lord, thereafter, Lord, notice was issued onto him.
Thereafter, he did not come to the witness box at all?
No, he did not come. In fact,
Did he
has
cross-examine you? He had cross-examined you.
here, my lord, here we have cross-examined,
But
not
there
there.
you did not.
He did not appear.
He did not appear.
In fact, my lord, he admits in his cross-examination here that after 21/11/2003, he had gone to United States, but did not make any steps to defend this case. That he has admitted. Page number 77 of the booklet. His
77.
cross-examination.
77. It may be true to suggest that after 21/11/2003, I must have visited USA.
Para 2.
I have not contacted any other lawyer to conduct my case in USA after I received intimation from earlier lawyer. See, so and so. But get him. All right.
Lordship may also take page number 68 of his cross-examination. 68. Because this will answer 13F.
Para,
68, top portion, second line from the top.
no agreement was executed by me in favor of the plaintiff. Plaintiff ordered textile goods from the second defendant and wire transferred so and so, and paid the defendant number 2 by cash. Cashier's check dated so and so, another sum of rupees for the textile goods from the defendants. Payment is admitted by him.
Yes, my lord, he has received the payment. There is no document to show this payment has been returned because his contention is that I was only a dealer who places orders on which he delivers it to me. That was his contention and defense. In United States, he takes a stand.
All check payments.
Yes. The documents which he sought to be relying upon on.
Para 4 deals with the invoices.
Huh?
Para 4, thereafter, in continuation of that evidence. Where my lord pointed
The
out
state
that
has
this
mentioned
delay
about the defendant firm shipped
was
the
for
textile
invoices
assignment.
that we have raised for the items
Yeah, yeah.
supplied.
It was raised and it is objected at page number 75, cross-examination. It was not authenticated.
What is corresponding answer?
Page number 75 is cross-examination.
75.
Yes. I have produced. I have produced 4 invoices pertaining to the transaction. They are marked as exhibit so and so so and so. Plaintiff object to marking of these documents on the ground that they are neither admissible nor relevant. The documents marked are subject to objections of the counsel of the plaintiff. These.
To suggest. Ah. All right.
But, after he was absent, after he did not make any on 3/12/2003, Lord, magistrate recommended for a judgment, entering of a judgment. I'm sorry.
The evidentiary value of the policy. Not B. B, 13B, my lord. Your fees. Look, the issue that has been raised, issue says whether it falls within, well, on page 32, as we have seen, the additional issue that was framed. Whether the defendants prove that foreign judgment on which plaintiff is relying is not conclusive as it comes in any one of A to F. Anyone, should be any one of the exceptions, A to F of section 13.
Whatever case.
As contended in this written statement.
Yes.
But I'll take my lord's. But my learned friend's submission. It is more so far on 13G, my lord. It appears that my learned friend is arguing on.
No, you have to
No.
dislodge whatever he may say now.
Just say-
There is a foreign judgment.
Because his.
You should disclose the factors that would rob away evidentiary value of the said judgment.
Yes,
That
sir.
is the law.
I'll do that. Because the tenor of his argument.
Argument may not be, that's true. We have,
Is
we have seen that
the
anyway.
ground G, 13G, it says, where the proceeding in which the judgment was obtained was not in conformity with the procedure law applicable in the said court, my lord. But I
No,
was still-
make out your
I'm
case.
still looking for.
Leave all that.
No, my lord.
Leave all that.
I'm still looking for 13G, my lord.
No, and that's not there. But to make, now there is a.
Now, coming to 13B,
B.
my lord, I will take my lord through page 262.
Come.
That is the judgment.
262,
Judgment of the
court below,
court, not the court.
of the Illinois court.
I'll take my laws to, because I am now to dislodge 13 first.
Correct.
And get myself the exception of 13.
Correct.
Benefit of that.
Yes.
262, my lord.
Yes,
262.
not 262. It is at 264. It begins.
Fine.
Yes. 265, actually, from there we can
Okay.
begin.
This matter coming before the court on plaintiff's motion for entry of final judgment by default against defendants as the sanction for their failure to appear and cooperate. So
Yes.
it is coming up. There are three sentences here, three phrases here rather. The court on plaintiff's motion for entry, we will go back to that motion for entry for a moment if necessary, of final judgment by default against defendants as a sanction. So one statement is, it is judgment by default. The second statement is as a sanction for their failure to appear and cooperate in discovery and for prove up instanter.
What is meant by, that is motion.
Motion. Due notice having been given, the court having reviewed the motion and
Finding it sufficient to support entry of judgment.
Entry of judgment, and the court finding that there is jurisdiction over the parties and the subject matter herein. Now, my lord. Then, let us see. It is hereby ordered and adjudged as follows. We'll complete it. It's hardly 2 pages to see whether we find a semblance of merit in that of 13B. Judgment is entered because what is written here is why I said we will go back to reading what is the motion of, what is even the motion. Even the motion is not appropriate. That also I will point out. Finding.
But that ground is not available to you. Your
leave that.
ground of defense is
I don't need it.
13.
I'll again.
You will give up that.
I will fall within the straitjacket that my lord will place. Judgment is entered in favor of plaintiff, associated textile so-and-so, and against defendants so-and-so, jointly and severally on count of 2. In the total amount of rupees 2 million so-and-so, as follows. Compensatory damages of 1,134,000 so-and-so, plus costs, plus judgment interest at the statutory rate, plus punitive damages of an additional 1 million. Then, para 2. Further, defendants so-and-so are enjoined in order to provide plaintiff so-and-so a full and complete accounting of all revenue, profits and proceeds from defendant KP export sale of textiles to the US and Canada from so-and-so. This particular sentence would also mean that textiles were indeed sold to them and supplied to them for the monies paid. As a passing remark, since my learned friend raised that issue, that monies were paid. Nobody is denying monies were paid. What were they paid for and what was done with it? We said invoices were paid. Further, a constructive trust is hereby imposed for the benefit of plaintiff associated textiles upon 1/3 of the profits shown by an accounting to have been wrongfully appropriated and retained by defendant so-and-so. The proceeds therefore, and the interest and or other return which the defendants earned or could have reasonably earned thereon. Further, judgment is entered in favor of the plaintiff associated textile incorporated and so-and-so. On all counts of judgments counterclaim, defendants counterclaim, defendant shall take nothing and are entitled to payment, credit or set off from plaintiff. Pursuant to Federal Civil 54B, the court finding that there is no just reason to delay entering final judgment on the claims enumerated above, the court directs that this be entered as a final judgment upon the docket. Therefore, a reading of this does not beget even a semblance of a statement that they have even dealt with the pleadings, they have dealt with any evidence, they have dealt with any document.
But that is not the ground recognized under 13.
13 says,
13B
13B says, 13B deals with where it has not been given on the merits of the case.
Where it is not given on?
Where it has not been given on the merits of the case.
It is given on merits of the case because he had, pleadings were complete.
Yes.
Issues were not framed, but that's the procedure there. And he had entered witness box. Discovery was ordered. You did not avail the opportunity. Therefore, merits means not in that sense.
That will be the finding that my lords will have to give. Merits,
According to you.
Merits means what?
Now.
Discussing evidence, everything.
yes, that is,
Did the claim, what
that
is
is
the-
exactly what we have urged before the trial court, and that is exactly what we are repeating
Court agreed with your view.
before this court also.
Yeah.
Because if that were to be so, then 13G would have come into play. That whether the procedure as applicable there was complied with, if it is complied with, then it is a valid law. Then it is a valid judgment.
What was the procedure
Then,
there?
no,
Uh,
that,
That will not travel to that point at all.
that is why I'm arguing to show
So-
that if that was envisaged, there would have been 13G. That would have said that if they have, whether they have followed the procedure there, that is not our business.
All right.
We are
According to
least
you-
bothered about them.
Understood. According to you,
We
what is
only-
meant by merits of the matter?
Merits of the matter, as has been understood by the courts in this country, my lord.
Yes.
I will point out that I'll pass on this compilation for my lord. While some of them are already there. I have actually extracted some of the other judgments also in my,
Ah,
the
but-
rather detailed written arguments.
Yes.
This is elaborate because apart from the points, I have extracted the whole relevant portion of the judgment there in that particular place. Otherwise, it would have been 3-4 pages. But it extracts the entire.
First, Black's Law Dictionary you have mentioned, which which clause applies to you?
13B.
13B. No, Black's Dictionary, which you are referred to. You have produced a copy now?
Yes.
Which we should read. There are many expressions, many terms, words. Default judgment.
Yes, my lord.
Default judgment.
Default judgment.
Page 2.
Page 2.
Default and default judgment. We can look into now.
Yes, ma'am. That is coming up at page 3, my lord. So the extract is of what we read already at page 2. And thereafter what Black's Law Dictionary says. Given you that. Lord, it says both. It deals with both default judgment and also defines merits, judgment on, both of which are extracted here. Under rules of civil procedure, when a party against whom a judgment for affirmative relief is sought has failed to plead, answer.
So page 2 is relevant, 3 is not
Page 3,
of your compilation.
3.
Relevant.
My lord is the.
This one, Mr. Hetty. This. Merits, page 3.
I'll just pass on a copy to my brother.
You want copy?
No, copy to my brother.
Page 3, judgment on merits. That is merits, comma, judgment on. Page 3, come to your page 3. That may help you.
Yes. But I have extracted that in the
You were compiling in the
in
written
the written
argument.
argument. So we could just go on with that.
That will- Yes.
So then it spills over. Default judgment is there at page 3 of the written argument.
You are right.
The extract. And then it spills over to merits and judgment on, exactly copied from there.
You are right. Merits judgment sum, understood.
The
So to
purpose of
say
doing
all that it's a judgment on merits, all these things should happen,
one rendered after argument and investigation
etc. Okay,
is determine which party is in the right, as distinguished from a judgment rendered upon some preliminary or formal or merely technical point, or by default and without trial.
okay.
A decision that was rendered on the basis of evidence introduced. Normally, a judgment based solely on some procedural error.
Whether, was there any, what was the corresponding provision under 1908 CPC, unamended CPC? This we are asking to know what was the debate on framing
13.
13.
For that, I, in fact, in Vishwanath, Hidayatullah's judgment on that.
What was the corresponding provision under Old Act,
I think it was-
pre-1976 amendment?
It was 14.
It was, section was there.
It says.
Ah.
the
You
law
are
is-
reading from your argument.
No,
Ah.
no, now,
Now you got it. Okay.
yeah,
Good. Okay. AR 1963 SC.
I'm reading from 1960s.
So my brother is very, very efficient in this computer, though I don't touch computer at all.
SCC online,
AR 63 Supreme Court page 1, para 163,
Para, no, para 130.
113. 63 Supreme Court page 1. Is it a 4-judge bench decision?
It is a 3-judge. It's
Huh? 2 judges,
Justice Das, Justice Hidayatullah, and J.C. Shah.
3 judges. All stalwarts. At least 2 are
At
stalwarts.
least though, that period between 60s, we've got a plethora of judgments on every point under civil law. Yes, yes. Yes. R. Vishwanathan and Gajambal Ahmad.
63 SC. What was how was the provision?
Provision, I'll-
Just as post that provision
I'll just read.
with this provision.
Yes. In fact, that is the reason anticipating, which is impossible to do in this court.
No, no.
But,
Nothing like-
but we did burn a little bit of oil. But the question whether these findings, the question, I'll just read a little bit, then by the time they will.
Very.
The question whether these findings or has been conclusive in the subsequent litigation in Madras has been raised in connection with so and so, by who claim the benefit of the same under section 13 of the Code of Civil Procedure. Though the question is mainly one of interpretation of section 13, the
Ale,
arguments-
can you put on your mic? So that
the argument-
there are many.
The arguments were reinforced by reference to books on private international law and cases decided by English courts. The law as contained in section 13 has been the result of an evolution. Exact words of my lord.
That's the reason I said like that. In fact, that's how Oliver Wendell Holmes in his famous book, Common Law, says, we should never see the text of the law at all. For the first time you should see, then go to its etymology, how it took
How
birth,
it took place.
how the growth happened. In fact, the other book of Cardozo, The Growth of the Law, is also like that. It's a very beautiful books there. Yes.
The law as contained in section 13 has been the result of evolution. In the Code of Civil Procedure 1877, the subject of foreign judgments was a part of the law of res judicata. It was enacted in section 14 at that point of time. No foreign judgment shall operate as a bar.
1878 CPC.
Yes. No foreign judgment shall operate as a bar to a suit in
As a
British,
res
in
judicata.
British India.
British. Correct.
A, if it has not been given on the merits of the case.
So we have borrowed it from this only.
So we have borrowed.
This part remains intact.
This part remains intact, and this part was the most important point which came to mind first. So the draftsman then put that there, that there can be no other thing more sacrosanct than merits of the case. Because if merits is there, it can withstand any scrutiny. B, if it appears on the face of the proceedings to be founded on an incorrect view of international law or of any law in force in British India. If it is in the opinion of the court before which it is produced contrary to natural justice. Now, why I also repeated British India twice, it virtually meant that in my own domain,
It was so.
I wanted it to be on merits. We were the, if it is the opinion of the court before which it is produced contrary to natural justice. If it has been obtained by fraud, if it sustains a claim founded on a breach of any law in force in British India. So it broadly covers most of the point. We have dissected it later and fine-tuned it further because with experience, they would have found several other facets will come. And with the growth of law and growth of international committee, a lot more changes will come. But committee or otherwise, the sanctity of an order has to be there because Committee of Nations can be maintained by salutary relationships between the heads of state and between the treaties that are entered into. And therefore, for that purpose, we have 44A. Enter into that treaty. Then what you do in your place, we are very happy with the way you conduct your affairs in your country.
In other words, if under 40.
That we are giving you reciprocal arrangement.
This kind of judgment was granted, it would have been.
It would have, because we would say that whatever you do is sacrosanct.
From 1878 to 1908 to 1976, text of the law remains substantially same. Therefore, idea also remains the same. If it were to be 44A, then even this judgment would have bound you.
Yes.
But if it is under 13,
yes,
then it should be on merits. Is your version. You are a very tough guy, I tell you. We have always faced a difficulty with you.
No, it is my privilege because day in and day out we do that. The only thing we can, without risk of attributing anything else, as we have known my lords through the bar years and now, it's the same erudition and the same. I have only one copy for this reason, that this was a last minute study because I felt that there will be something coming, one googly will come. And that is why I'm unable to give my learned friend a copy despite his asking me twice.
No,
because I had only for my study.
You are very,
and I had marked it and kept it only for myself.
You are very gracious and lavish also. Anyway, he's my friend last 3 decades, very closely known to my family, my mother.
And while arguing before the courts, we do not shy of saying that because one is doing one's job, duties rather.
So your trump card argument is it is not a judgment on merits. Therefore, that assumes importance because of text of section 13, which remains throughout even during colonial days, 1878 to 1908 to 1976. It cannot be without any significance, is your version. If it were to be under 44A, even judgment by default would have answered and it would have operated as res judicata. In fact, 44A is more on res judicata. This is on evidence. Res judicata is not evidentiary rule of evidence. Res judicata in our Vedic literature, it is treated Purva Nirnaya Siddhanta. In Gautama Sutra, it is treated. Res judicata was treated
Purva
long.
Nirnaya, past decision is a principle, or
That's it.
that's the
Purva means earlier.
earlier.
Nirnaya means a decision. Siddhanta means proposition. That way.
In fact, when was, we would see, when was
That maybe about 2000 years ago, much before Latin people found it. They were there here.
there is no monopoly on that, and
Of course, no
and-
monopoly on wisdom.
and law is what, as we have seen, it's a composition of practices and customs which were going on, which got codified
Correct.
to whatever extent and whenever. But even this 44A came in much later. 44A also
44A came perhaps in
In,
1908 it was there.
it was not 1937 it came.
37 it was there. Correct. Even under even before 1937, there were some judgments that led to enacting 44 law. There were judgments because the international law started developing more particularly after the First World War, 1914 to 1999, 1914 to 1919. In that, during that period and post that period, lot of international law
Because that is where for the first time, a League of Nations came into being.
came into it. That's the
So
reason.
that became the first forum of international.
That way. And after, more particularly after people started flying, in fact, contribution of lot of international law should be attributed to Wright brothers. Otherwise, so much.
Otherwise, we would not be able to.
You would have traveled in ships. They would have taken 3 months, 4 months that way. And growth of law also would have been as slow as the sailing of a ship. So, how other countries, courts in other countries treat our judgments, especially that country, Illinois, how it treats our judgments? Where is that not treatment? Reciprocity is of two kinds, maybe several kinds also. At least two kinds of reciprocity come to my mind because of J.G. Stark on international law, Cheshire and private international law. It's a very famous book, Cheshire, one of the very great authors on private international law. Because you read that, no? Private international.
It is there. In fact,
Ah,
all the great
judgment.
names are mentioned in the subsequent paras.
In that judgment.
In that
itself.
judgment. It's Hidayatullah there, my lord. Therefore,
Great.
he would have gone into
all these things. One of the greatest judges of this country, Justice Hidayatullah. Is a classic judgment on re-Beruberi Union. Many judgments he has given.
the
And
Beruberi
one judgment was
corridor
affirmed
in
by
Ba-
American Supreme Court, Douglas. Judge Douglas of US Supreme Court referred to, he paid respects to Hidayatullah in one American judge.
Beruberi corridor between Bangladesh and
That
India.
was
That is
earlier
the
one. But before that, Douglas said, he referred to Justice Hidayatullah, which we refer to in our hijab judgment. We said, the great judge of this court said like this in the great judge. Antavella odalla. People do not read such things. They think that it's a wastage of time. Anyway, perceptions vary, approaches also vary.
My lord, wastage of time before the courts.
You continue to be witty and humorous all through. I have seen you at the bar, best friend and bad opponent. That's what you have earned now. Yes. So, Mr. Kheti, Barkali, Chetan Barkal. Mr. Kheti, in his inimitable style, submits that judgment on merits is the idea that obtained right from the first CPC of 1878 and continued in 1908 CPC and continues in 1976 CPC. And this cannot be without significance. Semicolon. He adds that judgment on merits idea should be understood as the jurists have understood throughout. And in support of that, he banks upon Adeno Ramnath Ayyarda, who's that Lexet you have that you have
Vishwanath.
No, not that judgment. You have given the Black Dictionary.
Black Dictionary.
He refers to Black Dictionary. At pages 1 and 2 of his compilation, which he has culled out in his written submissions. First off, he banks upon decision of the Apex Court, pre-judgment decision of Apex Court, AR 1963, Supreme Court, page 1, paragraph 113.
130.
113. You said that?
130.
130.
130.
130.
In addition, there are several paragraphs. If one not permits, we can read.
And other paragraphs?
Other paragraphs.
All right, but read other paragraphs also.
I can focus on that. It's worth reading, but
That's
I will specify the paragraphs that I'm relying on. Other than 130, which deals with this point as my lord raised, but other.
It is different in AIR, different in ACC.
I
Yes,
know,
yes,
I
of
know
course.
that. Unfortunately, I think I am reading SCC.
SCC.
SCC online, because I thought that they will not have SCC
How
online.
it begins, tell that. How it begins. They are paraphrasing our judgment. We put paragraph with a particular idea.
How can they?
They are doing that also. It's a big problem.
They change the paragraphs.
They may change our judgments also. We do not know. One day. Because how paragraph should be made.
The law is contained in section 30. Is that how it begins?
Para 130, in dealing with the case, the full bench gave the following findings. Vaidyalinga Ulliyar, who was away.
Ali SCC and Barkumada. Give SCC only.
SCC citation is
1963 SCC.
Para 132.
It's 1962.
As contained in section 13 has been result of evolution. That's what you are reading, no?
Yeah.
That is 131. 131. All right, anyway, we'll write down page itself. Write down that page number.
132.
You read that.
My one is the law as contained in section 13 has been the result of an evolution. 132.
Okay. He adds that the judgment and decree now put in challenge before the court are founded on the principle that the judgment of the foreign court is not on merits, but was rendered by default procedure. Okay. First, he also adds that if the plaintiff had invoked section 44 capital A, comma, arguably, the judgment by default would also operate as a res judicata, unlike in this case. Or you don't agree with that also? if it were to be 44A, 44A makes it res judicata to the foreign
To the
judgment.
foreign.
That's all. All right.
So what was earlier
Ah,
res judicata more in its wording, the earlier incarnation of 13 was later a res judicata component came in by way of 44A in 37,
in 1937.
1937.
You are right.
In fact, they say here in para 148, it says,
They themselves have said that.
no,
You
there's
read that?
another part to it. It is inconceivable that a foreign judgment in rem of the class mentioned in section 41 of the Indian Evidence Act was intended.
No, that is different.
That's a different point, but
Different point.
it's just they've developed it from different
Yeah,
dimensions.
What happens is, rem judgments were rendered in English courts only in 4 jurisdictions:
That is
probate, insolvency,
Admiralty.
matrimonial, and admiralty. Now, we have added one judgment where constitutional declaration of validity of statutes, etc. That way. But this is not judgment in rem.
So what they
question
say-
is, no, one more aspect, final aspect is there. Res judicata, judgment in rem is a res judicata only as against the non-parties. Res judicata, our idea is as against parties.
So what they say in the subsequent line, what I was reading, the existence, so I'll just read that. They say, it is inconceivable that a foreign judgment was intended to operate as conclusive, even though it was not, it was opposed to the principle of natural justice, or though it was not given on the merits of the case, or if it was founded on an incorrect view of the international law of the law of India, or was in breach of the law in force. The existence of such prior conditions in section 13 of the code and their absence in the Evidence Act compel one to hold that both judgments in rem and judgments in personam are contemplated by section 13 of.
That is what I was telling.
That's, so I'm, either he said it earlier or my lord said it.
That's what I wanted to say.
Yes, yes. So,
They have discussed all.
so it widens it and says in both spheres,
It applies.
it applies.
Provided conditions are complied.
Conditions, asterisk conditions apply.
Yes. What other points? Do you have any other points?
Not, that's the sole point on which we are
That's-
going. There
you
can
are
be
right.
any other point.
You are right.
And as far as my learned friend's Alcon judgment is concerned, my lord, I'll distinguish it by taking my laws through it once again. Because one eye sees it, the other eye also sees it, but differently. My lord may kindly take same paras as pointed out that para 15, my lord. I'll point out how that is different from international woolen case. International woolen, I have extracted the para 32 and 33, which this portion, which I will read of 4 paragraphs, also extracts that and swears by that. But at the same time, there are some points there which a glance on the enforcement of the foreign judgment. The position at common law is very clear that a foreign judgment which has become final and conclusive between the parties is not impeachable either on facts or law, except on limited grounds enunciated under section 13 CPC. In construing section 13 CPC, we have to look at the plain meaning of the words and expressions used therein and need not look at any other factors. Further, under section 14, there is a presumption that the foreign court has passed the order. This is not, this is just the,
But competence.
then 16. The appellant's content, here is the distinguishing feature of this judgment, where it does not sway from merits. That's what I'm trying to point out. The appellants contend that the order of the English court is not given on merits and that it falls under 13C CPC, as a result of which it is not conclusive and therefore unexecutable. We cannot accept such submission. A judgment can be considered as a judgment passed on merits when the court deciding the case gives opportunity to the parties to the case to put forth their case, and after considering the rival submissions gives its decisions in the form of an order or judgment. They also repeat this. We say we cannot accept your submission, whatever it might have been, my lord. Let us forget about that. But in reiteration, they say it must consider this. It cannot be said to be not on merits, provided
It is, the points are considered and rendered.
and rendered. So they have already, they themselves have clarified that. So to say that it is not, doesn't hold water. Then it is certainly an order on merits of the case in the context of the interpretation of section 13C. Applying the same analogy to the facts of the case on hand, we have no hesitation to hold that the order passed by the English court is an order on merits. The appellant who has submitted itself to the jurisdiction of the court and on its own, in the instant case, requested the court to assess the costs summarily. So if I come and tell this court that please assess my costs summarily, I cannot then turn around and say, because that is part of my merits. I made a submission, rival submissions. This is one submission. I made a submission. I said, please do it summarily. Thou hast done it summarily. Therefore,
So it is more like judgment on admission,
yes,
because you said you show concession in costs. But rest of the things tacitly you said it can be there.
yes. So these are some of the distinguishing features of this.
Paragraph is
Para 17, para 16 and 17 are the six.
para 16 and 17. Katie banks upon in which is that judgment
Alcon Electronics cited by the appellant.
appellant, no?
Yes.
Like 2001 judgment it is.
It is no, it is 2017 judgment. 2001 is the international
Yes,
Woolen judgment.
In no, just work out. 2017 2 ACC 253, which is heavily banked upon by the Cabinet Council appearing for the appellant. Okay.
Then it further goes on to say there's acceptance there, further acceptance. While passing a reasoned order by dismissing the application filed by the, so they again admit there is a reasoned component to the main order. The issue was with regard to the cost part of it. While passing a reasoned order by dismissing the application filed by the appellant, English court granted the costs against the appellant. Had it been the case where appellants, so it's one component. It's
Your
one,
application seeking dismissal of the suit is rejected.
yes.
It makes no difference.
That's
at all.
like a 911 application. It is akin to a 911 application. How does it solve? If that was, if that, yeah, and it was my application. His suit
Seven-
remained. My application to summarily reject it. That is rejected.
But suit remains as.
Suit
it is.
remains as it is.
But that is not tried on merits and.
That is not
therefore
tried on
is-
merits. That process has to be done. We can't say 911 is rejected, suit is decreed.
711. Why are you saying 911? 711.
711.
711. No, I was under impression some other you are referring to.
No, no, no.
Parkadi. To our question, whether the rejection of his client's application for dismissal of the suit at the hands of Illinois court would have relevance in adjudging as to whether the suit is decided on merits, comma, Mr. Keti submits that the consequence of rejection of the application is that suit as it is would continue. And therefore, it would not touch merits of the case at all. First, okay.
Then the last part of it, had it been the case where appellant's application allowed and costs were awarded to it, it would have been well, it would have as well filed a petition for the execution of the order. Be that as it is, the appellant did not prefer any appeal and indeed sought time to pay costs. So again, there is further burden there. The appellant, I'll just complete that one
I
more
have it.
para,
We
which
have-
deals with, so I don't need to go through other judgments because they've extracted international woolen here. The appellant therefore cannot be permitted to object the execution. It cannot be permitted to blow hot and cold at the same time. In our opinion, it is a pure abuse of process of law and the courts would be cautious in entertaining the. Then, in international woolens, this court observed thus, these are two paragraphs which are there in 29. Even when the defendant chooses to remain ex parte and to keep out, not just ex parte. Ex parte itself means, but they have still used the word and. So I kept out. It is possible for the plaintiff to adduce evidence in support of his claim.
Is kept out is.
No,
Ex
I-
parte,
I
I'll
know,
tell you. Kept out means where pleadings are struck off ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ. We have provision. In American law also, there are such provisions in several states. Where we, just if we say you are placed ex parte, you cannot participate in evidentiary matter. In trial, that's all. But where your defense is struck off, in Indian law,
And you are kept out of.
straightway, suit has to be
Decreed.
That way it is.
It is possible for the plaintiff to adduce evidence in support of his claim And such evidence is generally insisted on by the courts in India, so that the courts may give a decision on the merits of his case after a due consideration of such evidence instead of dispensing with such consideration and giving a decree merely on account of the default of the appearance of the
All right, one more thing now.
in the form.
Assuming that 13 is not applicable, then on that ground, you cannot reject the suit if other evidence avails on record
Yes,
supporting his case.
yes, that is correct. What my lord has said is correct. There is no material available on record for this reason. I'll point out that also. I'll just complete this so that I would have done my, the principal one.
Well.
In the former case, the judgment will be one on the merits of the case, while in the latter, the judgment will be one not on the merits of the case. Thus, it is obvious that the non-appearance of the defendant will not by itself determine the nature of the.
Say.
Then, my lord may kindly take the plaint.
Can we come at 2:30? We have other matter now. 371J. Yes, you could tell within few minutes.
Few minutes, just that. My lord, plaint may be seen, page 4, para 2.
Page 4, para 2.
Para 2.
You read the last 4-5 lines in that, no?
Yes.
Yes.
So now I'm coming to the Roman 3, where they say this is a suit on the foreign judgment dated so and so on counts 1, 3, and 4 in complaint number so and so. This is what they say. This is a suit on that. So they're restricting themselves by their own conduct and by their own pleadings and wishing to sink or sail on this statement. Then again, they come a lot. They go further and say in on page 12. On page 12, they say the motion was not merely based on the so and so. Para 13, the court-wide order dated so and so, the fact of withdrawal. Well, it is here. Since the defendant, the motion was not merely based, this is why they say like this. Since the defendants failed to appear and cooperate in the discovery, the plaintiff took out a motion for entry of final judgment by default. The motion was not merely based on the defendant's default, but also relied upon the evidence affidavit of the plaintiff.
That's not.
That phrase is not there in the,
That's not.
when we read it. That's why I pointed out that it's not there.
It's available at
Huh?
exhibit. It's available as exhibit P
Exhibit, but
21.
not in 265.
Ah,
Not on page 265 where the order is.
Illinois court.
While passing the
Illinois
order.
court is a judgment by default.
There they have filed an affidavit that is enclosed at exhibit 21 and 256 page number. The affidavit which was filed.
Filed all right.
Yeah,
But
it was
not
filed.
re- Not referred to in the judgment.
That has been answered again. But some judgments, because your lordship knows the way in which, because that is a common law country which a complaint has been registered. A complaint has been set in motion before the concerned district
Whether
court.
America is also treated as common law country?
Not really.
Not common.
But here we follow CPC as a civil suit. Because common law, my lord, for all and everything, they file only a complaint.
Your motion, that time your affidavit that for the motion of by default judgment, that didn't contain the merits also.
Because your motion was for default judgment.
On the basis of the motion, this judgment is passed. That's what. the
Motion
order
and affidavit, because he did not appear. He
No,
has,
that's not it.
not appear.
He did not appear is very well. We can't say that it's a judgment on admission also. Order 1206 or 1206, 612. 12:6. It is not even equivalent to a judgment on admission.
and in fact, my lord, this plea was on two grounds before the district court at Illinois. When he wanted to file an application to strike off my complaint, he had taken a stand that it was barred by limitation under the Fraud Act therein.
No, that is equivalent to
It
711.
was negative. It was,
Our equivalent of 711.
yes. Order 7, Rule 11.
11, okay?
There was no appeal against that.
That's all right. After 711 is rejected,
Thereafter, he
suit
filed.
remains as it is. No,
Yes,
we are
the
only.
complaint remains as it is.
That's how he argued.
Yes.
We are only putting it to you.
Yes.
So that you can say something on that.
The complaint remains as it is. And he files his answers also.
In their
And
argument,
subsequently, because his conduct shows that he was aware, even on 1911-2003, he knew, my lord, his attorney has retired. He has gone to the United States. That is his own evidence.
We are-
my lord, what is that part of the case which,
Because-
my lord, this is extraneous again, we are going back to the 13. My lord, please take page 88 of the paper book. This is very important. This
88.
answers directly what my lord says. The present issue, this is in support of their arguments for the application to change the issue. It was done, the additional issue was framed at their behest. This is what they say.
It would not,
present
it would
issue-
reopen the
present-
trial in the foreign.
The present issue as framed by this honorable court, if allowed to remain, would entail reopening of the trial by the foreign court.
Okay.
All that the plaintiff is required to prove is that the judgment of the foreign court is conclusive. So he has put all his eggs in the basket of saying, I am only required to prove that this is it. Plaintiff is not required to prove the suit transaction, and the relief in the suit is consequential to recognition. which is
Recognition of that judgment of the foreign court is conclusive.
conclusive.
No,
So
he,
does-
he need not prove that it is conclusive.
No, what he's saying is, what he's saying is,
You have to.
he
prove it
doesn't
is not
want, he
conclusive.
doesn't want to prove anything further.
That one, for additional.
Beyond this,
independent of-
so he's saying, I am strong on this point. It is conclusive. It is 13G. Therefore,
In other words, it was open to him to lead independent evidence.
yes,
And seek the decree on
Seek the
that
decree.
basis, regardless of what happens to.
What happens
section
to-
13.
that is enough, because he admits it is supposed to be a suit, but as I read in para 2, he says this is a suit founded on the
Foreign
decree,
judgment.
foreign decree. He doesn't want to travel beyond that.
Say that the present suit was solely on the basis of the.
Foreign judgment,
Foreign judgment.
because that's how he says in one paragraph.
I read that portion to the court.
But though the plaintiff could have filed that basing his claim on the foreign judgment as well as the.
Other
original
evidence.
transaction-
Other
Original
evidence.
transaction. between
Yes,
the
yes.
Parties.
That was on the merits. And this is on the foreign judgment. Now
Yes.
that is not pleaded, and therefore you say that it is only 13 which is applicable.
In fact,
Only if it passed within 13.
Because issue is framed that way.
he sought for the framing of that issue.
Also.
In fact, his pleadings in that affidavit, which I read just now, is to obviate the need for that. He said, I don't want that I should be required to prove those first 3 issues. He says that
Therefore, observation in page 88 is version.
is the version. He in fact wants that only. What has happened there, you jolly well accept that.
All right.
Then even if we see his affidavit, just to point out that what he has done, as my lords would recollect, his affidavit is as page 35.
Page 35 is his affidavit in this Indian court, Bangalore court.
In the Bangalore court. There, the documents that are referred to, that is why I pointed out those documents earlier. I will have to re-point out that again. Please see page 49, para 22.
Fine.
Board resolution pointing out authorization. Then from this point onwards, where is the cause of action in any of the documents or relatable to it? Certified copy of the complaint, certified copy of summons, certified copy of letter together with annexes sent by the plaintiff's attorney. So all these are post filing of the suit. Nothing to do with filing of the suit there. The issue arising before the suit, which forms the cause of action and the bundle of facts and the documents in support thereof, are totally absent in this. All the exhibits, each and every exhibit, I need not read it. Docket entry 6, motion 7, Our response to the motion, 8. Reply, 9. All these, each and every one of them. My lords may take my word for it that all the documents which have been filed are not there. And he confirms that in a particular para, in in page 58, I think in his cross, which is marked there. Here, which I read earlier, here I have not produced any facts evidencing any documents evidencing the fact, but the witness says I have produced those documents before US court, para 8 of his deposition at page 64. And then again, he has again said,
all right. Yes, you want to say anything?
In fact, my lord, far as my lord, all the points of 13A to F, Lord, it is for him to say, my lord, and suggest that it is non-conclusive. So far as my lord, I will also circulate another judgment of the Gujarat High Court.
No, his contention is,
Lord,
we are
this
only
is-
saying his contention. His argument, we are putting it to you.
Yes.
13 is invocable where judgment is obtained on merits as contradistinguished from the one obtained by default. That's his contention, number one. Number two, independent of the judgment also, it was open to you to lay other evidence on material, and you have not laid is his argument.
Yes. In fact, my lord, on 13, my lord, he has not taken any stand, my lord, to rebut the presumption or the non-conclusiveness of the judgment of
The
the
presumption arises. Why presumption? Even conclusive
Lord,
evidence.
section.
Presumption is
Yes, only with regard to jurisdiction.
competence,
Yes.
not jurisdiction, only competence. We'll not go to, we'll assume that 14 is available to you. 14 avails, provided 13 is 13, 14, 44, capital A, 45. These are all kinship provisions, cognate provisions of law. They deal with one particular subject in a particular way. You need not travel to 14 because to travel to 14, 13 is a must. What he says is, judgment of Illinois court is not on merits, notwithstanding that is a application which is approximated to 711, order 7 rule 11. Even if it is rejected, where it is rejected in this case, suit as such does not alter its nature. Suit remains as it is. Suit is not decided on merits, but it is decided by default judgment is a question. Number one. Number two, he says, you have structured and founded your suit on section 11 judgment, not any other evidence. And what all exhibits you have produced, they are subsequent to 2001 is in wholesale way. They are all subsequent to 2001. Therefore, they make no difference to the case at all.
Lord, the risk of repetition, section 13.
You need not repeat it all. As you
Section
rightly said,
13
it's a risk
operates
for
in my
everybody.
favor.
Huh?
Section 13 operates in my favor. I am bound to bring in before this honorable court, my lord, the instances on which, my lord, the judgment was passed by the foreign court. All the instances that he was summoned, he came, he filed his application, all those instances have been marked as exhibit 1 to 20.
But they do not constitute part of the judgment. They were part of the record is true.
But it is for him to say how it is non-conclusive. If he wants, my lord, conclusive means it is final. If my learned friend is trying to say that should be a reasonable judgment, what he is trying to say on merits is a reasoned judgment. The section doesn't warrant a reasoned judgment. That is the intention of the legislation. Legislation is carefully worded. If they intended a judgment on merits with a reasoned judgment, they could have worded it in such a manner.
Meant by judgment on merits.
Yes, merits means, my lord, that because if the parties have, if the adjudications on part of both the parties have been adjudicated finally, here's the case. I have pleaded before the foreign court that he has taken money from me and I have recovery, a suit has been filed against him.
Therefore, 13 operates is your,
Yes,
it comes to
yes.
your aid.
Yes.
Heard, will not pass this judgment immediately.
Just pass.
Will reflect on
Two
that.
judgments, my lord, because two judgments following Alcan Electronics. I'll circulate those two. Because.
Give them.
Purtacha.
Every argument, whether we took note or not, they are noted here. We'll make them. Every argument.
just pass
To you
on.
also we say this.
That's fine, brother.
In fact, my lord, your lordship.
We will not
no.
have anywhere else to go and say 13B.
Yes, give those judgments. also.
Gujarat and Bombay
one-
full bench.
That
Bombay full bench.
63
Where
I'm
again,
passing
my
on.
lord, reasonable judgment, all this.
Counsel
other
for
things.
the appellant
The other two.
banks upon Gujarat judgment and Bombay judgment.
And Bombay
What a
judgment.
copy.
I'll just give it. And with regard to
Yes.
my lord, section.
Judges should read that. We'll read that. This is only
But
in order to our.
And also citing
Okay.
another judgment regarding conclusiveness of a judgment, conclusiveness of a
Give
provision.
that judgment also.
That is
We'll read
2001.
everything. We have
I'll give
lot of
everything, my
time.
lord, because I've incorporated everything in my
That in that written
my-
submission. Okay.
compilation.
Okay.
Because I have taken all A to F. Because
Correct.
E, my lord, he tries to say that there is, because he has not pleaded regarding E.
Okay.
Lord, that particular Gujarat judgment, I will only say that I have forsaken Gujarat in several ways, more ways than one. So this
That is-
is
Lord,
also a stray one.
I have
Gujarat
nothing.
only.
This is also a stray one. I'll just,
Beauty is,
Lord,
you are from Chennai, Madras,
Madras,
Madurai.
Madurai.
He is from Gujarat.
So we are meeting at Karnataka.
And, my ancestors from Jammu Kashmir. His ancestors, maybe they are from Ahit Chhatra. Haveks have come from Ahit Chhatra.
Because I was fortunate, my lord, here. I had my law here.
Let us see. And we are referring to American court. Incidentally to Indian court also.
I'll circulate all those judgments which I have.
So much. Thank you.
Much
Serial-
obliged.
Serial number 30, my lords, it has already become infructuous, sir. Therefore,
3-0.
3-0, my lords, sir.
But ಯಾರ್ದರ case inspectors but you the number in hand.
30, my lords, it pertains, there is a senior engagement in this matter. I believe.
We are respondents there, Lord.
They are saying infectious
No,
ಆಗಿದೆ
no.
ಅನ್ಕೊಂಡು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
No, we are respondents. I'm appearing for him.
Ah.
Lord, what happened, Lord? Recruitment rule was, Lord, without.
Has it become infectious?
It has become infructuous.
ಬರ್ಕಳಿ.
Now respondents, sir, but they didn't.
Respondents are.
Now respondents. ಹಂಗಾಗಿ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಅವ್ರು ಬರ್ಬೇಕು.
My lord, I'm only requesting your lordship, may posted for orders, will produce the lord rule, finalizing rule, that's all.
ಅವಾಗ
Nothing
ಕಳ್ಸಿ ಮಾಡಿ, ಇರಲಿ ಇರಲಿ ಏನು.
ಅಷ್ಟೇ.
A date may be
Now,
fixed
my
for-
lord may call for orders, my lord, so that we'll produce the rule, final rule.
No, ಅವ್ರು ಬರ್ಲಿ.
My lords, sir,
Next week.
Interim order may be.
maybe
Interim order to continue. Okay. All right.
First week of January. Okay, thank you, sir.
The 230 matter.
ಹೌದಾ? ಅದನ್ನಾರು ಹೇಳೋಗ್ಲಿಲ್ಲ.
Sir. 34. 34. 34. 34. Serial number 26, Madhyana. 26.
ಇದು ಮೂರನೇದು ನಾನು ಅಲ್ಲಿ ಆ ಕೋರ್ಟ್ ಹತ್ರ ಕಾಯ್ಕೊಂಡಿದ್ದೆ ಸರ್ 40%. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆ ಕೋರ್ಟ್ ಎರಡಲ್ಲಿ ಇದ್ದೀನಿ ನಾನು ನಿಂತ್ಕೊಂಡು ಅಲ್ಲಿ. ಡೇಟ್ ಹೋಗಿದ್ಯಾ? ಸರಿ 13ನೇ ತಾರೀಕ ಸರ? ఏం చెప్పారు
ಜನವರಿ 13ನೇ ತಾರೀಕು 14%. ಅವತ್ತು ಬನ್ನಿ 13ನೇ ತಾರೀಕು ಜನವರಿ.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟು ಇನ್ನೇನು ಕೇಳ್ತೀವಿ.
ಏನು
ಬರೆಯಲ್ಲ ಏನು ಇಲ್ಲದೆ ಬರೆಯಲ್ಲ. ನಿಮ್ ಡೇಟ್ 13ನೇ ತಾರೀಕು ಕೊಟ್ಟು ಬನ್ನಿ 14% ಹಂಗೆ ಕೊಡೋದು. ಅವೆಲ್ಲ ಕೊಡಲ್ಲ ಇವಾಗ. ನೀನ್ ಕೇಳ್ದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಹೆಂಗ್ ಕೊಡ್ತಾರೆ? क्या दादा समझ में नहीं आया इनका वो क्या बोल रहे चेतन सर क्या कर रहे थे वो क्या करते हो ಬಾ ಏನಾರ ಮಾಡ್ತೀನಿ ನಾಳೆ ನಾಡ್ದೇನೆ ಏನಾರ ಮಾಡ್ತೀನಿ ಬಾ ಮಾಡ್ತೀನಿ ಬಾ ಎಲ್ಲಿದ್ಯಾ ನೀನು ವ್ಯವಸ್ಥೆ ಮಾಡ್ತೀನಿ ಬಾ ನೀನೇ ಎಲ್ಲಿದ್ಯಾ 90% ನೀನು ಎಲ್ಲಿ ಹುಡ್ಕಡೆ ಬರ್ತೀಯ ಅಲ್ಲೇ ಕೆಂಗೇರಿ ಚಾಮಸ್ ಹೋಗ್ಬಿಡಿ ಎಷ್ಟೊತ್ತಾದ್ರೂ ಫ್ರೀನಲ್ಲೇ ಇರ್ತೀನಿ ಫೋನೇ ಮಾಡಬೇಡ ಹೋಗ್ಬಿಡಿ ಬಿಲ್ಡಿಂಗ್ ಹೊಡೆದಾಕ್ತವ್ರಲ್ಲ ಕೆಲಸ ಮಾಡ್ತಾವ್ರೆ ಎಷ್ಟು
Your lordships leave one matter where the Assistant Commissioner had a benefit of stay before the KT. Assistant Commissioner of GST. He has been, now it's a premature transfer, case of premature transfer. KT has dismissed her petition gently tomorrow, but otherwise.
ಯಾವಾಗ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿತ್ತು?
Transfer 1 year ನಲ್ಲೇ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. In a year. That's the issue.
ನಾಳೆ ಹೆಂಗ್ ನಾಳೆ ನಾಟ್
ನಾಳೆ.
ನಾಳೆ ಆಗಲ್ಲ.
ನಾಳೆ
ಹಾಕ್ಬಿಡಿ.
ನಾಳಿದ್ದಕ್ಕೆ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Next week ಸ್ವಲ್ಪ, by then she'll be removed from the position. But
With
that's
kind,
the difficulty.
with kind leave, my lords.
Lordships, kind permission. On matter, my lords, state has filed a writ petition. Contempt is on Friday, my lord. Kindly.
Friday?
Yes, my lord.
Monday ಬರ್ರಿ.
With kind leave, my lords.
Can it be on Friday?
Friday we are not sitting. In another bench, na?
Oh.
Friday we were now. No,
Se-
we are not there.
Serial number,
Otherwise we would have taken.
ನಾಳೆಗೆ ಏನನ್ನ ಅದು ಪಾಪ ತುಂಬಾ ಸೀರಿಯಸ್
Sorry.
ಎಫೆಕ್ಟ್ ಆಗಿದೆ. Please. Oblige.
serial number 28, my lords.
20?
28, if it can be accommodated on third, my lords. 28,
ಕೋರ್ಟ್ ಮೂಡ್ ಅಂತ ಯಾರು ಹಾಕಿದಾರ ಚಪ್ಪ?
my lords.
ಇದು ನೀವೇ ಮೂವ್ ಮಾಡಿದ್ದ?
ನಾನೇ move ಮಾಡಿದ್ದು.
ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋಣ? ಯಾರು ನಿಮ್ಮ ಅಪ್ಪನ ಬಟ್ ಅವ್ರಿಗೆ
Third, my
all
lords.
right, week after next, on request of
My lord, serial 25, my lord.
25.
Serial 25,
ಹಾ,
September 29.
29th ಬೇಕಾ?
ಹಾ.
We don't know how we are placed on 20. Friday ಬರಕ್ ಬರಲ್ಲ.
ನಾಳೆ,
ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಹಾಕ್ಬಿಡಿ.
ನಾಳೆ.
ಎಲ್ಲ ಆಲ್ರೆಡಿ
3/8 ಹಾಕ್ಬಿಡಿ, my lord. 3/8, 3/12.
ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್.
3/12.
Next.
Lords, serial number 15, my lords.
1/5.
1/5, matter was passed over in the morning. Opponent took pass over.
1/5, you are right.
Oh, my lords, may I seek for a short accommodation, my lords. I have some inconvenience.
ಕೊಡ್ಬೋದಾ? ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಅದ್ರ ಒಂದು ಡೇಟ್ ಹಾಕಿ. ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಅಂತ ಸಾಕು. 2013 ಮ್ಯಾಟರ್.
ಹೌದು.
ಎಷ್ಟು ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರಿ?
ಇಲ್ಲ, ನಂಗೆ ಮಧ್ಯಾಹ್ನ ಸ್ವಲ್ಪ
ಬರ್ಬೇಕು. ಹಗಲೆಲ್ಲ ಓದಂಗ್ ಇರ್ತಾವ ಪೇಪರ್ಸ್ ಎಲ್ಲ, ಕೇಸ್ ಪೇಪರ್ಸ್. ಎಸ್.
Oblige.
4, my lord. Serial number 24, my lord. Respondent, employee,
2018 ಮ್ಯಾಟರ್.
house.
ಏನು?
ಗವರ್ಮೆಂಟ್ ಅವ್ರನ್ನು ಬರ್ತಾ ಇಲ್ಲ. ಈ ಮ್ಯಾಟರ್ ತಗೊಂಡ್ರೆ ರೀಚ್ ಆಗಿಲ್ವೇನೋ ಅಂತಂದು.
ಹಾ.
9th,
9/12
9th.
ನೋಡಿ ಹೌದಾ?
Oblige.
ಹಾ,
My lord, serial number 30,
ಎಂಟ್ರಿ ಮಾಡಿದೆ.
it is.
ಎಂಟ್ರಿ ಮಾಡಿ
My
ಕಂಟಿನ್ಯೂ.
lord, serial number 32, my lords.
32.
32.1, I appear for the petitioner, my lord. 32.1, I appear for the respondent number 1. Seek for short accommodation next week, my lords.
32.1 ಅಲ್ಲಿ ಇದ್ದೀರಾ ನೀವು?
In both the matters, my lord. 32, I am the petitioner, my lord. 32.1,
ಕೋರ್ಟ್ ಮೂಡ್ ಯಾರು?
I have moved the matter, my lords.
ನೀವು ಮೂವ್ ಮಾಡಿರಾ?
Please, my lords.
ಯಾರು ನಿಮ್ಮ ಅಪೋನೆಂಟ್?
State is the opponent, my lords.
ಆಲ್ ರೈಟ್, ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಆನ್ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್.
Date may be
ಮೂವ್ ಮಾಡಿ ಮತ್ತೆ ಡೇಟ್ ಕೇಳ್ತೀರಾ? ನೆಕ್ಸ್ಟ್.
my lords, because of
ನೋ ಡೇಟ್. ಇಫ್ ಯು ಮೂವ್, ಯು ಹ್ಯಾವ್ ಟು ಟೇಕ್ ದ ಡೇಟ್ ವಿಚ್ ವಿ ಗಿವ್. ಎಸ್, ನೆಕ್ಸ್ಟ್. ಹಾ. ಎಸ್. ಹಾ. Yes, anything new you want to add?
Lords, there is, now I had developed only one thing, my lords, that 371J per se did not expressly or explicitly say local cadre. But 371J2 provides that there can be a reservation based on the region. Lords, may kindly have a look at
Yes,
that.
region-based reservation.
371J1C provides for a statewide reservation or taking into consideration the statewide my lords, matrix and the requirements of the state, it would be permissible for them to fix the reservation. Then the second question, which I have raised is, what is the manner of reservation this should be construed as? Because it's on the fact scenario before your lordships. The first of the notification said that you are entitled to choose your option, whether you want to open, you wanted it in the open competition, that is a non-local cadre, or you want it in the local cadre. Even with that, there are some conditions which are imposed. But the subsequent notification, which is now impugned at your lordship's hand, says that wherever notifications has been issued and the final select list is not published, we are following the principles of vertical reservation. That means wherever people come within the merit, we will push them into the non-local cadre. Wherever people who don't get into the non-local cadre, in the order of their merit and the category, they will be accommodated in the local cadre. This is the impugned order before lordships. So now, therefore, it gains a greater significance as to whether what is contemplated in terms of 271J can be construed as providing for a reservation, which in substance is a vertical reservation. Notes, my answer to that is very simple, Notes. Any reservation which falls out of the scope of Article 14 and 15 and 16 of the Constitution of India is never
Elements of vertical.
It is only horizontal reservation. We are presently having.
They may have elements of vertical also.
Notes, it may not be, Notes, because vertical reservations gives an assurance of the filling up of the posts after exclusion of the meritorious candidates in a given category.
Please repeat.
Notes, the vertical reservation gives the assurance of filling up of the number of posts in a given category after exclusion of those candidates in the category who fall into the realm of merit. So total number of candidates who get into this in this category is no criteria in vertical reservation. Criteria is this. Notes, I'll refer to the judgment minutes. It is very simple. If there are 10 posts reserved for scheduled caste, let us assume that 25 candidates have participated. If it is found that out of 25, 6 are those candidates who, while drawing up of the merit list of the open category seats, they get into it, then they get into open category. But that does not mean that their reservation of 6 will be counted for the purpose of filling up of their 10 seats.
No.
So that is vertical reservation. Now that is what is sought to be done. That is the reason why I said the concept of reservation, which falls outside the purview of Article 15.4, 16.1 and 16.4. Because Indra Sahni, 9-judge bench of the Honorable Supreme Court says 16.4 is exhaustive so far as scheduled caste, scheduled tribes and backward classes is concerned. Anything which falls beyond that scope is not a reservation in terms of what is provided under Article 16.1 or a classification under 16.1 or 16.4 or for that matter even 15.4. Now there were reservations provided, the only exception, I'll have to bring it to your lordships at this juncture itself. Realizing that this is the position of law, EW was inserted under 16.6 as another category. Then in Janhit's case, a question came about that creation of another 10%, in addition to 50% which is already there, would breach the principles in both Indra Sahni as well as in Balaji's case. There are a series of cases.
That is Justice Maheshwari Saab's judgment.
Lordships, Justice Dinesh Maheshwari Saab's judgment. There, though a 3:2 judgment came about, the majority view has taken a view that with the existing scenario of 16.4, where the classification is of SC, ST and backward class, 50 was deemed appropriate. Now the scenario has changed because there is another backward class which is identified, which is on the basis of the economic criteria by inserting it under the Constitution as 16.6. Therefore, the increasing of 10% to make it as 60% would not violate the mandate in terms of the requirements under Indra Sahni's case, because it is not completely a watertight compartment. It is a flexible concept depending on the circumstances. But while saying so, the minority took the view, because sometimes there may be some knowledge even in the minority view.
Why Indra Sahni? Is it not M.R. Balaji?
M.R. Balaji was the first judgment. M.R. Balaji is the first judgment. If not for M.R. Balaji, it would have been a different scenario altogether today. That would have been reservations and reservations only. And reservations would have been provided. This is a scenario which came about under Article 371D. That they provided for 85% as a local cadre Then there was and they reserved 15% for open competition. So that the High Court said, no, you cannot reserve it for 15% as open competition. There also you provide reservation, just like it is going to be a vertical reservation in two categories.
371D Sikkim.
No, it's 371D is Andhra, local cadre.
Okay.
It's the parimateria with Andhra and the Hyderabad, Karnataka, Milords. To that, I don't say it is entirely parimateria. The parimateria.
But there it starts with non-obstante clause.
There it starts with a non-obstante clause.
Ours does not have that.
No, it's expressly, it does not have a non-obstante clause. So I will say, my lords, that because the non-obstante clause itself was examined on the touchstone of the basic principles in Sammurthy's case while examining the principles under 371D.
That is argued, na? Somebody argued.
Sammurthy's
There is
case.
non-obstante clause, so it will be subject to 14 and
Article
21,
14,
something like
yes.
that.
Lords, there, of course, they went on the principle because what 371D provided was tribunals would be constituted to decide upon the service disputes and all. Even if the tribunals were to decide the disputes, before its implementation, it would be permissible for the state government to take a decision otherwise. So this 371D5, my lords, was what was challenged, my lords, before the Supreme Court. The constitutional validity was challenged. On the doctrine of, my lords, the basic structure doctrine, my lords, it was struck down. But the other provisions was upheld. But 371D, my lords, why I wanted to refer to 371D, the parimateria is region-wise backwardness or the backwardness of a region as a criteria for reservation is what is common to 371D and 371J. There, a discretion was given. This is called a special status, my lords. What we usually find that the states are trying to find a special status. This is the special status which was given to the state of Andhra. At which point of time, my lords, the Andhra Pradesh was very dominant in the power calling and they were in a position to. But what it enabled this, the Andhra, my lords, was there the lock was president himself had to pass the orders. And then there was a delegation, my lords, which is come about where the governor has passed, legislature has passed, even the cabinet has passed the orders. Lords, the reason why I'm saying this is there was a discretion vested in the state for picking and choosing the regions to be called for the purposes of creating a local cadre. Then there was Schedule 5 to that, which described, my lords, what are all the regions. So these regions formed units apart from each other where independent policies could be implemented. This is how the entire scheme of 371D. But what is common is only this, that regional backwardness or the backwardness of a region of its development as a criteria for the purposes of special status in the nature of creation of a committee or a commission, in the nature of allocation of funds for development, and in the nature of providing for employment opportunities, facilities in the educational and vocational training, forms a comprehensive part in both the statutes. This is the reason why I said, because there may be some importance to the manner in which 371D was understood, my lords, by the Supreme Court, to say as to how 371J requires to be implemented. Because we are faced with a situation where the latest of the notification says that notwithstanding their representation in the entire state services, we will take into account only those people who are being accommodated after excluding those people who are already on the merit. But more particularly like a vertical reservation. Lords, I was bringing to your lordships the minority view which was expressed, my lords, in Janhit's case, that is EWS case. Minority said that consistent view of the courts have been that the reservation is a proportionate representation enabled provision to bring about social justice or the justice of the kind which is sought to be achieved. EWS, you are searching from those set of people on the basis of purely economic criteria. But they may belong to that sect of class which is covered under 16(4), who may already have representation or adequate representation in the public employment or for that matter the educational opportunities. So therefore, it would not be permissible for you to subclassify it into economically weaker section merely on the basis of economic backwardness. in the teeth of what is required under the Constitution as social and economic backwardness as a composite term. This is the minority view, Milords. The reason why I said, Milords, is that the representation which is required being proportionate for the purpose of enabling them to, Milords, be in the mainstream with the reservation forms the basic concept of reservation is what was observed by the minority view. Milords, having said that, Milords, now may I just file this small compilation, Milords. The reason why I'm filing this compilation is only to take your lordships to the manner in which the governor has passed the order, how it fits into the scheme, Milords, of Article 371J 1C and 2B. And this has already been spelled out, Milords, by a coordinate bench headed by the Honorable Chief Justice, as he then was Justice Oka. May I just pass this on, Milords? Milords, page number 3 is the amendment 371J. Then page number 8. The Karnataka Public Employment Reservation in Appointment for Hyderabad Karnataka Region Order 2013. In exercise of the powers conferred by Clause 2 of the Karnataka Special Responsibility of Governor Hyderabad Karnataka Region Order 2013, Governor of Karnataka makes with respect to the state of Karnataka following order. Lords, I'll just pause here and may take your lordships to page number 150. 150. Lords, this was made in the year 1975 after 271D was inserted. I find that it is the structuring of this entire notification is exactly the same.
They kept the text of 371D.
Yes.
Instead of 371J is your version.
That's how they have done it, my lords. I'll be in a position to demonstrate. Lords, lordships will find clause 1 is short title and extent. Clause 2 is interpretation. They have instead of
your case that this itself falls foul of structure of 371J.
Lords, I will not say so, my lords, because this is not under challenge. In the recent judgment, my lords, the Supreme Court said that Section 3.2 of Benami Transaction Act was struck down by a 3-judges bench when the review petition was filed by the union. Lord, that order was recalled only on the ground that the validity was not under challenge. It could not have been examined by the court. So I will not undertake that exercise, but only to draw the parallel that there is a order of the kind which is underwent the judicial scrutiny in a particular manner.
How, in what way you want to make use of that?
Yes.
In your case.
Lords, in this case, what I want to make use of is for this reason. There, they had permitted a 2-tier system of making an assessment of the reservation. The 2-tier system was throughout the state. If let us say 1 million people, or I'm sorry, my lords, 1 crore people are there throughout the state. If the representation which is of the present territory, given territory, is 6%, then you can not exceed to provide a reservation in excess of 6%. This is the first principle. I will take your lordships. This is essentially what they have done. Number 2, even if you are creating a local cadre by taking the entire state scenario into consideration, the number of posts in the local scenario or the local cadre in total cannot exceed 6% of the total cadre strength of the state. 2-tier system. So there are 2 checks and balances. There also 80%, 85% was provided. In our legislation, in our governor's order, it is 80%. There it was 85%. Depending on the regions, they have provided as 85%. This is exactly what is, my lords, covered even under the scheme of what is called now the order of 2013. Lords, may kindly have a look at page 8. And, my lords, I will only take your lordships to only clause 5 and clause 13. At page 10 is clause 5 or para 5. The region for which a local cadre has been organized in respect of any category of post shall be a separate unit for purpose of recruitment, appointment, seniority, promotion and transfer and such other matters as may be specified by the state government in respect of such category of posts. Local cadre is defined under 2E, para 2E, means a local cadre under the state government or in any other local authority or body or organization organized in pursuance to paragraph number 3. This is where they provide at 3.2.3.3.
80% of the posts.
75% of the posts in the region belonging to Group A, junior scale, and Group B posts in each department of the state civil service or in local authority or body or organization shall be organized into as local cadres. 80% of the posts in the region belonging to the category of Group C and 85% of the posts in Group C in the Department of State Civil Services or in local authority or body organization shall be organized as local cadres. So 75%, 80% and 85% depending on the group.
Yes.
Then clause 5 is region for which local cadre has been organized in respect of any category of post shall be separate unit for the purpose of recruitment, appointment, seniority, promotion, transfer, and such other matters as may be specified.
Exactly replica of
They do, yes, my lord.
71D.
Yes.
150.
They have taken the cue because I personally feel, my lords, that is probably what was required to be done. This was already experimented. In 1974 itself, it was experimented to recognize a regional backwardness as a special provision to give a special status. One of the facets of giving the special status is giving them the reservation. It is not the whole of it. So now, clause 13.
State level officers
Or institutions or apex institutions, 8% of the posts in the following state level offices are state level institutions or apex institutions reflecting population percentage of the region in total population of Karnataka in all departments or organization up to levels of Group A shall be reserved for local persons of the region, namely so and so. Now, this came up for consideration before a coordinate bench of this honorable court. The interplay between clause 13, clause 5, that is paragraph number 13 and para 5, and 371J 1C and 371J 2B. This came up for consideration. An argument was advanced saying that once the local cadres are organized and 371J B2 is operated, then that is the extent to which 371J 1C has to be read down or it should be curtailed. The reservation or the concept of reservation itself should be restricted to what is contained under 2B. That was the argument canvassed. May I just pass on, my lords, this compilation of judgments? I'll just answer that and so that I can go to the next question. One C, equitable opportunities and facilities for the people belonging to the said region in the matters of public employment, education, and vocational training, subject to the requirements of the state as a whole.
State should be the
unit is the state. But leverage is given. That's what they do. This is very beautifully drafted. 2B, identification of posts or class of posts under the state government in any body or organization under the control of the state government in Hyderabad, Karnataka region, and reservation of a proportion of such posts for persons who belong to that region by birth or by domicile, and for appointment thereto by direct recruitment, by promotion, or in any other manner as may be specified. Overall statewide reservation you fix, and thereafterwards you identify the posts to create the local cadre. Since the word local cadre is used in the governor's order, I will use the word local cadre. So local cadre you will have to create. Now, so far as this local cadre is concerned, you have to bifurcate this local cadre in the process of recruitment, promotion, etc., is what paragraph number 5 says. Para 3 says that 75%, 80%, 85%, depending on the groups, will be the reservations in the local cadres. So there is a distinct local cadre and there is a non-local cadre in respect of the posts which are in the region. But the overall
reservation, yes, whether it should be construed as 8% because that is what paragraph number 3 says. Paragraph number 3. I'm sorry, paragraph number 13.
13.
Yes. Shall be 8%. This is essentially what came up for consideration, my lords. Idanda copy. ನನ್ನನ್ನೇ ಅಲ್ಲ ಮಾರ್ಕ್ ಮಾಡಿದ್ನಲ್ಲ ಇಲ್ಲಿ ಬಿಡಿ. Right. It specifies the posts. I understand, my lords. On the face of it, it appears that other than the posts which are reserved under the local cadre, there is an additional 8% which is reserved for certain categories statewide. That is what I can understand, my lords, by a plain reading of paragraph number 3, 5, and 13.
Yes.
But let's kindly have a look at page 46, my lords, of the Potra. Page 46 of the compilation of the judgments which I have now given. Page 46.
Begins at.
Yes, it begins at page 46. Lordships may kindly take the paragraph number 2. The issue revolves. Lordship gets it, no? Sorry if there is any mistake. On
Yes.
Yes. The issue revolves around the interpretation of Article 371J of the Constitution of India, which reads thus. Lords, I'll skip this. Next page. We have highlighted the portion which is relevant for our consideration. Honorable President has issued an order on 24th October 2013 on the name and styles Karnataka Special Responsibility of Governor, Order 2013 for the short said order. This said order dated 24/2013 passed with the Honorable President reads thus. Notes after
In
that,
exercise of power conferred by clause 2.
yes. The Governor of Karnataka passed an order styled as Karnataka Public Employment
Then.
Reservation in so and so. Then clause 13 is
13.
extracted.
State level.
Yes.
8% of the posts.
8% of the posts. Now, what came up for consideration, my lords, was if your lords were to take page number 54.
For the people of Hyderabad, Karnataka region will have to be read to mean for the benefit of the people of the said region.
Yes. The reservation of a proportion of such posts for persons who belong to that region by birth or by domicile. Learned Senior Counsel analyzed 371J and urged that there is no ambiguity in the language deployed by the Parliament. Submitted that for giving effect to the order made under 371J by the President of India, is necessary to identify the posts or class of posts in the state government in the Hyderabad Karnataka region, which is defined in the impugned order. Thereafter, the local cadres for the domiciles of the region are required to be constituted. A reservation is required to be provided for a proportion of such posts in the local cadres of persons who belong to that region by birth or by domicile. Submitted that the finding of the single judge, etc. I'll skip this. I'll come for the discussion itself.
Yes.
Then kindly have a look at page 59, paragraph number 11. Kindly permit me to read this because this is probably the only judgment. Yes.
Consideration of submissions.
Consideration of the submissions. We have given our careful consideration to the submissions made by the learned counsel appearing parties. 371J was introduced by the Constitution of India, 2012. Legislative Assembly of the Karnataka as well as Legislative Council passed resolutions in 2010 respectively for making a special provision for the Hyderabad Karnataka areas of the state. Broadly speaking, the Hyderabad Karnataka region was falling within the jurisdiction of Hyderabad state prior to the reorganization of the states. Resolutions passed by the legislature of the state recognized that this region was most backward region of the state, and therefore it was felt necessary to take steps for reducing intra-district, intra-regional disparity. In the statement of objects and reasons, the constitution of the bill, it is mentioned that Hyderabad Karnataka area of the state consists of the districts of Gulbarga, Bidar, Raichur, Koppal, Yadgir. It's observed that in addition, it is necessary to include Bellary district in the region.
For accelerating growth and development in most of the backward regions of the state, a provision was made authorizing the Honorable President of India to make an order for providing any special responsibility to the governor for establishment of the separate development board for the aforesaid region, providing for equitable allocation of the funds for development of the said region, subject to the requirements of the state as a whole, and to provide equitable opportunities and facilities for the people belonging to the said region in the matters of public employment, education, vocational training, subject to the requirements of the state as a whole. In exercise of the powers under clause 1, 371J, the order of 2013 has been promulgated by the Honorable President, providing for the Honorable Governor that shall have special responsibility for establishment of separate development board for the Hyderabad Karnataka region and other matters referred to in clause 1 and clause 2 of 371J of the Constitution. The said order provided that the Honorable Governor, for the purpose of subclause 1, shall have the power to issue such order as may be necessary. Accordingly, the impugned order has been passed. Subclause A, B, C of 1, 371J are matters in respect of which the President is empowered to make an order providing for special responsibilities.
Come to
Lordships.
page 66.
66. I'm sorry, Milord Sahib. It is for this reason. Can I read it from bottom of page 60, para 60?
I feel like that.
Yes.
Yes.
It is for that reason the word may is used in clause 2 of 371J, which enables the Honorable Governor to make provisions for identification of the posts or classes of posts in the state government or organization under the control of the state in that region, and provide for reservation for the people domiciled or born in that region in the said identified posts in the region. Similarly, clause 2 provides for reservation of the proportionate seats in the educational institutions in that region for the students belonging to the region. This apart, the power conferred under subclause C of 1 of Article 371J, clause 2 thereof enables the governor to provide for equitable opportunities for employment for the people belonging to the said region in the posts available in the said region. But in view of subclause C of clause 1, it is not necessary for the governor to confine the reservation in the public employment in the posts available in that particular region, or to provide for reservation for the students of the said region only in the educational institutions available in that region. Clause 2 of 371J is only an enabling provision, and it does not control subclause C of. This is essentially the point which I want to make. But what is necessary and important is the next phrase, Milords. In paragraph 13 of the impugned order, Governor has provided for equitable opportunities of employment to the persons belonging to the said region in the cadres and posts which are located in any part of the state. Thus, reservation provided in para 13 of the impugned order is referable to the power of the governor under subclause C of clause 1 of Article 371J. The said power is not controlled or affected by subclause B of clause 2. Then, having said that, may not sit further, the next paragraph only, Milords. Other things may not be. Chapter 1 of the impugned order of the Honorable Governor provides for organization of the local cadre by identifying the posts in civil service posts under the state government in Hyderabad, Karnataka region, or the posts in local authority or body of organization under the control of the state and region. Para 3.3 lays down the percentage of the posts in the region belonging to the Group C and Group D which can be organized with local cadres. Thus, the provisions of Chapter 1, starting from Para 3 of the impugned order, are referable to Clause B of Clause 2 of 371J. Para 13 of the impugned order, Chapter 2, is enacted under Clause C of Clause 1 of 371J. This interpretation, so on and so forth. Of course, in the next paragraph, Milords, also the second page. In other words, subclauses A, B of Clause 2 of Article 371J can be illustrations of the manner in which the powers, general powers under 371J can be exercised.
The learned single judge felt only this is the way to make that provision workable.
Workable.
DB did not agree with
Yes.
that. Even otherwise it is workable if you go this way.
Yes. Milords, now kindly I will look at para 20 minutes, which is the concluding paragraph. This finding, Milords, is something which the state government will have to ponder upon to ensure that the total reservation, including the local cadre posts, will never exceed 8% of the total number of posts in any given cadre. This is the paragraph which I want to read. As stated earlier, by paragraph 13 of the impugned order, Governor has provided for reservation of 8% posts in the state level offices or the state level institutions 8% reservation is provided representing the population percentage of the said region in the total population of the Karnataka. The reservation provided in the state level offices which are outside the said region, the exercise of power by the Honorable Governor by providing reservation in para 13 of the impugned order is fully legally supported by clause C of Article 371J. Therefore, our conclusion is that though we do not fully concur with the view taken by the single judge, for the reasons we have recorded, there is no illegality associated with paragraph 13 of the impugned order. It is well within the domain of 371J. Therefore, ultimately so also.
Do you have that judgment of the learned judge?
That I didn't carry it, not my sincere apologies, because it merged in the orders of the. I will make it available by the end of the day, Milords. Please. Now, this is only to indicate, Milords, that interplay between 371J1C and 371J2B have been considered, where 371J1 will have primacy of application having larger scope, and 371J2B being only in the nature of an illustration. That means creation of a local cadre is just merely a step in aid of achieving the object under 371J1C.
It appears that way.
Please. Then Lords may request your Lordships to have the compilation of the documents which I have given, Lords. These are just the notifications which I have enclosed along with this. There are no other documents. Sorry, Lords. Page 16.
16.
Yes.
This compilation is only of rulings, documents also.
Only the documents, Lords. There is one compilation of documents, one compilation of the judgments. Lord, these documents are produced in almost all the matters, Lords. It will be convenient, Lords, that
Which page?
16, 16, ink page number 16. Lords, 29/1/2014, bottom of the page. These rules may be called as the Karnataka Public Employment Reservation in Appointment, Hyderabad, Karnataka region, Organization of Local Cadres, Allotment and Transfer of Persons Rules of 2013.
These rules are made by governor.
Milords, these rules
Government.
will be Milords, in the name of the governor.
But government has, no, why we are saying it is
I understand, Milords, because
that
Milords, there one recent view, which of course there was a very recent judgment which came about, Milords, by a learned single judge of this honorable court, where whether the governor has a discretion to exercise under the scheme
Not
of
on the
the
800
constitution,
words.
that was dealt with reference to the sanctioning of the governor pertaining to prosecution, where
No, that's the
most of
different.
no,
It's
but
a
it is exhaustively dealt, Milords, as to what are the circumstances where the governor, because the general scheme of the constitution itself is that governor is the fountainhead of the executive, which essentially means that he is always acting under the aid and assistance of the Council of Ministers.
That's what
The
Maru Ram-
deviation should be explicit.
Maru Ram said that one. no?
Yes, Maru Ram's case said the deviation should be explicit. Milords, then page number 17, Milords. Rule 3.
3.
Pursuant to para 3 and 13 of the order,
Yes.
pursuant to the para 3 and 13 of the order, cadre controlling authority may identify by notification the number of posts in each cadre within the jurisdiction of the cadre constituting local cadre in the manner specified below.
The order is dated?
Milords, 2014, Milords.
No.
Rules.
The order which we
Milords,
are referring to is
2013.
2013.
That is the governor's order.
Governor's order. Where this power is given to the state,
Milords, this
rules power to make
Milords,
these
power
rules.
to make rules is not explicitly there even in the order of 2013. Explicitly, it is not there.
In the president's order is also not there.
It is not.
In
It's
governor's
president's,
order.
not president only.
It's very skeletal.
Because very skeletal, because it only enables the president to activate the powers of the governor. It is something like you are just switching it on. The powers of the president is to switch it on. He issues a notification and activates the governor. Then it's for the governor to do it. Then, my lords, whether the governor is acting independently, my lords, if your lords were to see, there is another provision under 371, which specifically says, with the aid and assistance of the Council of Ministers in his independent judgment.
Or in consultation with etc.
Lords, it says in
Both are
consultation with, and in his independent judgment. Lords, there is an explicit conferment of powers on the governor, where he will have a consultative process, but decision-making is independent judgment.
No, in consultation means always independent only.
Yes, not because consultation.
Otherwise, governor becomes the shorthand for the government.
Correct. But that's the constitutional scheme, my lords.
But here it is bit different.
That's what your lordships had observed, my lords.
Yeah.
If the other provision is seen, because to my understanding, my lords, the constitution in its structure providing for the executive to a state always provides for the governor as a fountainhead or a constitutional head of the executive, which is the Council of Ministers.
More
So,
symbolic.
It is only symbolic, but
Because
there are
today, Mr. Rajagopal has shown
only exceptions.
certain provisions where they say government,
Yes,
state
see,
government.
even 371,
governor.
yes.
That
Even
way.
371 refers to state government in some provisions, my lords. But the moment word governor is used, then it comes with a package. That governor includes the aid and advice of the Council of Ministers unless he is expressly
indicated.
otherwise indicated. Otherwise, it militates against the scheme of the Constitution itself.
ಅಲ್ಲ ಆ ಇಂಡಿಕೇಶನ್ ಇದೆ ಅಂತ ಅವರ ಒಂದು ವಾದ.
ಅದು ನನಗೆ
ಇದರಲ್ಲಿ ಗವರ್ನರ್ಸ್ ಆರ್ಡರ್ ನಲ್ಲಿ ನಲ್ಲೇ ಇದೆ ಅದು.
It's there, but I'm just indicating, my lords, this why I am submitting this. Kindly permit me to elaborate for a minute, my lords. These are all in the nature of policy decisions.
Correct.
Where the participation of the elected representatives and the likes of the intellect of the bureaucracy requires to conglomerate for the purpose of evolving a policy.
At
Not-
times, the involvement
not
them
something,
itself may come in the way.
And
There is a famous book, India Grows During Night,
yes,
when all politicians sleep ಅಂತ.
that's true, my lords. No, that's true. But
It's
lords,
such a book.
whatever I am arguing is theoretically, my lords. Practically, whatever happens,
No,
theoretically.
Not only that. Kindly see how Article 371J is coined.
yes.
It's very different. In a different
Lords,
way.
it only says provide for any special responsibility of the governor for so and so. Lords, that's the reason why I said, Lords, if your lords were to see I think there's one judgment which is already discussed on the.
But other
Shamsher,
provisions.
Lords, the three judgments.
Shamsher Singh,
Shamsher Singh's case, Bommai's case, very explicitly dealt with the exclusivity of the powers of the governor, where it can be exercised, and where such
Individual
exclusivity is not explicit in the Constitution, then he is deemed to be under the aid and advice.
We have gone further.
I understand, my lords. I was
Rameshwara Dayala, which is that?
yes, my lords.
Huh?
That is
Rameshwara. The powers of the governor and whole ಒಂದು thesis ಬರ್ದಂಗ್ ಬರ್ದಾರಲ್ಲ ಯಾವ್ದು?
Ramesh versus state of yes.
Correct.
So, of course, now, my lords, as to whether the governor has done, because that's the reason why I said, my lords, whether an ordinate legislation or a subordinate legislation. Now, this makes the bifurcation of the three cadres. Under, in page number 17 of the compilation, organization of local cadres. The manner of constituting a local cadre which may consist of following units. 3 units they have carved out. State level local cadre means a cadre carved out of the respective group up to junior scale B, C, D in the state level offices or institutions in the government or body or organization to the extent of 8% as local cadre. Regional local cadre means a cadre carved out of the total number of posts of 75, 80, 85 for ABCD. This also includes cadres having jurisdiction in the cadre district wise, taluk wise or smaller jurisdiction of the respective appointing authority within the region. Statewide local cadre means local cadre constituted by merger of state level local cadre and regional local cadre where the jurisdiction of the cadre is of statewide in the government or the body or the organization. So there is a state level cadre, there is a regional cadre. Then there is also a possibility of a merger wherever it is a state level cadre, where it is called as a statewide local cadre. Okay. So three categories, minutes. Then Lordships may kindly take page number 19. The residual parent cadre and the local cadre carved out of it shall be treated as separate unit for the purpose of recruitment, appointment, seniority, promotion, and for operation of reservation. Two parallel roster cycles shall be operated for the residual parent cadre and the local cadre. Notice the cake is cut. If I can, that is what they do. The cake is cut unless they get into 2C, statewide local cadre for whatever purposes. The cake is cut in the regions, the posts in the regions, which is the Hyderabad Karnataka region, into what is called as the residual parent cadre and the local cadre. And whatever should happen pertaining to these two should be kept distinct and separate. Then again, 20 minutes, page 20, clause 7, rule 7.
Seniority and related issue.
Competent authority shall maintain separate seniority in each local cadre and residuary parent cadre. Not only the entry point, but the existing points will be in two different streams. Now, my lords, your lordships may kindly take. Now, this is an FAQ, page number 23, which is the FAQs pertaining to, because this is what the state has understood. My lords, ultimately, what state understood of for itself while implementing the scheme of reservation under 371J, 2013 order and the 2014 rules is what is contained in their FAQs, my lords, which is available in all the recruitment notifications where 371J, if you click it, it will open the FAQs. Page number 23. Notes, I'll just read two.
Yardi, question answers.
This is our state government.
State government and yaru. Who is that?
Notes, this is
frequently asked questions.
Frequently asked questions is an information which will be given to the candidates who are willing to participate in any recruitment process.
Who prepared this document?
This is available in the websites of all the recruiting agencies, Milords.
Author yaru?
Author, Milords, of course. DPR.
DPR Department of Personnel and Administration. This is Milords FAQ. FAQs Milords is now FAQ is frequently asked questions where Milords it is just uploaded in the website for information.
What weightage should be attached to this?
Please.
Who is the author? What is the process?
This is
authoring it. Either will depend on
that information they can
I'll
give it.
get
Just two sentences which I want to read is,
Yes.
this is one understanding. I will not, since I do not know the author, I would say that this is one understanding, Milords, of how
At
371
least you
is.
can say there is another person who is with you. The unknown person.
Unknown person.
Okay.
Antarjaldalanttu ide. Page number 25 minutes, 12, 13, 14, 15.
What is cadre? What is local cadre?
What is a
the
parent cadre? What is a residual cadre? Then,
Our prakara ಏನು?
our prakara, it's perimeterial.
All the category. of
Cadre
posts.
means strength of all category of posts in a service are part of the service sanctioned as a separate unit as per rule 87 of the KCSR. Is a cadre. That's the total cadre strength. What is a local cadre? It is it's a cadre carved out of the existing cadre in a service which is earmarked for reservation for being filled up by the local persons belonging to Hyderabad Karnataka region under the control of the appointing authority. Parent cadre means it is the cadre in a service existing before the carving out of the local cadre under the control of an appointing authority. The parent cadre left over after carving out the local cadre is known as the residual cadre. Okay. Then let's kindly have a look at page number 28. Question number 31.
Can a local person after
Having opted out of a local cadre can revoke the option so excised? No. Option once excised, opting for the local cadre is irrevocable. Now, this is already a view which is expressed by the coordinate bench of this honorable court. What I am reading at 31 is a view which is expressed by the division bench of this honorable court.
focus of judgment? which-
Illa, Justice Pandit has taken a view that once excise of option is made in respect of the local cadre or the residual parent cadre,
It is irrevocable.
that is irrevocable. That's a view which is already expressed. That was, of course, I'll have to tell your lordships that this is pertaining to the exercise of options when the seniority list was made. What happened? The existing posts and the existing personnel of the region, post identification was made, and then they were given an option. You want to go into the local cadre or you want to stay in the residual parent cadre. So they exercised their option. One of them came before the court and said that no, he wanted to withdraw from it. The court said it is irrevocable. That's the facts of that case. I have produced that judgment also, my lords, in my compilation. Then question number 38.
But the option ಸ್ವಲ್ಪ
Next, let's now that next notification, I personally felt, this is so very beautifully worded. The next notification 6620 gave them an open-ended option. Actually, I'll take your lordships. Even if you are asking for local cadre, then your options are still open for the open competition posts. Lordships, may kindly have a look at page 30. Can local persons be eligible to apply for direct recruitment vacancies in respect of posts available in the residual cadres? Yes, only in respect of direct recruitment vacancies and without claiming reservation as a local person.
Yes.
That, of course, I would request, the Additional Advocate General can get the information. This is available in the websites of all the. Now I will come, my lords, I'll skip the 2 pages and then come to page number 38. This is where the controversy starts, or this is where the controversy was set at rest, but it started later. This was where it was set at rest.
Yes.
Note 6/6/2020. Notes, I will take your lordships to page number 40. Notes 4. ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಸಮಯದಲ್ಲಿ ನೀವು ನೀಡಿರುವ ಹುದ್ದೆಗಳ ಆದ್ಯತೆಯಂತೆ ಮುಕ್ಕುಳಿದ ವೃಂದದಲ್ಲಿ ಸ್ಥಳೀಯ ವೃಂದಕ್ಕಿಂತ ಉತ್ತಮ ಆದ್ಯತೆ ದೊರೆಯುವುದಾದಲ್ಲಿ ಮಿಕ್ಕುಳಿದ ವೃಂದ ಆಯ್ಕೆ ಮಾಡುವಿರಾ? ಹೌದು ಅಥವಾ ಇಲ್ಲ?
This option is
there. Next, ಒಂದು ವೇಳೆ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಯು ಮಿಕ್ಕುಳಿದ ವೃಂದದ ಹುದ್ದೆಯನ್ನು ಆಯ್ಕೆ ಮಾಡಿಕೊಂಡು ನೇಮಕಾತಿ ಹೊಂದಿದಲ್ಲಿ ಅಂತಹ ಅಭ್ಯರ್ಥಿಗೆ ಜಾರಿಯಲ್ಲಿರುವ ನಿಯಮದಂತೆ ತನ್ನ ಸೇವಾ ಅವಧಿಯಲ್ಲಿ ಅನುಚ್ಛೇದ ರಿಸರ್ವೇಶನ್ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್, ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ, ಬಿಕಾಸ್ he is given an option to choose. ನೆಕ್ಸ್ಟ್, ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ಎರಡೂ ವೃಂದಗಳಿಗೆ ಏಕಕಾಲಕ್ಕೆ ಒಂದೇ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಒಂದೇ ಇಲಾಖೆಯ ಅಥವಾ ಒಂದೇ ಪದನಾಮೆ ಬಹು ಆಯ್ಕೆಗೆ ಅವಕಾಶವಿಲ್ಲದ ಹುದ್ದೆಗಳನ್ನು ನೇರ ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳಬೇಕಾದ ಸಂದರ್ಭದಲ್ಲಿ ಮಾತ್ರ KPSCU ಸೇರಿದಂತೆ ಎಲ್ಲಾ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಗಳು ಸ್ಥಳೀಯ ವ್ಯಕ್ತಿಗಳಿಗೆ ಈ ಕೆಳಕಂಡ ಆಯ್ಕೆಗಳನ್ನು ಒಂದೇ ಅರ್ಜಿ ನಮೂನೆಯಲ್ಲಿ ನಮೂದಿಸಿ ಒಂದೇ ಅರ್ಜಿಯನ್ನು ಆಹ್ವಾನಿಸತಕ್ಕದ್ದು. May I just read this minutes? ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ ಸ್ಥಳೀಯ ವೃಂದದ ಹುದ್ದೆಗಳ ಆಯ್ಕೆ ಬಯಸುವಿರಾ? ಹೌದು ಇಲ್ಲ. Do you want to get into the local cadre? Yes or no? Then next, ಹೌದು ಎಂದಾದಲ್ಲಿ ಈ ಕೆಳಕಂಡ ಆಯ್ಕೆಗಳನ್ನು ಕಡ್ಡಾಯವಾಗಿ ಭರ್ತಿ ಮಾಡತಕ್ಕದ್ದು. ಮಿಕ್ಕುಳಿದ ವೃಂದದ ಹುದ್ದೆಗಳಿಗೂ ಸಹ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ಬಯಸುವಿರಾ? ನೆಕ್ಸ್ಟ್, ಹೌದು ಅಥವಾ ಇಲ್ಲ. ನೋಟ್, ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ ಪ್ರದೇಶದಲ್ಲಿ ಸ್ಥಳೀಯ ವ್ಯಕ್ತಿಗಳು ಸ್ಥಳೀಯ ಹಾಗೂ ಮಿಕ್ಕುಳಿದ ಎರಡೂ ವೃಂದದ ಹುದ್ದೆಗಳಿಗೂ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ಅರ್ಹರಿರುತ್ತಾರೆ. ದೆನ್ 3, ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಸಮಯದಲ್ಲಿ ನೀವು ನೀಡಿರುವ ಹುದ್ದೆಗಳ ಆದ್ಯತೆಯಂತೆ ಸ್ಥಳೀಯ ಹಾಗೂ ಮುಕ್ಕುಳಿದ ಎರಡೂ ವೃಂದದಲ್ಲಿ ಒಂದೇ ಹುದ್ದೆಯ ಆಯ್ಕೆಗೆ ಅರ್ಹತೆ ಹೊಂದಿದಲ್ಲಿ ಯಾವ ವೃಂದದ ಹುದ್ದೆಗೆ ಆಯ್ಕೆ ಬಯಸುತ್ತೀರಾ? ಸ್ಥಳೀಯ ವೃಂದ, ಮಿಕ್ಕಳದ ವೃಂದ. Note, this is so open-ended. ನೋಟ್, ಒಂದು ವೇಳೆ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿ ಮಿಕ್ಕುಳದ ವೃಂದದ ಆಯ್ಕೆಯನ್ನು ಮಾಡಿಕೊಂಡು ನೇಮಕಾತಿ ಹೊಂದಿದಲ್ಲಿ ಅಂತ ಅಭ್ಯರ್ಥಿಗೆ ಜಾರಿಯಲ್ಲಿರುವ ನಿಯಮದಂತೆ ತನ್ನ ಸೇವಾ ಅವಧಿಯಲ್ಲಿ ಅನುಚಿತ
ರಿಸರ್ವೇಶನ್ ಇಲ್ಲ ಅಂತ
ಇಲ್ಲ.
ಆ ಆಪ್ಷನ್ ಇದ್ರೆ ಇಲ್ಲ.
ಇಲ್ಲ. Note, this is what led to settling what could be a very equitable and justifiable way, my lords, of settling this reservation for the local cadre at the time of recruitment. At the time of reservation, it is only exercise of option. I'm sorry, at the time of promotion or at the time of choosing between the local and the non-local cadre in the seniority list, it's an exercise of option. These provisions are not there. That means, lords, if your lords were to see this, how beautifully this is worded. I will say, I want to be a local candidate. Then it becomes mandatory for me to fill up two other clauses. It says, ಮಿಕ್ಕುಳಿದ ವೃಂದದ ಹುದ್ದೆಗಳಿಗೂ ಸಹ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ಬಯಸಿದಿರಾ. So whether my application, my lords, in the beginning I said, ಒಂದೇ ಅರ್ಜಿ ನಮೂನೆಯಲ್ಲಿ ನಮೂದಿಸಿ. It's a single application. In this, again, I will be given an option. Do you still want to continue to contest for this post? Then I get selected. I get selected for both. Note, this is very important. I get selected for both. That means I may have a posting on the basis of my merit in the residual cadre, and on the basis of the reservation of a local cadre, I may even get it here on the basis of my merit. Then I can still exercise my option whether I want to get into the local cadre or the residual parent cadre.
Subject to the condition that no facility of reservation.
Yes, then I will not be entitled to reservation. Now, this is what was referred to in the recruitment notification issued for appointment of the police sub-inspectors. Lords, that notification your lords will find at page number 128. I'm sorry. I'm sorry. Idalva?
47 alva.
Lords, page 47. Sorry, my lords. Lords, in that, in the first paragraph, almost 4 lines from the bottom. ನಿಯಮಗಳು 2013 ಹಾಗೂ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ 2018 ದಿನಾಂಕ 6/6/20 ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ದಿನಾಂಕ ಸೋನ್ಸೋ ಮತ್ತು ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ನಿಯಮಗಳು ತಿದ್ದುಪಡಿ ನಿಯಮಗಳು ಕಾಲಕಾಲಕ್ಕೆ ಆಗುವ ತಿದ್ದುಪಡಿಗಳ ಅನುಸಾರ ಈ ಅಧಿಸೂಚನೆಯನ್ನು ಪ್ರಕಟಿಸಿ ಅರ್ಹ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಆನ್ಲೈನ್ ಮೂಲಕ ಅರ್ಜಿಗಳನ್ನು ಆಹ್ವಾನಿಸಲಾಗಿದೆ. Notes, in this what they have done at page 49. ಮಿಕ್ಕುಳಿದ ವೃಂದದ ಹುದ್ದೆಗಳು 438, ಕಲ್ಯಾಣ ಕರ್ನಾಟಕ ಪ್ರದೇಶ 80% ರಂತೆ ಸ್ಥಳೀಯ ವೃಂದದ ಹುದ್ದೆಗಳು 107. Notice the competition, unless opted, is within the local cadre. The competition for the local candidates is within the local cadre. Unless he wants to go out, if he has filled up in the application, he may go out. But so far as the residual cadre is concerned, this is a watertight compartment unless he has not exercised the option. 438 remains 438 unless a person who becomes meritorious and gets into 438 may reduce some posts when he exercises option. But this what happened. Recruitment process was completed. Provisional select list was made. Allegations were made that there was some element of technology user while the examinations were attended by the candidates. State government took a decision that no, we are going to cancel the examinations. And then that was challenged before this honorable court. This honorable court said, all right, you get it conducted through another authority. That's a part of the story, but provisional select lists had been published, after which the entire dispute arose. Examination was entrusted to Karnataka Examination Authority. They conducted the examinations. Now the provisional select list again, my lords, is published. But now it is in this interregnum, that is between 19/1/2022, the date on which the provisional select list was published. Now what has happened is, kindly have a look at page number 43. This is the second notification of the government. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ದಿನಾಂಕ 6/6/20 ಸುತ್ತೋಲೆಯಲ್ಲಿ ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ವೃಂದದ ನೇರ ನೇಮಕಾತಿ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಿಗಳು ಎರಡೂ ವೃಂದದ ಹುದ್ದೆಗಳಿಗೆ ಏಕಕಾಲಕ್ಕೆ ಒಂದೇ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ವೃಂದಗಳಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳ ಸಂಖ್ಯೆಯನ್ನು ಪ್ರತ್ಯೇಕವಾಗಿ ಮೀಸಲಿಡುವವರು ವರ್ಗೀಕರಣವನ್ನು ನಮೂದಿಸಿ ಒಂದೇ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ಒಂದೇ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿ ಅವಕಾಶ ಕಲ್ಪಿಸಿ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ತಮ್ಮ ಇಚ್ಛೆಯಂತೆ ಸ್ಥಳೀಯ ಅಥವಾ ಮುಕ್ಕುಳಿದ ವೃಂದದ ಆಯ್ಕೆ ಮಾಡಿಕೊಳ್ಳಲು ಸ್ಪಷ್ಟ ಹಾಗೂ ನಿಖರ ಆಯ್ಕೆಗಳನ್ನು ಪಡೆದು ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಕೈಗೊಳ್ಳುವಂತೆ ತಿಳಿಸಲಾಗಿರುತ್ತದೆ. ದಿನಾಂಕ 6/6/20 ಸುತ್ತೋಲೆಗೆ ಕಲ್ಯಾಣ ಕರ್ನಾಟಕ ಭಾಗದ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಹಾಗೂ ಆ ಭಾಗದ ಜನಪ್ರತಿನಿಧಿಗಳಿಂದ ತೀವ್ರ ವಿರೋಧ ವ್ಯಕ್ತವಾದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ವಿಷಯವನ್ನು ನಿರ್ಣಯಕ್ಕಾಗಿ ದಿನಾಂಕ 7/5/22 ನಡೆದ ಸಚಿವ ಸಂಪುಟ ಉಪಸಮಿತಿ ಮಂಡಿಸಲಾಗಿರುತ್ತದೆ. ಸಮಿತಿ ತೀರ್ಮಾನದಂತೆ ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಉಲ್ಲೇಖಿತ ದಿನಾಂಕ 6/6/20 ಸುತ್ತೋಲೆಯನ್ನು ಹಿಂಪಡೆಯಲಾಗಿದೆ. Then next what should be done? ವಿವಿಧ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಗಳು ಇನ್ನು ಮುಂದೆ ಮಿಕ್ಕುಳಿದ ವೃಂದ ಮತ್ತು ಸ್ಥಳೀಯ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ನೇಮಕಾತಿ ಹುದ್ದೆಗಳಿಗೆ ಅರ್ಜಿ ಆಹ್ವಾನಿಸುವ ಅಧಿಸೂಚನೆಯನ್ನು ಪ್ರತ್ಯೇಕವಾಗಿ ಹೊರಡಿಸಿ, ಪ್ರತ್ಯೇಕವಾಗಿ ಸ್ಪರ್ಧಾತ್ಮಕ ಪರೀಕ್ಷೆಗಳನ್ನು ನಡೆಸಿ, ಪ್ರತ್ಯೇಕವಾಗಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಕೈಗೊಂಡು ಆಯ್ಕೆಯನ್ನು ಅಂತಿಮಗೊಳಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ. ಇನ್ನು ಮುಂದೆ ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್.
But one which is already halfway through, that
has to, because it says ವಿವಿಧ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಿಗಳು ಇನ್ನು ಮುಂದೆ ಮಿಕ್ಕುಳಿದ ವೃಂದ ಸೋನ್ಸೋ ನೇಮಕಾತಿ ಹುದ್ದೆಗಳಿಗೆ ಅರ್ಜಿ ಆಹ್ವಾನಿಸುವ. So wherever applications will be invited, for that this will be applicable. So you issue separate notification.
This is purely prospective in operation.
This is purely prospective in operation. Then the last paragraphs. ಈಗಾಗಲೇ ಗೆಜೆಟೆಡ್ ಪ್ರೊಬೇಷನರ್ಸ್ ಹುದ್ದೆಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಒಂದೇ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಜಾರಿಯಲ್ಲಿರುವ ಪ್ರಕರಣಗಳಿಗೆ ಸೀಮಿತವಾಗುವಂತೆ ಮಾತ್ರ 6/6/20 ಸುತ್ತೋಲೆಯಲ್ಲಿ ನೀಡಲಾಗಿರುವ ನಿರ್ದೇಶಗಳ ಅನ್ವಯ ಆಯ್ಕೆ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಅಂತಿಮಗೊಳಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ.
That is for
complete the process.
The last paragraph.
Last paragraph.
Because this was twice read by Mr.
I understand, it would have been.
No, last paragraph.
Yes. Then came page number 45.
Allah, read that last paragraph.
Last paragraph.
Many are eagerly awaiting to have this read by you.
ಈಗಾಗಲೇ ಗೆಜೆಟೆಡ್ ಪ್ರೊಬೇಷನರ್ಸ್ ಹುದ್ದೆಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಒಂದೇ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಜಾರಿಯಲ್ಲಿರುವ ಪ್ರಕರಣಗಳಿಗೆ ಸೀಮಿತವಾಗುವಂತೆ ಮಾತ್ರ ದಿನಾಂಕ 6/6/20 ಸುತ್ತೋಲೆಯನ್ನು ನೀಡಲಾಗಿರುವ ನಿರ್ದೇಶಗಳ ಅನ್ವಯ ಆಯ್ಕೆ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಅಂತಿಮಗೊಳಿಸುವಂತೆ ಸೂಚಿಸಲಾಗಿದೆ.
ಏನದು?
To complete the selection process in accordance with the guidelines dated 6/6/2020, except in respect of gazetted probationers. Wherever there is a single notification issued.
Yes.
Then, my lords, this is where the problem arises at page number 45, because till this place, recruitment of these police sub-inspectors had to take place only in accordance with 6/6/2020. The recruitment process fell into litigation and the recruitment process is still going on. Now, page
ಎಲ್ಲ ಕೇಸು ಗೀಸು ಮುಗಿಯೋ ಅಷ್ಟೊತ್ತಿಗೆ ಎಲ್ಲರೂ ಏಜ್ ಬಾರ್ ಆಗಿ ಹೋಗ್ತಾರೆ.
ಇದೊಂದೇ ಇರೋದು ಇದ್ರೊಳಗೆ ಇದೊಂದು ಅದು lots many such instances. Your lordships is aware, my lords, because I probably started my service practice by taking up the KPSC litigation of 1998. Lords, your lordships may take my words, my lords. Even today I am conducting these litigations, the offshoot of the litigations. Even now I am conducting. And very recently, I think it's about 4-5 months back, one of the persons was ACTO. He got a posting in the revenue department as a KS senior scale because of his that service was also counted and he was given. That means he was deprived all these years. And similarly, some people have gone out. There are some people who have come in now. And I think one of the persons, I filed a memo saying that I cannot pursue this matter because though he is in the final select list, which is now published, he is already age barred. You can't give him an appointment. Notes then 45.
No, two things, just little out of the context. Those, see where recruitment process is halted by orders of the court or by government also. Or government does not decide to go for recruitment at all. During that period, those who are rendered age barred.
Yes.
No provision for protecting them.
Lords, there are judgments to that effect. Wherever the litigations have cropped up pertaining to the recruitment process itself, some leverage has been given
That period
by the
should be-
courts, by extending the age. And many a times, Lords, the state government itself has come about.
No
Lords, many-
policy, or, but it
There
is
is no
only an
policy. No,
individual
it is-
piecemeal.
It is only recruitment specific, Lords, that notification specific, where those posts could not be filled up. They have come about with a notification saying that we are extending the age. So those people who are eligible as on the date of the previous notification, they
Yeah.
will also be eligible for the second notification. That's how the state government has intervened. Courts have also granted minutes. As I submitted minutes, this, what is this called as moderation and all these things took place.
Periodic recruitment.
There is one general notification in operation as on date, where my lord's extension is till next year, 1 year.
Because of
has
the
been-
COVID.
I'll place it on, I'll just give it to the court. It is for.
COVID related.
ಅವಾಗ ಮಾಡಿದ್ದೆ ಅದು
No, my lords,
2022.
Not that, there is, as on date, even today, my lords, in respect of age bar candidates, if there is any recruitment that is being held till I think next September, it was issued, I think 1 year back. Any recruitments that will be held for the next 1 year, if there is any age bar candidate, it has been extended. So there is general notifications also that are being issued, but there is no
So good
policy or any specific rule that way, but it is being done.
Because in one judgment, the bench where I was also
Please.
a member, in
Please.
fact, I authored that judgment,
Please.
saying that where periodically you do not hold the
Recruitments
recruitment process at all,
to be done.
then the period during that period shall be added while deciding the age bar.
Age bar.
If he is 35 years and 3 years you do not hold, they become 38.
38.
One fine day you start the recruitment process. Many factors enter the fray of decision making.
Please.
We need not say that. So they also should get the opportunity to be in the fray. This is how we structure one judgment. Anyway, yes.
Now, my lords, page number 45. This is where the problem starts. This is where it has been triggered. The entire dispute gets triggered
Yes.
only on the basis of this notification.
Yes.
ಉಲ್ಲೇಖಿತ ದಿನಾಂಕ 15/6/22 ಸುತ್ತೋಲೆಯಲ್ಲಿ ದಿನಾಂಕ 6/6/20 ಸುತ್ತೋಲೆಯನ್ನು ಹಿಂಪಡೆದು ವಿವಿಧ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಗಳು ಇನ್ನು ಮುಂದೆ ಮುಕ್ಕುಳಿದ ವೃಂದ ಹಾಗೂ ಸ್ಥಳೀಯ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ನೇರ ನೇಮಕಾತಿ ಹುದ್ದೆಗಳಿಗೆ ಅರ್ಜಿ ಆಹ್ವಾನಿಸುವ ಅಧಿಸೂಚನೆಯನ್ನು ಪ್ರತ್ಯೇಕವಾಗಿ ಹೊರಡಿಸಿ, ಪ್ರತ್ಯೇಕವಾಗಿ ಸ್ಪರ್ಧಾತ್ಮಕ ಪರೀಕ್ಷೆಗಳನ್ನು ನಡೆಸಿ, ಪ್ರತ್ಯೇಕವಾಗಿ ಆಯ್ಕೆ ಪ್ರಕ್ರಿಯೆ ಕೈಗೊಂಡು ಆಯ್ಕೆಯನ್ನು ಅಂತಿಮಗೊಳಿಸುವಂತೆ ಸೂಚಿಸಿರುತ್ತದೆ. ಮುಂದುವರೆದು ಸದರಿ ಸುತ್ತೋಲೆಯ ಕೊನೆಯ ಖಂಡಿಕೆಯಲ್ಲಿ ಸದರಿ ಸುತ್ತೋಲೆಯ ಜಾರಿಗೆ ಬಂದ ದಿನಾಂಕಕ್ಕಿಂತ ಮೊದಲು ಈಗಾಗಲೇ ಗೆಸ್ಟೆಡ್ ಪ್ರೊಫೆಷನಲ್ ಹುದ್ದೆಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಒಂದೇ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಜಾರಿಯಲ್ಲಿರುವ ಪ್ರಕರಣಗಳಿಗೆ ಸೀಮಿತವಾಗುವಂತೆ ಮಾತ್ರ 6/6/20 ಸುತ್ತೋಲೆಯನ್ನು ನೀಡಲಾಗಿರುವ ನಿರ್ದೇಶನಗಳ ಆಯ್ಕೆ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಅಂತಿಮಗೊಳಿಸುವಂತೆ ಸೂಚಿಸಲಾಗಿರುತ್ತದೆ. ದಿನಾಂಕ 15/6/22 ಸುತ್ತೋಲೆಯ ಕೊನೆಯ ಖಂಡಿಕೆಯಲ್ಲಿ ತಿಳಿಸಲಾಗಿರುವ ಅಂಶಗಳು ಕಲ್ಯಾಣ ಕರ್ನಾಟಕ ಭಾಗದ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಹಾಗೂ ಜನಪ್ರತಿಗಳಿಂದ ತೀವ್ರ ವಿರೋಧ ವ್ಯಕ್ತವಾದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ವಿಷಯವನ್ನು ದಿನಾಂಕ 29/12/22 ನಡೆದ ಸಚಿವ ಸಂಪುಟ ಉಪಸಮಿತಿ ಸಭೆಯನ್ನು ಮಂಡಿಸಿ ಸಮಿತಿ ನಿರ್ಣಯದಂತೆ ದಿನಾಂಕ 15/6/22 ಸುತ್ತೋಲೆಯ ಕೊನೆಯ ಖಂಡಿಕೆಯಲ್ಲಿ ತಿಳಿಸಿರುವ ಅಂಶಗಳನ್ನು ಮಾತ್ರ ಹಿಂಪಡೆಯಲಾಗಿದೆ.
Last paragraph.
Last paragraph. But if last paragraph is withdrawn,
ಹೋದ್ರೂ ಏನಾಗಲ್ಲ.
even then nothing will happen because page 44, the first paragraph. ವಿವಿಧ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಿಗಳು ಇನ್ನು ಮುಂದೆ ಮಿಕ್ಕುಳಿದ ವೃಂದ.
That remains as it.
That remains as it is.
But ಇಂಥವನ್ನೆಲ್ಲ ಓದುವಾಗ ನಾವು ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಓದ್ದಂಗೆ ಓದ್ಲಿಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ, ಆಗೋದಿಲ್ಲ. ನಾನು ಅದನ್ನ ಓದ್ತಾ ಇಲ್ಲ ಹಾಗೆ. Notes, if they are deleting the object and intent, Millards will have to be read that they did not want this 6/6/2020 to prevail. Then next, ದಿನಾಂಕ 15/6/22 ಸುತ್ತೋಲೆಯ ಕೊನೆಯ ಖಂಡಿಕೆಯಲ್ಲಿ ತಿಳಿಸಲಾಗಿರುವ ಅಂಶಗಳು ಕಲ್ಯಾಣ ಕರ್ನಾಟಕ ಭಾಗದ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಹಾಗೂ ಜನಪ್ರತಿನಿಧಿಗಳಿಂದ ಹಿಂಪಡೆಯಲಾಗಿದೆ. ವಿವಿಧ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಿಗಳು ದಿನಾಂಕ 15/6/22 ಸುತ್ತೋಲೆಯ ಜಾರಿಗೆ ಬರುವುದಕ್ಕೆ ಮೊದಲು ಗೆಸ್ಟೆಡ್ ಪ್ರೊಫೆಷನಲ್ಸ್ ಹುದ್ದೆಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಎಲ್ಲಾ ಹುದ್ದೆಗಳಿಗೆ ನೇಮಕಾತಿ ದಿನಾಂಕ 6/6/20 ಸುತ್ತೋಲೆ ಅನ್ವಯ ನೇಮಕಾತಿ ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಿ ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿ ಪ್ರಕಟಿಸದೇ ಇದ್ದಲ್ಲಿ, this is very important. This is actually the gist of my arguments, my lords.
If
Final select list is not published, but as per the notification of 6/6/2020, the reservations were called for in a single notification, then ಅಂತಹ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆಗಳಿಗೆ ಸೀಮಿತವಾಗಿ ಮಾತ್ರ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವ ಸಮಯದಲ್ಲಿ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಪಡೆಯಲಾಗಿರುವ ಆಯ್ಕೆಯನ್ನು ಪರಿಗಣಿಸದೆ without considering the option exercised by them, ಮೆರಿಟ್ ಪಟ್ಟಿಯಿಂದ ಆಯ್ಕೆ ಪಟ್ಟಿ ತಯಾರಿಸುವಲ್ಲಿ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಮೊದಲಿಗೆ ಮಿಕ್ಕುಳಿದ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳೆದುರು ಪರಿಗಣಿಸಿ ಆಯ್ಕೆ ಪಟ್ಟಿ ತಯಾರಿಸುವುದು, ನಂತರ ಸ್ಥಳೀಯ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳಿಗೆ ಪರಿಗಣಿಸಿ ಆಯ್ಕೆ ಪಟ್ಟಿ ತಯಾರಿಸುವುದು. This is exactly what is contemplated for vertical reservation.
ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿ ಪ್ರಕಟಿಸದೇ ಇದ್ದಲ್ಲಿ ಅಂತಹ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆಗಳಿಗೆ ಸೀಮಿತವಾಗಿ ಮಾತ್ರ ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಸಮಯದಲ್ಲಿ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಪಡೆಯಲಾಗಿರುವ ಆಯ್ಕೆಯನ್ನು ಪರಿಗಣಿಸದೆ ಮೆರಿಟ್ ಪಟ್ಟಿಯಿಂದ ಆಯ್ಕೆ ಪಟ್ಟಿ ತಯಾರಿಸುವಲ್ಲಿ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಮೊದಲಿಗೆ
ಮಿಕ್ಕುಳಿದ ವೃತ್ತದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳಿಗೆ
ಎದುರಾಗಿ ಪರಿಗಣಿಸಿ ಆಯ್ಕೆ ಪಟ್ಟಿ ತಯಾರಿಸುವುದು, ನಂತರ ಸ್ಥಳೀಯ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳಿಗೆ ಪರಿಗಣಿಸಿ ಆಯ್ಕೆ ಪಟ್ಟಿ ತಯಾರಿಸುವಂತೆ ಸೂಚಿಸಿದೆ.
ಅದು ಅಷ್ಟೇ. ಈಗ the reason, whole reason why I built up this case.
This is the epicenter of.
This is the epicenter because what this contemplates in substance is a vertical reservation. Wherever the reservation is provided by excluding those candidates who gets into the merit list while maintaining the integrity of number of posts to be filled up in a particular discipline is what is called as vertical reservation. That is essentially what they are doing.
All right.
Now the question is this, Milords. Now the main question is this. I will postulate my submission in this way. Any reservation which falls out of the, sorry, Milords. Any reservation which falls out of the purview of Article 15(4), Article 16(1) and 16(4) will be horizontal reservation. Only those reservations which are accorded under 16(4) or a classification under 16(1) or 15(4) can be vertical reservation. Abreast of this, 16(6) was introduced by the Constitution Amendment to provide for a vertical reservation to EWS, that is under Article 16(6). Every other reservation, Milords, it may be women's reservation, reservation for the physically handicapped, reservation for the sexual minorities, that is the transgenders, everything cuts across the vertical reservation, therefore it becomes a horizontal reservation. Now, this is the basic concept, Milords. This is where they introduce this very system. Now, what they have done in this PSI recruitment is, the matter is pending at your lordship's hands as to whether this could be made applicable. Retroactivity is permissible or not. Retroactivity, Milords, I'll not delve into it because Prithvish has already dealt with that matter. Milords, retroactivity, there are only two principles, Milords. I will not, it is not, because as your lordship said, Milords, this is not something which is a statute or a subordinate legislation. These are circulars. If there is a violation of a substantive right or a vested right, then the retroactivity, Milords, on the face of it is not permissible. Even then there are exceptions. They can give reasons and say that we wanted this to be still retroactive. But certainly not, Milords, a reason to say that somebody objected, therefore we wanted it to be retroactive can never be a reason. So now, the second part of it is, by introducing this, what they have done presently in the these police sub-inspectors posts is, out of this number of posts, 40 gets into the merits list, Milords, under different categories. Out of 438, out of 107 candidates who would have found their place in the local cadre, 40 of them in different categories gets into the residual cadre. So the open competition posts, excluding the reservations under Article 16, gets diminished. And they have kept 40 seats vacant in Hyderabad, Karnataka, in the local cadre. That is how they have now prepared the provisional list. Milords, we come in this last 40 people.
Yes.
Lords, we come in this last 40 people, Lords, the people who are now before Lordships, as per the marks which we have secured in the rankings, we are the people who will be affected in the event of the Hyderabad, Karnataka opted students and who are yet to exercise their option to get into their to the general cadre. Not because that option they have exercised. At the time when they are given the recruitment, they will have to be still asked whether you wanted to go into the residual cadre or you want to stay in the local cadre. That is an exercise of option which is to be done by them. Now, this 40 shifts upwards to the residual cadre, 40 seats gets reduced in the residual cadre, and 40 people will be accommodated more. More number of people will be accommodated. As I was speaking about that proportion, Millards, to represent that particular backward region, Millards, the proportion with which the representation is there itself should be sufficient. That is the yardstick, Millards, of horizontal reservation. Horizontal reservation does not require that I should be accommodated only as against that reservation. As long as my presence is there in that cadre or in that stream, I will also be counted. That means that number of people will be counted. Remaining will be filled up by means of a reservation, cut across the vertical lines. This is what I personally feel, was sought to be achieved by 371J. Now, if we compute, what is the number of posts which they have already declared as local cadre in the Hyderabad, Karnataka region, plus 8% of the posts, it will be almost 15% of the posts of the total cadre, total state. 8% and local cadres. That's another argument which I had already canvassed. You cannot provide for a reservation in excess of the total population, because what is provided for us for the purpose of reservation should have a scientific basis. There will be an empirical data on the basis of which the reservation percentage is fixed. 8%, Millards, is what is I read out, Millards, from the coordinate bench judgment, that 8% is the total population. If 8% is the total population, if the representation is there, I was also referring to that minority view, Millards, in that Janhit's case, where it said that there is a requirement of, because it is not under 16. I can understand if it is brought under 16, then I am under a different situation. I get covered under Janhit's case. I'm not under 16. Now, if my argument were to be accepted, Millards, the people who have opted, now that different streams are made, Millards, the workability is also made, Millards, in a manner that there are existing people. There are people of this origin and domicile who fits into the definition of local candidate. For the people who are already in service, number of posts is identified. They are given an option to migrate. That is to continue in the local cadre, or they wanted to continue in the residual local cadre. So that is taken care of. It's a one-time exercise. The other question is that once you wanted the recruitment process to take place, earlier it provided that under 6/6/2020, it said that one single notification, but you give options like this 1, 2, 3, where it is still permissible for them to make an option at the time of recruitment, whether they want to get into the local cadre or the residual cadre. But now it says, whether you exercise the option or you don't exercise the option, we are considering you under the merit cadre. Notice, how can the meritorious candidate of a regional cadre be deprived of claiming the reservation of a local cadre?
That will defeat the very purpose.
It will defeat the purpose. It is not the backwardness of a class, it is backwardness of a region. That will not, if your lords were to see in that just kindly have a look at page 147. Lords, page 147, Lords will find the tabulated column, serial number 9. Bellary range. This is priority number 1. Lords, I am given a list of priorities, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now, by applying this 1 to 2023, since I am meritorious, southern range Mysore I am given. I am deprived of my own local cadre. The next page, my lords, is the application. 19A, 19B, 19, 19A and 19B is in accordance with 6/6/2020, the options exercised.
Yes.
But in this regard, my lords, just two judgments which I wanted to refer to. In compilation today. Notes page 16 is Rajesh Kumar Dharia's case, which I'll just two paragraphs, notes, just to have a foundation of the horizontal and vertical reservation so that I can just page 16 minutes.
So EWS it is.
Notes Rajesh Kumar Dharia's case is only minutes defining what is vertical and what is horizontal reservation.
Not here.
Page 16. Okay. But just two paragraphs. It's a very short judgment, minutes.
Paragraph.
But in this, para 7 minutes. The second relates to. Minutes, paragraph number 9. Sorry.
Come to class item E.
E. Para 9 minutes. Yes. Only if there is any shortfall. Only if there is any shortfall, requisite number of scheduled caste women shall have to be taken by deleting corresponding number of candidates from the bottom of the list relating to scheduled castes. To this extent, horizontal special reservation differs from vertical social reservation. Thus, women selected on the merit within vertical reservation quota will be counted against the horizontal reservation for women. Let us illustrate by an example. This is a very classic judgment, Milords, which interplay between vertical and horizontal reservation.
Any other paragraph you want to read?
Milords, paragraph number 9 is the only paragraph. So I will not read anything beyond this. Milords, then page number 25. Milords, I'll just mark the relevant portions and give it. Milords, I am preparing that short synopsis of the relevant paragraphs.
ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ನೀವು ಹಿಂಗ್ ಕೊಟ್ಟು
Highlight ಮಾಡಬೇಡಿ ಯಾಕಂದ್ರೆ highlighting is not a
ಅಲ್ಲ ಪ್ರೊಪೊಸಿಷನ್ ಇನ್ ಸಪೋರ್ಟ್ ಆಫ್ ದಟ್ ವಿಚ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಜಡ್ಜ್ಮೆಂಟ್
yes Milords.
ಆ ರೀತಿ ಮಾಡಿದ್ರೆ ಈಸಿ ಆಗುತ್ತೆ.
Milords, I wanted to say this. Of course, I could only sacrifice half a day, Milords, to prepare for this case. But when I was with senior Parasaran, so he was telling me when the senior counsels who were required to lead the cases before constitution benches, they used to sacrifice their work for months. They used to shut down their offices for open consultations for like 20 days, 25 days, only to prepare for the cases to be presented before the constitution benches.
Contemplate and
Milords, page 25, Milords, is the Honorable Judge, the Honorable Supreme Court says that a reservation for the physically handicapped is purely horizontal in nature. Similar is the view, Milords, if your lordships were to take women reservation ಎಲ್ಲಿದೆ ಯಾವ್ದು ಹಾಕಿದ್ ನಾವು But the main decision which I want to rely upon is a constitution bench judgment, Milords, in the first judgment, Milords, is NTR University, Milords, which is at page number 1. This deals with the question of giving a reservation in excess to the local cadre. That means bringing the local cadre or making the residual cadre as accommodating the local cadre. This was essentially the question which came up, Milords, for consideration. Let's kindly have a look at page number 3.
G. Babu Rajendra Prasad.
Yes, Milords. Milords, page number 1, NTR University, yes, Babu Rajendra Prasad. In that, the facts, Milords, is at page number 3. Whether the government of Andhra, while framing AP regulations, institutions, regulation of admissions order of 74, made in terms of 371D of the Constitution of India was bound to provide reservation for 15% of non-local seats, although reservations in terms of its policy decision had been taken in respect of seats available for local candidates, is the question involved in these appeals, which arise out of a judgment and order of 29-3 of the full bench of Andhra High Court. The first respondent is said to be a member of the scheduled caste. He questioned the validity of the policy decision of the state of Andhra Pradesh as regards non-reservation of scheduled caste, scheduled tribes, backward class by filing a writ petition. Single judge of Andhra High Court, by order dated 27/10/98, directed the appellant herein to reserve seats for reserved category of 15% open seats also. Notice this, the Supreme Court is upset, saying that it cannot be done. Notice why it cannot be done, my lords, is what your lords will find from paragraph number 12 and onwards. Lords, of course, it extensively considers the judgment in Indra Sani, R.K. Sabharwal, and and M.R. Balaji. Para 25 is the conclusion. It quotes H.M. Sirvai, my lords, on treatise. Of course, Sirvai was in turn referring to what was spelled out by Mr. Ambedkar. So that is at page number 14. In the event, the ratio of the impugned judgment of the High Court is given effect to, having regard to the limited number of seats available by providing reservation of an additional seat, principle of reservation to the extent of 50% would be violated. Furthermore, it is not for the High Court to say as to the efficacy or otherwise of policy of the state as regards providing for reservation for the category of candidates. In that view of the matter, High Court, in our opinion, must be held to have committed a manifest error in issuing the impugned directions, as a result whereof percentage of reservation would exceed 46%. Such a direction is not contemplated. Then, my lords, is a Constitution bench judgment, lords, of course, which arose in the context of 371D itself, which your lords will find at page number 73. Nandidin Kode. iPad.
The 3-judge bench decision or 5-judge?
Lords, this is by 5 judges, by a Constitution bench, because the matter was referred to the Constitution bench, my lords, on certain questions which were framed. Lords, one of the question which was framed, if your lords were to take page, paragraph number 139, I remember it properly. So I just open it. Lords, may kindly give me a minute, lords. Lords, paragraph number 147. Which your lords will find at page number 510. Internal page, yes. Lords, page 182. Whether the notification merely contemplates a classification under 16.1 and not a reservation under 16.4. Lords, this was a case where reservation was given for 100% to scheduled tribes in an area where there was a majority of scheduled tribes. So this was what was called in question, but in extenso, my lords, the Constitution bench has examined this question. Lords, I have not produced Indra Sani because Indra Sani is exhaustively
Referred in every judgment.
Yes, lords. The
They said
conclusions,
it is bad. What they said?
lords, they follow Indra Sani and say that principles as laid down in Indra Sani twofold. One is 50%. Other one, because the threshold 50% is in the interest of a competition for the other candidates while maintaining the equilibrium for the suppressed class. So that is mandatory. That is number one. And any reserve, 16.4 is exhaustive of the social and economic educational backwardness. That is exhaustive. So any reservation given beyond 16(1), any classification or back on the basis of the backwardness of a class, ultimately, my lords, backwardness of class is the yardstick for reserving under 16(1), 16(4). Now, if any reservation is given beyond what is called as a class for the purpose like a regional backwardness or the sexual minority or the women's reservation or physically handicapped, these are the kind of reservations which does not come within the realm of 16(4). In which event, they don't get into the vertical reservation policy at all. Then they go into horizontal reservations.
In other words, 16(4) is confined only to vertical.
Yes. 16(1), 16(4) is vertical. Notice the reason why such exceptions are provided as part of Part 3 is only for this reason. That notwithstanding that I have a right of participating in 100, there is another right which is created by virtue of the classification provided under 16(1) and 16(4), where there is an exclusivity created. But the exclusivity is something which cannot be created otherwise. That is the reason why I have drawn parallels with the women's reservation, physically handicapped reservation, the transgenders or the sexual minority reservation, and the present reservation.
Yes.
And the answer, my lords, is that the question is answered saying that 16(4) is exhaustive of the backwardness reservations. Not the two other judgments which I have provided is essentially on the point of women's reservation and transgender reservation.
Yes.
Notes one Patna High Court judgment which I produced, which is at page number 215. Sorry, my lords, page 211 by a division bench of the Patna High Court. Gaurav Kumar's case. My lords, of course, in extenso deals with the principle of 50%. In other words, the reduction of the general merit from 50% to a lesser extent itself will be a criteria of consideration when you are increasing that 50% of the reserved candidates. That means the very object with which you are introducing a reservation, if you are exceeding 50%, should be with the application of mind as to why this 50% is getting increased or it is getting reduced for the open competition. That itself is a criteria. That's the only basis on which that judgment is pronounced, where it says that 50% is a hard and fast rule. But of course, as I submitted, in Janhit's case, the Supreme Court took note of the fact that there is a conscious effort to increase it by inserting it under 16(6). Article 16(6) was inserted to bring about the economic weaker sections or the economical backwardness as a criteria for providing the reservation, which again gets a vertical reservation because it's a part of Article 16. That's how, my lords, the courts have interpreted. So therefore, my lords, my respectful submission is the conclusion of the recruitment process on the basis of the latter notification has got far-reaching effects. At least let them permit what has been settled at flown and is in the verge of settlement to be settled without unsettling it at this point of time. Grateful for the hearing, lords.
It was a learning experience, at least for me, plus my brother also.
Always a pleasure, my lords, to be before lordships. Grateful for the hearing. Lords, there is one IA, my lords, put up again. Lords, there is an IA in WP number 16343 of 24.
Pleading.
35.13. Impleading. Lords, we will be the candidates. I had made a submission on the last occasion. Mr. Hegde was also there. I told him. He said he has no objection because we are the petitioners. We're only being, it's only a
Implead Mana will hear them also.
Sub-inspector recruitment that senior is referring to. That is not the subject matter of this case. It's a different sub-inspector. But anyway,
the issue is only this. Is the only these three notifications, because several teachers they have affected, assistant professors they have affected, police sub-inspectors is affected. All recruitment notifications of 6/6/2020 on the teeth of the later notification is what is under challenge before your lordships. But incidentally, I had to say this, because on a conceptual basis, whatever they are thinking may not be correct. And it may militate, my lords, against the very scheme with which the reservation is provided.
All.
Please, my lords, great.
Hello, Marna.
Please.
Lodi. Application in IA number so and so supported by the affidavit and not much opposed by the other side.
Not technically affected, not but that's because the applicants of a different note. You will hear the interveners.
But if we,
Interveners
if we pass some order,
will be directly affected.
That is not part of the court notification, because there the final list is already out. That is the recruitment notes which is not part of the, but the same.
it is not affected.
No, no.
It will be affected. But there'll be,
Lordships may say intervening applicant. We may be
As interveners.
interveners.
application is partly favored and the applicants are permitted to be in the fray as interveners,
Please,
as distinguished from
respondents,
parties you nominate.
please. Grateful.
No. ಅಲ್ಲಿ petitioner to, I mean, ನೀವೇ petitioner ಅಲ್ಲ? Petitioner to amend the cast title. two ಯಾರು? ಲಕ್ಷ್ಮೀನಾರಾಯಣ. Identical ಆ? Impleting a intervener.
Petition filed by Ravi Shankar. Same petition.
ನೋಡಮ್ಮ. Same order, ಲಕ್ಷ್ಮೀನಾರಾಯಣ ಅವ್ರ matter ನಲ್ಲಿ. Petitioner to amend the cast title. ಇನ್ನು ಎಷ್ಟು ಜನ ಇದ್ದೀರಿ ನೀವೆಲ್ಲ ಆರ್ಗ್ಯೂ ಮಾಡುವಂಥವ್ರು?
Sir, I will not deal with the merits or the circulars or the government.
ಇಲ್ಲ, ವಿ ಆರ್ ನಾಟ್ ಅಗೇನೆಸ್ಟ್ ಇಟ್. ಈಗಾಗಲೇ ಬೀಟನ್ ಟ್ರ್ಯಾಕ್ ಮೇಲೆ ಮತ್ತೆ ಕರ್ಕೊಂಡು ಹೋಗ್ಬಾರ್ದು ನಮ್ನ. ವಿ ಕ್ಯಾನ್ ಟೇಕ್ ಅಸ್ ಆನ್ ದಿ ವರ್ಜಿನ್ ಪಾತ್.
In fact, I will confine my submission only so far as 371J. And what is meant by a constitutional order issued by the President of India, empowering the governor to lay down the norms so far as implementation of 371J is concerned. I will confine only to that. Your lordship need not go.
ಅದರ್ ಥಿಂಗ್ಸ್ ಐ ನೀಡ್.
Yes, Mr. In fact, I just
ನಿಮ್ದೊಂದು
want.
ರೈಟ್ ಅಪ್ ಕೊಟ್ಬಿಟ್ರೆ so that that
ಅದು
becomes very
ನೆನ್ನೆ ಎಲ್ಲ ಮೊನ್ನೆ
articulate and easy.
I was in KDB parted matter. Tomorrow I am completing.
Ah.
I will complete my.
Yes. Chandrasekhar's flight, back journey flight is booked on which date?
All depends on the.
At their hands.
Focus will be whether can be given retrospective. One thing, whether those two notifications which compelled the candidates to give their option is justifiable on the touchstone of Article 14 and 16.
Or any injustice is caused to them,
If the
otherwise
mis-
also.
If the mischief is remedied
Yes.
by this, it cannot be, my lord, quashed, will be our sum and substance of our.
Very well. Yes.
Let if your lordships kindly take this.
Just make one small statement, then you can elaborate it. What is that you want to say about the
That
nature of
this
this order?
is Article 371J, subclass 1. The president, the constitution says, my lord, the president is empowered to carry out the various obligations provided under 371J.
Correct.
Now, that is 371J. This order I'll just read out. The president may by order with respect to the state of Karnataka for any special responsibility of the governor this is a constitutional provision. An establishment of a separate development board for Hyderabad, Karnataka region with the provision that a report on the working of the board will be placed each year before the state.
Yes, this we have read. We can skip off the text and make
Now,
it submission.
2 is important. 2 is important. An order made similar 371 JC equitable opportunities and facilities for the people belonging to the said region in matters of the public employment, education, and vocational training, subject to the requirement of the state as a whole. Then an order made under subclause C of clause 1 may provide that this is the order which has been made in 2013 by the governor is now source of power for reservation of a proportion of seats in the educational and vocational training institute in the Hyderabad, Karnataka region for students who belong to that region.
Educational reservation, employment reservation.
Next minute. Identification of the post or classes of post under the state government and in any body or organization under the control of the state government in the Hyderabad, Karnataka region and reservation of proportion of such posts. Kindly underline this minutes. When there is an 80, 20, 85, 15, 75, 20, the reservation millet should be proportionate. That is how it talks. Proportionate of such posts for persons who belong to that region by birth or by domicile and for payment thereto by direct recruitment or by promotion or any other manner as may be specified in the order. Now, my lord, the first clause contemplates the president may by order. Then the implementation is through the governor. The document which I passed on to your lordships is issued under Article 371J, subclause 1, where it is a presidential order conferring the power on the governor to carry out the constitutional obligation under 371J. I will just read out, my lord, the clause. The state of Karnataka, special responsibility of governor for Hyderabad, Karnataka region order 2013, published by notification New Delhi 24th October 2013, Ministry of Law and Justice also. The following order made by the president as published for general information. Then the title comes. The Karnataka special responsibility of the governor for Hyderabad, Karnataka region order 2013. In exercise the powers conferred by clause 1 of 371, Article 371J of the Constitution, the President hereby makes, with respect to the state of Karnataka, the following order, namely, then it shall come into force at once. Then, 2, special responsibility of the governor. The governor of Karnataka shall have the special responsibility for the establishment of a separate development board for Hyderabad, Karnataka region and for other matters referred to in clause 1 and clause 2 of Article 371J of the Constitution in respect of that region. The governor shall, for the purpose of subclause 1, have power to issue such orders as may be necessary. Now, this is a
constitutional order issued under Article 371J, empowering the governor to exercise the powers under this order to constitute and to carry out the obligations provided under Article 371J. Not it is in pursuance of this, 2013, I think, my lord, everyone has read, your lordship, the article 6/11/2013.
Governor's order.
Governor's order has been issued. Then, my lords, in fact, I made a compilation, my lord, your lordship, for
ನೀವೆಲ್ಲರೂ ಸೇರ್ಕೊಂಡು ಒಂದು ಸ್ಮಾಲ್ ಕಾರ್ಟ್ ಅನ್ನು ಕೊಡಿಸ್ಬೇಕು. ವಿ ಹ್ಯಾವ್ ಟು ಕ್ಯಾರಿ ಆಲ್ ಎಂಟೈರ್ ಕಾರ್ಟ್ ಲೋಡ್. ಹೌದು.
State government has printed a lot of
ಇದ್ರ ಸಲುವಾಗಿನೇ ಇದೆಯಾ ನಿಮ್ಮಲ್ಲಿ ಅದು? ಕೊಡಿ.
ಅದರಲ್ಲಿ ಎಲ್ಲಾನು ಇದಾವೆ.
Complete our literature, entire, beginning with 371J, President's order, Governor's order, government's order, circulars.
Amendment ಎಲ್ಲ.
Good.
It should be better to.
So that ಇದರಲ್ಲಿ ಇದು ನಾವು ನಿಮ್ಗೆ ವಾಪಸ್ ಕೊಡಲ್ಲ, ಇದನ್ನ ಕೋರ್ಟಿಗೆ ಇಟ್ಬಿಡ್ತೇವೆ.
ಕೊಡಿ ಒಂದು ಕೊಡಿ.
It becomes easy for you. Yes, very good. ಅಲ್ಲಿ ಪರಿವಿಡಿ ಅಂತಿದೆ ನೋಡಿ, ಮೊದಲನೇ ಲಾ ಮಿನಿಸ್ಟರ್ ಫೋಟೋ ಆದ್ಮೇಲೆ ಅಲ್ಲಿಗೆ ಬನ್ನಿ.
I will use it by compilation. Milord, if your lordships kindly
ಯಾವ ಆರ್ಡರ್ ಓದ್ಬೇಕು ಅಂತ ಹೇಳಿ ನಾವು ಅದು ನಮ್ಮಲ್ಲಿ ಇಲ್ಲಿ
page
ಕರೆಸ್ಪಾಂಡೆಂಟ್
2, milords, page 2.
ಪೇಜ್ 2 ನಿಮ್ಮ
That is
ಆರ್ಡರ್ ಹೇಳಿ ಡೇಟ್
6/11/2013. 6/11/2013.
ಪೇಜ್ 12. Correct.
Milord, I just wanted to, milord, draw your lordship's attention. What has been, milord, issued by the governor by virtue of this is in pursuance of the delegation of the presidential power under 371J1 to the governor under the notification which I read to your lordship, and this is an order issued by the governor. So it has to be.
ಇದು ಒಂದೇ ಆರ್ಡರ್ ಇದಾವೋ? there is a slew of orders. This is the only order, one order. Okay.
Under clause 9 of this order, the governor, my lords, can issue directions. He has got power to make the regulations, higher rules. Therefore, the second one, the governor has framed the rules by virtue of clause 4(1) and 5(1) paragraphs, subparagraph 1. That is 2014. If your lordships kindly take page 9, that is 29/1/2014.
You are right.
My lord, these are the rules framed by the governor by virtue of this the governor presidential order. The presidential order has got a constitutional flavor.
ಫ್ಲೇವರ್ ಏನು? ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ಲೇ ಇದೆ ಅದು.
Yes. I'm sorry, 2014, the rules framed
They have
under the, that flavor is there. If your lordships take, my lord, clause 9, power to authorize issue directions. The governor may by order require the state government to issue such direction as may be necessary as expedient for the purpose of giving effect to this order to any local authority
body
or body.
organization, so and so. Shall comply with such direction. Yes.
Then these rules, if your lordships kindly take rules 29/1/2014,
Page number AG
page 9. In my compilation, page 9.
2014.
29/1/2014, it says, my lord, notification 1.
ಇದ್ರಲ್ಲಿ 14 ಇಲ್ಲನ್ರಿ?
29/1/2014.
14 ಕಾಣ್ತಾ ಇಲ್ಲ ಅದಕ್ಕೆ.
ನನ್ನ
ಇದೆಯಲ್ಲ, ಅನುಬಂಧ 101 ಪೇಜು ಕರೆಕ್ಟೇ ಇದೆ. 101.
Whereas your lordships got it.
ತಿದ್ದುಪಡಿ ನಿಯಮಗಳು 99 ತಾನೆ?
29/1/2014.
99 also amendment.
Notification 1 ಅಂತಿದೆಯಾ?
Notification.
Yes.
Notification 1. 29 January 2014.
Yes, minutes. I am just showing the power, how it has come. Then where is the question of the government intervention? I just wanted to submit your lordship. Whereas the draft of the rules pertaining to the Karnataka public.
So and so, title, commencement.
Yes.
Definition.
In
clause.
exercise of powers, 5th line minutes, conferred by subpara 1 of para 4 and subpara 1 of para 5 of the Karnataka public.
Governor's order ಏನಿದೆ ಅಲ್ಲ, ಅದ್ರ ಕೆಳಗಡೆ ಮಾಡಿದ್ದಾರೆ. ಹೌದು. Next.
These are all the rules.
Next.
Then these rules contemplate the, if your lordships kindly go to the definition clause 2C, residual parent cadre. Parent cadre.
Parent
Then
cadre, residual parent cadre.
cadre.
Correct.
Then 3, organization of local cadre.
Correct.
Your lordship may kindly come to 2, my lord. 2 is important. State level local cadre. That is 8% in the capital city or any organization assist the capital city. State level local cadre. Your lordship got it, not? Sub rule 2 of rule 3(2). Yes. The manner of constituting a local cadre, which may consisting of the following units, namely, state level local cadre means a cadre carved out of the respective group A up to junior scale, group B, C or D post in the state level officer or the institutions in the government or body or organization to the extent of 8% as a local candidate.
ಆ ಲೈನ್ ಹೋಗಿಬಿಟ್ಟಿದೆ ಗವರ್ಮೆಂಟ್ ನಲ್ಲಿ.
Then
ಲಾಸ್ಟ್ ಲೈನ್ ಹೋಗಿದೆ. Same.
Which is with reference to rule that paragraph 13 of 2013 of that, and the division bench judgment.
Oka Sahib's judgment. Okay.
Then regional local cadre, that is 85%, 80 and 75%. Then, my lords, the regional cadre and the state level cadre, if it is merged by the competent authority, then it will become statewide local cadre. This is the definition. Now, if your lordships kindly come to
No, actually, you are reading all this now. For what purpose you are reading all this?
No, I am only drawing your lordship's attention. The local cadre as defined under the establishment of a local cadre under
Rule
the
2
governor's order. President 3
Yes.
is treated as a separate unit under Rule 5.
Correct.
Yes.
For the purpose of recruitment, promotion, perhaps reservation also it's mentioned.
Yes.
Correct. It's a separate unit. We agree with that.
Now, just Rule 4, my lord, I just wanted to read. Rule 4 of 2014. The residential parent cadre,
Residual.
sorry,
parent-
residual parent cadre and the local cadre carved out of it shall be treated as a separate unit for the purpose of recruitment, appointment, seniority, promotion,
Reservation.
and for reservation, and for operation of reservation. 2 parallel roster cycles shall be operated for the residual parent cadre and the local cadre. But here, the entire exercise, my lord, so far as by the respondents, by issuing the circulars and the various government orders, has to be examined with reference to, for the purpose of a local cadre, you have 100-point roster. For the purpose of residual parent cadre, residual parent cadre, 100-point roster. Now, you are applying the reservation a cadre wise. When you are treating the residual parent cadre as a 1 unit, then local cadre as a 1 unit, when you are applying the 100-point roster separately, because the rule contemplates the
Separate.
2 parallel roster. Now, my lords, there is no difficulty so far as the application of the roster is concerned, if it is 2 parallel. Now, you cannot map the vacancies or posts of residential parent cadre to the local cadre or vice versa. What has been laid down by the apex court, the reservation is applicable to cadre wise as 1 unit. That is how, my lord, I just read to your lordship in the governor presidential order 5, class 5, my lord. I appeal to your lordships.
Clause 5.
Of the government order dated 6/11/2013.
You're right.
Local cadres and transfer of persons. The reason for which a local cadre has been organized in respect of any category of post shall be a separate unit for purpose of recruitment, appointment, seniority, promotion, and transfer of such other matters as may be specified by the state government in respect of that category of the post. If the local candidate has been treated as a separate unit, the roster, that is reservation order, would be applicable treating that local cadre as a 1 unit, and 100-point roster is being made applicable. There is no question of, in fact, in Nagaraj versus Union of India, my lord, in paragraph 83, it has been laid down. So far as the roster, yes, Constitution. Yes. It says that for the purpose of application of the reservation order, that is the roster, 100-point roster, DR 100-point roster, promotion 33-point roster. Therefore, if you are treating the cadre as 1 unit, you are applying the 100-point roster, treating the cadre as 1 unit. In the same, in the local, as a local cadre. In the same manner, you are also applying the 100-point roster so far as residual parent cadre. Now, my lords, all these judgments which have been cited by my learned friends would be within the roster. If a reserved candidate of any, whether he is a scheduled caste or OBC, otherwise, if he has secured a highest marks, it is open for the selecting authority to push him to the general category.
Open or obligatory to push?
Pardon, Lord?
It is not just open.
It is open. Yes,
Catapulted to
yes, yes.
general category.
Yes, general category. So you are applying the 100-point roster within the residual parent cadre, if such is the case. And similarly, if there is a reservation or, a person who secures the highest percentage in the local cadre roster points, treating it as a separate millet, you will go to the general pool. This is the well-settled principle of law. Now, if the presidential order, millets, I can say, millet, I think your lordships are aware of it. If the government has delegated the power to any other authority, the delegate is exercising the power of the delegator. 1963 Supreme Court, millet, that's the position. Now, therefore, we call it as this presidential order. So far as 2013 is concerned. The second order is the rules framed by
Broad proposition, but anyway, for our limited purpose, we can say the first proposition you said appears to be little broad. Many exceptions are recognized to that. Anyway, now that may not be of much requiring much debate. We agree. We can take that. We are with you.
Millet, I only appeal to a lordships, millet. If it is a presidential order, like 341, 342, where constitutional scheduled caste order of 1950-51, constitutional scheduled caste order of 1950, 51, 52, that is scheduled tribes order. These are all constitutional orders. What the apex court has said, if it is a constitutional order, published under Article 341 and 342 is concerned, even the President of India has no power to amend such an order. If it is to be amended, the law should be framed by the Parliament, is a settled legal position. That has been followed by the seven judges recently by the apex court. And one of the contention was whether a constitution when Chinnaya's case has been referred to the Constitution bench.
Chinnaya is overruled.
World one, that has been referred, whether there is a sub-classification under Article 16(4), that has been dealt recently by the Supreme Court. I'll read it, let's.
My impression is Supreme Court said that Chinnaya is hereby overruled.
Yes. In fact, this is not State of Punjab versus Devinder Singh. Yes. I'll just, only one paragraph I'll read. To show that constitutional order cannot be a subject of revision or a modification even by the President of India once it is notified. The modification.
How that, that's very interesting point, all right. How that question crops up in this case?
The first order, the constitutional order, would say a local cadre would be treated as a separate unit for the purpose of reservation. Now I am supported by the Nagraj case, the Constitution bench. You apply the roster treating a cadre as one unit. That is how the class 5 has to be read, that the region for which a local cadre has been organized in respect of any case shall be a separate unit. If it is a separate unit, then cadre will be treated as one unit, then apply the 100-point roster. Now I can understand If there is an 80% in the residual parent cadre, 20% local area, local cadre, put together 80%. If it is a norms or a government order which contemplate you prepare a list of a composite list of merging 20 and 80, which has taken place in Andhra Pradesh, 371D, the judgment which I cite to your lordship. Then the merger is take place. Then there is no question of the mapping up the vacancies from one unit to another unit.
Are you referring to Rajendra Prasad judgment?
Yes, Rajendra Prasad judgment is applicable. In fact, it says my learned friend was making a submission, physically handicapped. Physically handicapped would not come under 16.4. There is some little bit mistake. It comes under 16.1. If it is 15%, 3%, up to 50% reservation is provided.
Only said horizontal.
No. What is meant by vertical means up to 50% is the vertical provided by the state government. 15 plus 3 is a vertical reservation. OBC 27% is 2% physically handicapped comes under Article 16.1, not under 16.4.
Correct.
Yes. Horizontal, where by virtue of the reservation provided. In fact, in the Beer Singh case, the 5 judges.
Anything that cuts across vertical is horizontal.
Horizontal. Yes,
Any law is there any change of law on this?
There is no change. There cannot be any change. That is the judgment of the Indra Sahni's case. Now, the woman reservation comes under horizontal. The rural area comes under horizontal. But though physically handicapped 2% comes under Article 16.1, it is a vertical reservation.
Because of
But points have been given, the roster points have been given in the 100-point roster.
yes.
Now, as on today, 100-point roster for a direct recruitment, it is filled up with a roster. There is no ambiguity, which includes vertical and horizontal reservation. So far as the promotion is concerned, 33% roster is already provided. First vacancy, second vacancy, and the first vacancy is scheduled caste, second is ST, seventh vacancy SC, 14th SC, 22, then that is how. Second and 25 is the ST. That is how the roster has been.
Very well. Can we continue other day, some other day? The clock is ticking. Right? Tuesday. Tuesday?
Yes. But what I am appealing to your lordships, my lord,
Yes.
if your lordships holds that this is a presidential order, which has got a constitutional force, it cannot be altered by means of any governmental circular or order.
There is no alteration of presidential order.
Presidential order, the paragraph which I wanted to relay is that even a president has no power to modify the presidential order. It can only by the law of the law by parliament. That's the paragraph which I wanted to.
Where is the modification of that order?
There is no modification. Therefore, there is a separate parallel unit of reservation, separate cadre. You can't, my lord, exchange the post because of the merit. Merit means you will go to the local cadre. Here in the residential parent cadre, if there is a merit from the reserved or SC/ST, he will occupy the general. There is no question of crossing the unit. If we apply the Nagaraj case where cadre has one unit for the purpose of 100-point roster. That's the position.
Very well.
ನಾನು ಮಾಡ್ತೀನಿ
ಬೇರೆ ಇದಾರಲ್ಲ ಈಗ ಆ ರೀತಿ ಯಾರು ಮುಗಿಯೋದೇ ಇಲ್ಲ ಇದು And Chandrasekhar will go back saying that no meaning in arguing matter before this court. Endlessly, they are go on hearing. ಅವ್ರು ಮಾಡ್ಲಿ, ನೀವು ಇನ್ನೊಂದು ದಿವಸ ಮಾಡ್ಕೊಳ್ಳಿ. ಬಟ್ ಇದು ಏನೇ ಇದ್ರು ಇದು ಬಿಫೋರ್ ಅಟ್ ಲೀಸ್ಟ್ ರೀಓಪನಿಂಗ್ ಆಫ್ ದ ಡೇ ಆದ್ರೂ ಜಡ್ಜ್ಮೆಂಟ್ ಬರಬೇಕು. ಪೀಪಲ್ ವಿಲ್ ಬಿ ಡಿಸಪಾಯಿಂಟೆಡ್. ನೀವೇನೇನು ಹೇಳಬೇಕು ಅಂತೀರಿ, ಎಲ್ಲರೂ ಇಷ್ಟು ಜನ ಇದ್ದೀರಿ ಇಲ್ಲಿ, ನಿಮ್ಮ ನೋಟ್ಸ್ ಮಾಡ್ಕೊಳ್ಳಿ ಆಯ್ತಾ, ಮಾಡ್ಕೊಂಡು ರೈಟ್ ಅಪ್ ಕೊಡಿ ನಮಗೆ, ಅವನ್ನೆಲ್ಲ ಓದ್ಕೊಂಡು ಮಾಡ್ತೇವೆ ನಾವು.
My lord, this is an all India important, 371J. Therefore, my
ಆಲ್
lord,
ಇಂಡಿಯಾ
unless and until-
ಕರ್ನಾಟಕ ಇಂಪಾರ್ಟೆಂಟ್.
ಇಲ್ಲ ಕರ್ನಾಟಕನು ಇಂಪಾರ್ಟೆಂಟ್. Almost all, my lord, the recruitment is now under confusion. The lecturers and also, my lord, the various cadres, whatever it may be, they are under confusion, number one. Number two, if
any confusion is a grazing area for the bar.
No,
You
my
should
lord,
be happy.
No. In fact, we are assisting your lordships to give a solution, my lord, in the interest of the public, my lord. Ultimately, whatever your lordship says, this is the law, that is the correct legal position. It is not what we argue, what the other side is arguing. Ultimately, whatever your lordship says, this is the judgment.
Anyway,
That's the law.
whatever we say will be very provisional, because ultimately this side or that way, it will not be stopping here. It has very high propensity to travel to the north of the country. So that also we have kept in our view. It will not be resting here.
One matter, my lord, is not listed.
Jay is concerned.
One matter is missed out, my lord. I'll just give it to the court officer.
Good. Call along with them.
Yes, great.
Post along with them. Good, right. Okay. Next day. On Tuesday?
Tuesday or whatever.
Yeah, ನೀವು ಹೇಳಿರಲ್ಲ, ಅದನ್ನ ರಿಪೀಟ್ ಮಾಡಬಾರ್ದು. We have answered. Senior advocate said, we will be on our feet, therefore you can join later. Yes. Okay. Interim 33. ಎಲ್ಲೆಲ್ಲಿ interim ಮಾಡಿದ್ರೆ? All other matters too. ಏನದು? Which one?
33. Both are, my lord. He is appearing for the petition, I am appearing for the respondent.
That bank matter? No. 2 weeks. Entry model. Okay. Very well. Thank you.
Thank you. So great.
Court officer, serial number 27 ಏನಾಯ್ತು? Court officer? Court officer? Court officer? Serial number 27. Court officer? Court officer, serial number 27 ಏನಾಯ್ತು? ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ?
ಕೊಟ್ಟಿದ್ದಾರೆ. ಕೊಡಿ.
Court officer?